19th old. Convict is terminal. Serve it on tomorrow. Serve it on AG. Madam, get instructions. 19th.
Without any proper electoral role and all, without any proper electoral role and all the against all the procedures,
Society.
The election has been held on 14th. Kindly, 2:30 list or tomorrow.
Society jurisdiction illappa high court ge. You have to file a civil court. Civil suit file ಮಾಡ್ಕೊಡಿ ಬರುತ್ತೆ it will come.
Day after tomorrow itself election is.
Yes, for election matters, the High Court does not have jurisdiction. It's only 25, 27A. You'll have to file a civil suit. If you don't file it by that time, you won't get any relief.
List 1, serial number 71.
Wait, please.
No, it's not an adjournment.
Already discharged. There is only one petition.
Fresh matter.
Fresh matter. ED had not issued summons and are asking me to
Third.
appear today.
Yes. Pending matter. It will come in the regular. Everybody has urgency. We are not disputing your urgency. We are only saying it will come in seniority. That was 3 floors thing. ಏನ್ ಯಾವತ್ತಿದೆ ಅದು ಡೇಟ್ ಇರ್ಬೇಕಲ್ಲ. ನೋಡಿ ಅದು 20th ಏನಾದ್ರು ತಗೊಳ್ಳಿ ಅದು. Checking the date if it is next week.
Where the SEC Commission has ordered my immediate eviction. So hence there's
Eviction. Tomorrow.
2:30.
Tomorrow we'll take.
Lord, sir, yesterday I moved a matter, my lord, with regard to extension of parole, my lords. It has granted the date on
19th.
19th, because he has to surrender on 18th.
You surrender only after surrender only we'll consider. You can't move a extension in between. Then it's not 19, make it 25th.
Sorry.
Only after surrendering report ಬರ್ಬೇಕಲ್ಲ. 19th ಒಳಗೆ report.
Again, he has to furnish surety, my lords, procedures.
Yes. ಅದನ್ನ 19th ಅಲ್ಲ ಅದನ್ನ 27th ಮಾಡಿ ಅದನ್ನ.
ಇಲ್ಲ, earlier I moved.
19 ಮತ್ತೆ adjourn ಆಗತ್ತಪ್ಪ. There is no point. We'll have it on 27th.
Please.
Yes.
Fresh matter, my lords. The petitioners are called to the DCP office and they are made to wait from morning till evening for a small parking issue. They are issuing summons after summons, so the petitioner is not even able to attend this office.
So don't park.
What?
Don't park.
My lords, no, the respondent has parked in front of my gate. For that a summons.
Give it.
My lords, since last 1 week he has been called, and if he says that he has to go to office, the response from the outsiders is like DCP or.
You don't want to give the memo?
As
Give
made
it.
today or tomorrow.
Tomorrow.
ಏನಪ್ಪ?
Local settled tomorrow.
ಸೆಟ್ಲ್ ಆಗಿದೆ. ಯಾವ
Senior citizen.
ಮೀಡಿಯೇಷನ್ ಸೆಟ್ಲ್ ಆಗಿದೆ. ಪಾರ್ಟೀಸ್ ಬರ್ತಾರಾ? ಯಾವಾಗ ಬರ್ತಾರೆ?
Tomorrow.
Tomorrow at 2:30 PM for reporting settlement.
Meet, please, my lords.
Yes. Tomorrow, 3rd.
Matter, my lord, pertaining to tender, my lord. During the pendency of the financial bid is likely to be completed.
When is the date for opening the financial bid?
It is not fixed.
Lord, section 85 of the
Yeah, tomorrow. Kodi.
section 85 of the Waqf Act, my lord, it clearly bars civil court from entertaining the case. Hence, my lord. Election is there. If it is
Election of?
Election of masjid.
Huh.
Masjid committee. And they are
So you have to go
selecting
before-
instead of electing, my lord.
3rd.
ED,
You
my
have to
lords,
go
has
before the
issued-
tribunal.
ED has issued summons, my lord, despite there being a stay in this proceedings. Short point for consideration.
Inform them. Kodi.
My lord, GM passport ಇದೆ ಸ್ವಾಮಿ ಇದು.
Petitioner
ಬಂದು ಮೈನರ್ ಇದ್ದಾರೆ. ಸೊ ಅಬ್ರಾಡ್ ಹೋಗುತ್ತೆ ಎಜುಕೇಶನ್ ಪರ್ಪಸ್.
ಹೋಗ್ಬೇಕಾ? ಕೊಟ್ಟಿಲ್ಲ ಪಾಸ್ಪೋರ್ಟ್, ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. 3rd, 20th, 19th.
Fresh tender matter, my lords. My appeal was rejected on Friday. Communicated to me yesterday.
Tomorrow.
Today, please.
Just a moment, madam.
This is writ petition concerning the recognition of document writers. Matter was part heard, my lords. Thereafter, your officer listed it at 2:30 PM list, my lords, but then it was again adjourned at the instance of the state. Thereafter, it was never seen the light of the day.
When is the date given?
It's not a date given matter.
Everything has a date in this code. Everything.
No, it was listed on the day when you're also not holding sitting. That's it.
Not holding.
May I request for a
20th, 20th or 2:30.
request for a 2:30.
Yes.
Great.
But executive officer in the company, they are not holding, they are holding in the title to not to go for the work. Like some files are at the work manager, they are not allowing. This honorable court is allowed him to work. But even though the executive officer are not allowing him to work.
What work is to happen?
He is doing the files are at the work in the company.
Yes.
Yes, but he had some health issues, he couldn't do it. So in the meantime, the honorable court has passed the order in the 1st of July. But
That is a vitiligo matter.
yes, yes.
That's disposed.
Yes, it has disposed. We have written either for the modification.
Modification. Could be Monday. Though. Modification cannot come at 2:30, madam. Monday.
Tomorrow, because tenure is also working is already.
Please give the thing. Then file anticipatory bail if you're apprehending arrest. How will we have jurisdiction, Mr. Counsel, for arrest? Kodi, it'll all get dismissed, then you lose time. File it before the appropriate court. Kodipa. Bharat. Yes. Not 2:30, it'll come regular course.
My lord, in the Kolar Forest matter, the impleading application was allowed, my lord. For consideration of amendment application, kindly have this matter.
You are
for
filing an amendment application.
Yes, ma'am.
What is the date given in that matter?
19th matter.
It will come on that.
19th, your lordship.
It will come on that day, Mr. Judge.
Formal IA has been filed to carry out amendment, my lord. If the lords permit, if it
It will be formally considered on that day.
My lord, sugar
Please,
factory
my lord.
matter. It's a pending matter, but the only thing is that, our bank guarantees which were taken by the CDS are remaining.
Pending
with them.
matter will come in terms of seniority. We won't make any exception for sugar or salt.
Great.
ಯಾವತ್ತು ವಿಡ್ರಾಲ್ ನಾಳೆ ತಗೊಳ್ಳಿ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾ ಹಾ ಬರಲ್ಲ ಕೊಡಿ how many election matters you are filing for society? We don't have jurisdiction. ಕೊಡಿ. Yes.
It was a matter, my lord. It was given in this matter. On 10th, it was not being listed. I handed over one more memo to yesterday, my lord. It was not being listed. Kindly, within 15
Any compliances, any service to be completed?
pending matter.
So, like service is completed? No, date ಕೊಟ್ಟಿದ್ರೆ ಯಾಕೆ ಬಂದಿಲ್ಲ?
My lord,
Yes.
it's a fresh matter pertaining to section 10A of the banking regulations.
Tomorrow, third.
My lord, if I,
You wait, madam, you are in the list. They're mentioning matters.
Fresh matter.
Ah.
Posted for tomorrow.
For what reason?
My lord, petitioner is in the fear that adverse action may be taken against them by unilateral tribunal, arbitral tribunal.
Arbitral tribunal.
Yes, my lord.
ಕೊಡಿ. Yes.
Fresh matter, my
Yeah.
lord, regarding to the KDB. Acquisition has been completed, but compensation has not been paid.
ಕೊಡಿ. This will come regularly. What is the urgency in this?
Wait. What is the problem?
Why are you pushing?
Blood, 13. Yatisha KG, 13.
Inform ಮಾಡಿದ್ದೀರಾ respondents ಗೆ? At the request of counsel for the petitioner, released on 22nd September.
My lord, serial number 65, my lord, I appear for the respondent bank.
65, just a moment, 61, Allah. Yes. Yes, 65.
My lord,
What
I
is it,
appear
madam?
for the respondent, my lord, I have informed the petitioner counsel, I'll be filing the explanatory note today. My lord, kindly have it next week, my lord.
65 at the request of counsel for respond number 2 released on 11 September.
My lord, there is interim order, my lord, that may kindly be
Interim order
extended.
earlier grant. Note code interim order ಯಾವ್ದಿದೆ extend ಮಾಡಿ.
Much obliged.
My lord, 71, it's not an adjournment that I'm seeking. If your lordships will recall, this is a solid waste tender management matter. It was in the 230 list, my lord, it's come in the regular list.
ಯಾಕೆ 230 ಇತ್ತಲ್ಲ ಇದು ಪಾಠ ಅಲ್ಲ ಇದು.
Can it be taken up at 2:30 today?
We'll take it up at 2:30, 71.
Grateful.
Yes. And there are only few matters listed. What about the other set of matters? Only 4 matters in 71.
Those are 4 different baskets, my lord, that was divided by
12
the
matters in all.
these batch matters were listed for today, my lord. It was listed on the day your lordships were not
What
holding.
about the other
sitting.
matters?
Not sure, my lord, of those matters.
All of them have to be taken
No,
up.
but mine is a separate question of law, my lord. That is only for L1.
Only for the purpose of separate. The facts are the same. Yes, we'll find out when the other matters are.
Grateful. But this will be taken up at 2.
Yes.
Please.
Lord, serial number 77, my lord, I request a short accommodation.
The request of counsel for the
Interim order
petitioner
is maybe
released
extended.
on 17th September. Interim order earlier granted is extended till next date.
Grateful.
My lordship. This may be urgent or 19th, my lordship, along with the other thorough matters.
87, 19th. Yes, madam.
My lord, serial number 110.
110.
Yes, matter may be taken up by 2:30, my lords.
Why?
My lords, there is a family court order for custody and visitation.
That custody
rights.
matter, yes. 110, 230 crore. Yes.
Serial number 120, my lords. I will be permitted to withdraw and therefore I am liberty to file before Dharwad.
120. 120 memo is filed, dismissed as withdrawn, reserving liberty to file before the appropriate bench.
Serial number 91, my lord.
Hmm?
Parole matter, my lord. The separate date is parole matter, my lord. General parole, my lord. The date is given on 19th, my lord. It may be taken on 19th.
91, 19th.
19th at 2:30, my lord. Parole.
Parole matters will be at 2:30.
Lords, serial number 20 in second list, lords. I undertake to file wakalat, lords, innovative wakalat for petitioner, lords. Memo for retirement is filed, lords. 20.
Yes, have you informed the respondent?
Lords, fresh.
It's a fresh matter.
Yes, lords.
She so and so submit that you will be filing wakalatnama for the petitioner.
Yes, lords.
Registry is direct, print his name and delete the name of Sri Tata Krishna once wakalatnama is filed. A special order.
It may be taken on next week, lords.
Released on 17th August. (112), 119 memo for withdrawal, 112 memo for withdrawal. Yes.
The date wrongly listed. 12/8/12.
ಏನಪ್ಪ?
The date was wrongly listed. That's 12/9 instead of 12.
ಯಾವುದು?
It was supposed to be listed today. Listed as 12/9.
Which matter was supposed to be listed?
It's not listed.
Then move a memo. Check ಮಾಡಿ. Yes.
For the petitioner.
Yes.
On the CCTV footage,
Huh.
which existed preserved for the purpose of preservation, endorsement was also issued. Now the direction was passed by this honorable court on July 14th to state that appear before the CISF on July 15th and collect the CCTV footage. We appeared before the CISF commandant, and the CCTV footage what was given to us is between 4:30 to 7 p.m. That's all. On the contrary, what we had requested was CCTV footage from 3/3/2025.
You are alleging non-compliance.
Yes.
File a contempt. How can you come back and move the same
What
matter?
happens is,
Anyway, my lord, if, my lord, let me, and I think before this honorable court, we had undertaken that we have preserved from 16:30 hours on 3rd March to 6 hours on 4th March.
4th March.
I believe that video, there is one particular video which runs all the way up to 11 hours. So they have thought that since it is more than what the court ordered, it cannot be given. But I have told them that it can be given. So there are different videos. They have given some videos.
11 hours will not be more because it is 14 hours. 4:30 PM to 6 AM is 14 hours.
ಅಲ್ಲ ಅವ್ರ ಹತ್ರ ಅದು 6 AM ಅಲ್ಲ 11 AM ತನಕ ಹೊಂದಿದೆಯಂತೆ. So they thought that it will be beyond what the court ordered. So I told them that can be given. So they
cut it till 6.
No, I believe it cannot be. They cannot meddle with that. But after 2 days they can approach. So they will give one more.
The matter has been moved for being spoken to by the petitioner on the ground that the order dated 14 July 26 has not been complied with, and the entire video footage from 6 AM on 3/3/25 to
4:30 PM.
4:30 PM on 3/3/25 to 6 AM on 4/3/25 has not been provided. Learned ASGI submitted that there was some kind of misunderstanding with the officers, in as much as the recorded video which is available is from 4:30 PM to 11 AM on 4:30 PM on 3/3/25 to 11 AM on 4/3/25. And since the direction had been issued to furnish the video only until 6 AM, it was not furnished. He submitted that if the petitioner were to approach the first respondent,
Yes, ma'am. First.
the video up to CCTV video recording up to 11 AM would be furnished. Placing his submission on record, no further orders.
Whatever we have preserved, we'll hand over.
You are getting more, keep watching.
But the original is already erased. We cannot do anything. The original in
2
the
months
server, it
only.
is erased, but we have preserved and that is available. At any point of time, we can make copies and give.
Hash value is always there to verify.
Challenges to a notification of section 23, my lords, of the Hindu Religious and Charitable Institutions Act. I am not seeking for any interim order, my lord.
Section 23
of the Hindu Religious and Charitable Institutions Act. Lords, there are 3 categories of temples which can be
ABC.
included. Lords, I don't come under the first category. I was not covered under the erstwhile act.
This is not part of what Supreme
No.
Court, it's not there.
2 and 3 also I am not covered because I am not really getting any Tasdik alliance under the Mysore Religious and Charitable Inams Abolition Act, nor any monthly or annual allowance is paid by the government for maintenance of the temple. As a matter of fact, even after 2012, you have been giving representations.
But you are not challenging the virus of 20, you are challenging the notification.
Only the notification, my lords, because we don't come within the parameters under section 23 to be notified as a notified temple.
And AGA accepts notice for respond number 1 to 4. She seeks for and is granted 2 weeks time to obtain instruction maker submission. File a statement of objection. Released on 3rd September.
For preliminary hearing only, my lords. It's a very short.
Preliminary hearing.
Lords, it's so great.
IA 1 of 26 is allowed.
Sought for writ of mandamus to direct to consider representation is a covered by judgment. Annexure be paid, then vehicle release,
Release the lorry
the release of the vehicle.
without insisting on
Thank you.
bank
And covered by
guarantee,
judgment.
accepting surety.
Lord, my instructions are that they will release the vehicle, my lord, and they will hear
Surety
their
is-
application.
And AGA accepts notice for the petitioner, for respondents. Petitioner is before this court seeking for the following leaves. The lorry of the petitioner bearing registration number KA01AD1486 having been seized by the respondents in connection with the case in FOC number 3 of 2627. A condition initially was imposed for furnishing a bank guarantee in order to release the said lorry. The petitioner is before this court contending that in view of the various decisions rendered by this court, there would not be a requirement for providing a bank guarantee if the petitioner is willing to provide adequate surety, which could be considered for the said release. And AGA submits that on instructions, submit that if a necessary application is filed by the
Application is already filed, that
Filed.
will be, hearing will be conducted.
the application would as filed by the petitioner would be considered,
Next hearing.
given within how many days?
My lord, they'll consider it within this month. This month, my lord.
Within
15
2
days.
weeks from today, placing a submission on record, petition stands dismissed.
Please.
2 weeks without insisting bank. Without insisting bank.
On surety, they ಹೇಳಿದೆವು. Yes, Mr. Naidu.
The petitioner, this is regarding refund of the stamp duty and registration charges by the sub-registrar, because the registration did not take place on the date when the appointment was given. Subsequently, I have tried to register the property the next day, requested them to adjust the payment made online, but they have refused. They have suggested me to seek refund. Now they say that they are cutting more than 30% of this stamp duty and registration charges.
When is that matter? Reach agade problem allapa. And be considered like that. If yes,
One of the executed did not appear on that day, that will get it postponed. After he uploads and makes the payment to the stamp duty, that means the document is being presented.
fair enough.
Now, what happens is that the stamp has been used. Because they use the machinery. Now, what happens physically, my lord, if I print on a stamp paper and I don't execute the document, then I cannot put a white car and do it physically. Now, digitally, now what happens is, once I have uploaded the document, stamp has been calculated, the officer has approved the document, appointment is here, he does not appear because he says the reason for not appearing.
But he appeared the next day, is what you say.
Yes, my lord. The registration is taken place next day.
You made a change.
Judgment, similar grounds, the judgment of this honorable court.
Please give us the facts, Mr.
Yes,
Naidu,
madam.
first,
Yes,
then
madam.
you can
Yes,
go to the
yes, madam.
judgment.
Yes, madam.
You said the next day you appeared and got it registered.
Yes, madam.
Did you make any change in the document before submitting it again?
Nothing, no other changes. No other changes. Because the purchaser, because the vendor, one of the witness has to come, the attesting witness. He has not come on that particular day. Because
That
he
is
the
why
son
we
of
are
the-
asking you, was any change made, yes or no, ashte
No,
adralli.
my lord. No, nothing has been changed.
The attesting witness change antira, illa
He did
antira.
not come on that day,
He came on the next day.
next day.
So there was absolutely no change in the document.
Absolutely no.
Where is the document?
Lord, the document is at Annexure D, my lord. Annexure D is the sale date.
This is a registered document.
Yes, my lord.
Where is the document which you had uploaded which is not registered?
Uploaded is at Annexure B, my lord. The payment was made and it was uploaded before the concerned sub-registrar. Is at Annexure B. Ink page 19 shows the document it was uploaded. Ink page 18, my lord. There is no change in the document. The son of the petitioner did not come. He was the consenting witness. That is the reason it has been postponed.
What is the change which has happened, Mr. Jaffer?
But the consenting witness was not appearing on the day.
On that day, next day he appeared.
I will secure the instructions. The uploaded document
Hmm.
only has the first portion, not the kindly see page number 18,
Yes.
uploaded deed document, if not, you can see below the page on the left hand side. There is only the first page. Let me open the copy of
No,
that.
if you look at page 16, is who are the people who are represented? That is claimant number 1, Munaf Bhai, Amir Bhai, Veeramangalwala. Claimant number 2, N. Manjula, Lok Raju, Shashir.
Because the consenting, one of the consenting, the wife of the vendor was not present on that day.
There doesn't appear to be any change in the names.
I have to get this document that has been uploaded on 19.
Get it. If there's a change, we'll have to consider. If there's no change, then you'll have to refund them.
What has happened? I will raise the records.
These are practical. Someday somebody is not well.
That
Something happens.
cannot be the issue.
The next day it is registered. You can't keep the stamp duty with you.
That cannot be done because that is not the issue. I will place it before the court. If at all
The
that is
AG accepts notice for respondent number 1 to 4. He is called upon to secure instruction and make his submission as to why the refund of the stamp duty for the earlier uploaded document has not been made when the categorical submission made by Sri Rajgopal Naidu, the counsel for the which was listed on the very next day by making payment of additional stamp duty. Yes. Released on 24th August. Yes.
And for the petitioners, my lord, this petition is filed for seeking quashing the annexure D, my lord, passed with the respondent number 4, and for mandamus.
Annexure D.
D, my lord.
What is Annexure D?
My lord, it is the
Svikruti Patra.
Svikruti Patra, acceptance receipt, my lord. My lord, earlier there is a rival factions for the executive committee of the respondent number 6 institution, my lord. Earlier, one of the
And AGA for respondent number 1 to 4 issue notice to respondent number 5 and 6 returnable by 16th September.
my lord, till then the annexure D may be stayed, my lord.
Let them come, we'll hear them. We can't stay the section. Rule 13.
Matter of students, my lord, the institution students ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಅವ್ರ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ತಾ ಇಲ್ಲ. ಈಗ ಅಲ್ಲಿ
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅದ್ ನೋಡಕ್ಕಾಗಲ್ಲ. ಇದು ರಿಟ್ ಪಿಟಿಷನ್. Only 13, whether it's validly accepted or not, we'll consider. If you have any other dispute with the society,
OS is also
ಅಲ್ಲೆಲ್ಲ ರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಿ ಬರೀ 13 acceptance ಮಾತ್ರ ನೋಡೋದು.
For petition, my lords, petition by the Lokayukta, my lords, allegation is against regarding the misappropriation of funds, my lords. Earlier, what happens, my lords? The work board has passed a penalty order, my lords. Later, subsequent, she preferred an appeal before the board members, my lords.
Penalty has not been confirmed. And AGA for respond number 1, issue notice to respond number 2, returnable by ಯಾವತ್ತಮ್ಮ ಇದೆ ಇದು? ಇವತ್ತೇ ಇದೆ. 116. Register. So in a service ಆಗಿಲ್ಲ. Returnable by 22nd September. Connect with number ಕೊಡಿ.
Please.
Yes.
This was the matter yesterday, my lords, where I submitted that the caveat address was not put in my lords discharged their caveat.
Yes.
I gave them a copy yesterday.
Copy is yesterday, my lords. May be taken up on Monday.
No way.
I object.
Only for that reason we'll grant stay, whether it merits or not. You have done 2 mistakes. One, you have not even given the address properly in the caveat, purposely. As a lawyer, you should not do that. If we'll ask Karan to file a caveat against your client without any details. Don't even mention the caveat as details.
My good conscience won't let me, my lords.
Can't be doing that.
May I commence, my lords?
Yes, please.
I appear for the landowner, my lords. This arises out of a order passed by the K. RERA, my lords, where my application to recall an ex parte judgment against me was rejected without hearing on the sole ground that the RERA does not have the power to recall its own judgment. Now, very briefly, I'll only take 2 minutes on the background facts, my lords. This is a case of mysterious impediment. where more questions are
It is
raised.
mysterious.
I'll make good this case.
It's not Agatha Christie story.
I'll make good the case. More questions arise from the record than answers.
Hmm.
Very briefly put, my lords, in 2021, someone who has entered into an agreement for sale files a RERA complaint where the only respondent is the builder, who is my learned friend who is appearing before this court. I am not a party to the RERA complaint, notwithstanding section 2 ZK, my lords. I am not a party to the RERA complaint.
Hmm.
A judgment is passed
You
by
are the landowner.
I am the landowner.
Hmm.
A judgment is passed, ex parte judgment is passed against the developer by the RERA authority.
Hmm.
The developer files an application to recall the ex parte judgment, which is rejected on the same ground that there is no power to recall. They then file a writ petition, my lords. In the writ petition, the matter is remitted back to the RERA to decide after hearing the matter.
Hmm. Yes.
In January of 2025, the second judgment comes. I am not a party, my lords. I have no notice. I don't know about these proceedings.
Hmm.
Second time when the judgment comes, my lords, with no rhyme or reason, I am a party. And the entire liability has been affixed only on me to the exclusion of the developer. I have not received a notice. There is no impleading application ex parte. And the developer is exonerated in their entirety. Now, once this comes to my knowledge, my lords, I immediately file an application for recall of ex parte judgment. The registry, which has been arrayed as respondent number 4, informs me after 7 days of following up, my lords, that volume number 1 of my application has been misplaced by the registry, including all originals, all my certified copies. I asked them for an endorsement. They are arrayed as a party, my lords, respondent number 4. I request for an endorsement to say that my volume number 1 has been misplaced. Please give me an endorsement so I can file a Xerox copy and the matter can be heard.
Hmm.
The endorsement is refused on all occasions, which leads me to file a letter putting this on record and requesting for the endorsement. The matter is not listed for hearing. We are not given an opportunity
Where
to.
is that application?
The letter, my lords, is in volume number 2, page number 501.
Again, another volume.
This has not been misplaced, my lords.
Let's see. Yes.
Page number 501 at annexure Z. This is to bring to your kind notice that our office on behalf of respondent number 2 and 3 has filed an application for recall of the ex parte judgment, an order dated 31/2025 in the caption matter, comprising 2 volumes on 18th June 2026. Subsequent to the filing, our office has visited the authority on numerous occasions, seeking an update on the status of the listing of the application before the bench. On 3rd June, our office was informed by the registry that volume 1 of the court record was misplaced and could not be traced due to inadvertence. The miscellaneous application is yet to be numbered. Should the authority direct, our office shall provide a photocopy of the as-filed version of volume 1 at the earliest.
There is no e-filing there, is it?
No, madam. We request an
No
endorsement.
e-filing at all, or e-filing is not being done?
It was no e-filing, my lords. We had to directly file it.
Hmm.
We request an endorsement to this effect by the registry. We furnished a photocopy along with this, my lords. Few days later, the impugned order, without hearing, no notice, no numbering, the impugned order is passed saying that the authority has no power to recall. Now, at this stage, my lords, when I'm appearing in this writ petition, I've asked for 2 impugned orders. One is the order which says that the authority doesn't have the power to recall. The same bench has passed an order in a different case just a few months before, affirming the power to recall their own orders when there's a violation of the principle of natural justice. Now, if I may just show the record, my lords, it's inexplicable as to how the developer was exonerated in its entirety in the second round. And it's the developer that is today on caveat before my lords, not the complainant. If I may show, my lords, volume number 2, page number 525, my lords. In fact, even the developer's name is changed in the second round. I'm not able to ascertain from the records how it is.
7 case Rekha Rukmini.
Complete.
Where is the initial order which had been passed?
My lords will please see the first judgment is at page 446 at annexure U. Volume 2, my lords.
446.
My lords will see the respondent is a sole respondent, Naksha Project Private Limited. I'll show my lords in the second judgment, even this has been changed. Suddenly the managing director becomes a party instead of Naksha Projects. And there's no explanation as to how the respondent changed. If my lords will please see the order sheet, my lords, which is revealing of what has happened before the RERA.
So this is the initial order passed on 27 June 23.
This was set aside by the High Court in writ petition, my lords.
Where is that order?
That's at page number 81 in volume number 1, my lords. There also I am not a party in the rank of parties.
That is what we are looking at.
Page number 81, annexure D, my lords.
That was filed by the developer.
Yes, my lords. To seek recall of the ex parte judgment at the first round. I am not a party and I presume the registry has not raised objections because I'm not arrayed in the rank of parties. Now, if I may show the order sheet, my lords, the sequence shows at what point notice.
Just one. So the developer had not appeared, ex parte order.
Ex parte order, they filed an application to recall. That also was rejected on the same ground that there's no power to
But
recall.
the High Court allowed it.
High
Then
Court
the
allowed
matter was remitted. Then what happened?
My lords, if I may now show page number 56, annexure B, just before I come to the order sheet, the second order which has been passed, which I have impugned, my lords.
That is annexure B, that we have seen.
My lords will also see respondent number 1's name is changed.
Yes.
It's now become Shri Ravichandran K, Managing Director of Naksha Projects. There's no explanation as to this. Now, my lords will please see the order sheet of the RERA, my lords.
And Diwan Housing comes in.
Yes, my lords.
Yes.
The financier.
How does he become a party?
There's no explanation, my lords.
That also no explanation.
There's no explanation. If I may show the order sheet
The
now,
very
my
serious things you are making submission.
which is why I'm only saying, my lords, the record raises questions.
Where's the order sheet?
502, my lords. I'm very cautious. I would not want to make any allegation. I'll only point out what I am not able to ascertain from the records. Page 502, my lords. If I may just show a few pages. On page 502, my lords will see issue notice to both parties as the complainant and the sole respondent developer.
This is during COVID time.
Yes. Now, my lords will please see the rest of the order sheet records only two parties throughout till page number 508. At 508, my lords, on top of the page is recording that the High Court has sent the matter back for fresh consideration.
When was the final order passed?
Now, my lords, page.
Just one. Nothing to do.
Final order is 31st Jan 2025.
The 27 June 23.
First order, yes, my lords.
27 June 23 orders uploaded, yes.
Now, my lords, on page 509 is the first reference to me. If my lords has it, I'll read it, my lords. Case called, both the advocates are present. Respondent advocate is the promoter and submits that this flat T301 falls in the landowner's share. Hence, he has nothing to do. Issue notice to the landowner. Now, there is no application for impediment. Notice is issued to me on the assumption that I am already a party. In the MA for recall, I have said that these addresses don't belong to me. The notices that were issued, I do not reside at this address. The developer is fully aware that I am a permanent
Where is your
resident.
joint development agreement?
My lords, the JDA is at Annexure E at page 88. Keep the same deal ready. Same deal you have. My lords will see at the JDA.
Same address, 62 bar.
Correct, my lords. There are two addresses which come in the impugned judgment. One to which the notice is issued, I have no sense from where that address was created, my lords. I have never resided at that address.
The Basangudi address.
Yes, this address, my lords, Gavipuram extension, was in the transaction documents of 2014. It is my address. In 2021, I have sold this property. There is a sale deed. And in prior litigations with the developer and the complainant, it is within their knowledge that I no longer reside at this address.
Which litigation?
In 2021, my lords, the same complainant, in addition to filing the RERA complaint, also filed a suit for the same relief.
Where is the plaint in that suit? How do you, he has made your other address?
My lords, in fact, the notice that went to these addresses, he files an application for substituted service, and then I come on record. The suit, my lords, is at page number 369.
Yes. That is again Gavipuram address.
The sheet. Yes, my lords. Now, these
also this Datta Mandiram Basangudi address is also mentioned there.
Correct. Now, the address that is mentioned in the 2021 suit by the complainant, my lords, notices are not delivered to me. And the order sheet reveals, I didn't receive notice. The order sheet reveals that they filed an application for substituted service because the notice was not delivered.
Okay.
I have a separate suit in 2021, my lords, against the developer, where I've raised all allegations of fraud and collusion with the financier. And in that suit, I have put my new address. So the developer also at all points of times has knowledge that these are no longer my addresses. Now, even if all of this is kept aside, the question I ask from the RERA records, my lords, there is no order formally recording me as ex parte, which would have only been done if the authority is satisfied that service was completed upon me. When the developer was placed ex parte, the RERA authority has passed a separate order placing them ex parte after due service. But no such order is born from the RERA records insofar as I am concerned.
Yes, Mr. Counsel. Had any application been filed to implead them?
My lords, it is upon this. In fact, my lords, he is a complainant. Complaint is R1, my lords. In this appeal,
Who are you?
I am the developer, my lords.
You are the one who asked, made the submission that it comes to the landowner share, so make them a party.
No, I said that I have nothing to do. It is the shares that are falling under the share of the landowner.
Did you make any application to
No,
bring
my
them?
lords, absolutely not made any
From the order sheet, it doesn't appear that they were made parties ever. No application was filed.
I have not made any application, my lords. I can say it, my lords.
And my lords, they've been exonerated in the second round. The entire liability has fixed only on me.
My lords, may I submit, my lords?
Yes.
My lords, what my learned brother counsel submitted is only with respect to half of the factual aspects. My lords, till the matter was ex parte initially against me, I come before this honorable court. This court again orders me to go represent. Once I go back to the court, when the proceedings were going on, thereafter, my lords, the landowners were also have on record. My lords,
how did they come on record is why we asked you.
It was not on the application. What I have not made the application.
Who made the application? Anybody made an application?
It is upon, I should take instruction that, my lords, upon that, my lords. Next, my lords, in continuity, my lords, this order, my lord, the proceedings, the landowner was aware when he cross-examined the complainant in the OS matter, my lords.
He may be aware, but was he made a party?
Yes, my lords. His own admission, my lords, may take his cross-examination. He himself.
Was he made a party, Mr. Counsel? Knowledge you can establish. You are the developer. You are the one who has to construct. They are responsible, yes, as a landowner. But all completion activities by the developer, not by them.
Yes, my lords. I agree, my lord.
Very nicely you went and made a submission. It falls to the landowner share. Who is going to develop it?
Yes, my lord. I have to develop, my lord.
Then have you done it
Completed, my lords.
with delay?
Well in time, my lords.
So
They are already
delay,
in
you are
possession.
responsible. They can't be responsible.
He is already in possession, my lords.
He is not the complainant. So you have to pay the entire amount. They have to only execute the sale deed. So long as they don't execute the sale deed, if you are not there, we would have held them responsible because they have entered into a development agreement with a developer like you. What is the mistake that they have done? So that is why they are also responsible. But now that you are there, you are responsible to make payment. And you go and say there that they are responsible, it falls to their share.
My lords, my only submission, my lords, my only submission is
Who
this,
had appeared? Shilpa Rani had appeared.
my only submission is, my lords, they were well aware of these orders in the month of October 2025.
We'll direct you to deposit that entire amount. Ms. Shilpa Rani, who had appeared for respond, Ms. Shilpa Rani, who had appeared for respond number 1, complainant, before the care era, is directed to accept notice for respond number 1. Shri Tejas MR, who has filed caveat, accepts notice for respond number 2. Diwan Housing Arama. JM Patil is directed to accept notice for respond number 3. Shri Gautam Dev Ullal for respond number 4. Mr. Ullal is directed to obtain instruction and file the affidavit of the Secretary of respond number 4 as regard to various serious allegations which have been made in the present matter. Firstly, as regards the petitioners being brought on record without a impleading application. Secondly, as regards no notice having been served on the petitioner. Thirdly, as regards the loss of the application and the documents filed by the petitioner before the fourth respondent, as also various other, apart from therefrom, the other allegations made in the petition. Respond number 2 is directed to deposit the entire amount awarded initially,
That's at
while
page number
dated
63.
27 June 23 in complaint CMP number 210419 stroke 0007909 along with the applicable interest as on date.
My submission is that,
With
my
the
lords, I am not
registry.
at fault, my lords. I have not committed any kind of fault in this, my lords. I am here. to
We'll
again
consider
assist
your matter, Mr. Counsel. We'll consider what you say.
deposit, my lords, should be heavy, my lords, for no fault of mine, my lords.
Is
My humble
all-
submission, my lords.
Ex facie, it is your fault. You deposit.
My lords, my humble
Because
submission.
we
My lords,
cannot have this person not getting the money. Between both of you, will decide later.
my lords, I shall not be penalized at the initial day, my lords. My lords, let the matter be considered merits, my lords. I have not done any fault, my lords. In fact, my records clearly says, my lords, what is my role before the trial court, my lords.
You had the gumption to go and say that you are not responsible, they are responsible because it is their allotted.
It was.
That's a completely wrong statement.
I am sorry, my lord. It was only with respect to that flat, my lords. It was not with otherwise motive that, in fact, we both are the one who is going to bear this, my lords.
The
As
council,
a
you have
landowner,
already made a lot of mistakes. You have made a lot of mistakes. Your client has made a lot of mistakes. You want to make it even worse for yourself? We will impose further costs also.
My humble submission, I shall not be penalized at this stage, my lords.
Now we are restricting it to the only the amount. You want costs also to be imposed down only, we'll do that. This absolutely does not inspire any confidence. It is completely malafide. Within a period of 4 weeks from today, that is on or before 8th September, if the 9th September, if the deposit is not made by 9th September, suitable coercive action would have to be taken against respond number 2, which respond number 2 is put to notice. The operation of the order dated 30th January 25, passed by the Real Estate Regulatory Authority in CMP number 210419 stroke 0007909 is stayed till the next date of hearing. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the counsel for respond number 1 and 3 and file acknowledgement thereof by end of day 14th August, failing which the interim order will stand automatically vacated.
My lords, may I, in the interim order, may I request also consequential proceedings? I am not aware if RRC proceedings have been initiated.
Once that is stayed, then everything
I
gets
bow
stayed.
down. My lords. I bow down. Is that, can a date be fixed, my lords? The date is being fixed.
Date has not been fixed. Relist on 15th September.
Much obliged, my lords.
ಇದು ಅದ್ರ ಮೇಲೆ ಹಾಕೊಳ್ಳಿ. Email ಮಾಡ್ಬಿಡಿ.
Lord, one submission, Lord. I'm sorry, serial number 6, my Lord. Previous matter. Respondent number 1 is, my Lord, Karnataka State Work Board. I'm sorry, my Lord.
Waqf board.
Adರಲ್ಲಿ state has been direct. State ಅಲ್ಲ. Work
Shri
board
P.
P.
Usman
Usman
for respond number 1.
I'll serve
Issue notice to respond.
But I will permitted ಅಲ್ಲಿ State of Karnataka ಅಂತ ಮೇಲಿಂದ ಬಂದಿದೆ. Permitted to, my Lord, make some correction.
Change ಮಾಡಿ.
I'm sorry.
But you can't change it. Entry ಆಗೋಗಿದೆ CIS ಅಲ್ಲಿ. You have to file an amendment application.
Please, I'll file it. I'll file it.
Kindly permit me to appear in this.
Yes.
Lord, externment order under 55 without notice to me.
Without notice.
Without notice. What happened is on 13/11/25, my Lord, original order of externment was
Notice has been
passed.
served, madam.
Page 19, madam.
Then, my Lord, I challenge.
58 notice was served, my lord. Fourth line, my lord. ಕಲಂ 58ರ ಅಡಿಯಲ್ಲಿ. ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆಗೆ ಅಪಾದಿತಿಗಳಿಗೆ.
He did not appear on that.
No.
Let him appear.
Lord, kindly appreciate, my lord. One crime number is under Arms Act, my lord.
He'll appear, we'll ask him to appear on immediately after Independence Day.
Let them
My
prepare.
Lord,
Appeal maybe.
this few facts, my Lord, I'm sorry about it.
We are remitting the matter. You go and place all the facts.
Because this is an extension order passed. Original order has lapsed.
You place all of it.
So original order, they had issued notice. After lapsing, my Lords, again on the same material, second order is.
Don't make this court a executive magistrate court. That service of notice, madam, is summons.
Please, ma'am.
You do it so that
Please,
these issues won't be taken up.
May I bring to my lord's notice one government order
Sorry?
so far as externment, my lord. SP is appointed as a special magistrate, my lord.
He's been appointed.
Please, my lord.
So now that ground will not be available.
Please, my lord.
If you do all these things properly,
The one matter, my lord.
Mr. Dalwai cannot take advantage of it. And AG accepts notice for respond number 150. Petitioner is before this court seeking for the following leaves. The contention, the submission of Shri Venkatesh Dalwai and counsel for the petitioner is that notice had not been served on the petitioner, and as such the petitioner could not appear before the second respondent. Learned AG has submitted that notice had indeed been issued and been served. The petitioner had not appeared, and it is for that reason the matter proceeded with. Do you have the acknowledgement of service?
I'll have to certain.
The dispute is as regards service of notice. The acknowledgement of service has not been placed on record. Hence, benefit of doubt would have to be made available to the petitioner. In that view of the matter, having extended said benefit, it would have to be held that notice has not been served on the petitioner. As such, this court passes the following order. Writ petition allowed, a certiorari is issued. The order dated 4/7/26, bearing number so and so, passed by respondent number 2 at annexure A, is set aside. The matter is remitted to the second respondent. The petitioner shall appear before the second respondent without requirement of any further notice on 19th August 2026 at 2:30 p.m. and submit his written objection as also oral submissions on that day, which shall be considered by respondent number 2 in accordance with law and pass necessary orders
Please.
within 30 days from the date of
Instead of
such.
19th, 24th, there is a death in the family of 24th.
24th,
24th.
19th, but 20.
Great.
Within 30
Regarding
days.
summons, my lord, I have communicated to IGP.
Once that is done, ask them to send it.
Please.
You can produce it.
Yes, ma'am.
Petitioner in this case, madam.
Yes, Ms. Kushalapa.
Petitioner challenged the order passed by the respondent to appellate authority, the Maintenance of Senior Citizens Act, madam. This case, madam, fact is, madam, the respondent 4 is the uncle of the petitioner, and their wives has executed the partition deed in favor of the petitioner and his brother, giving some property of their own.
Wife is executed.
Wives, he has two wives.
Uh,
They have executed the partition deed.
Where is that document?
Document is page number 28, 25, my lord. ವಿಭಾಗ ಪತ್ರ.
ಭಾಗಪತ್ರ ನನ್ನ
ಈರಮ್ಮನ್ ಅಂಜಮಾದ ನಾವುಗಳು ನಮ್ಮ ಭಾವನ ಮಕ್ಕಳಾದ ಶ್ರೀನಿವಾಸ್ ಮತ್ತೆ ಅನ್ನೇಗೌಡ. This entire revenue record has been changed in my name, my lord. And subsequently, in 2024, I executed the gift deed in favor of my wife. So after the death of both the wives, the respondent 4 filed the petition under section 5 and 23 before the assistant commissioner, my lord. And assistant commissioner has passed the order to pay maintenance of rupees 3,000. Page number 24 is the order, my lord. Page number 24, to pay maintenance of rupees 3,000 per month. So from the date of the order, my lord, till date, we are paying that amount to the respondent number 4. This page number 69, I produced the statement of account. 60 and 61 is the statement of account. In that, every month we are paying rupees 3,000 to the respondent number 4, my lord. So respondent number 4 filed an appeal before the respondent to appellate authority. And appellate authority passed an order, impugned order for cancellation of the gift deed and also change of the kata in favor of the respondent.
What is the finding on the partition deed? Where is the impugned order?
This page number 18 and 19.
Page number
18.
18.
ವಿಭಾಗ ಪತ್ರ ದಿನಾಂಕರಂದು ಹಳೆಕೋಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 77ನಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ಜಮೀನು 1ನೇ ಪ್ರತಿವಾದಿ ಹಿಸ್ಸೆಗೂ ಹಳೆ ಸರ್ವೆ ನಂಬರ್ ಅವರ ಅನ್ನೇಗೌಡರ ಹಿಸ್ಸೆಗೆ ವಿಂಗಡಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಪ್ರಕಾರ 1ನೇ ಪ್ರತಿವಾದಿ ಮತ್ತು ಅವರ ಅಣ್ಣ ಅನ್ನೇಗೌಡರವರು ಹಿಸ್ಸೆ ಬಂದ ಮೇಲೆ ಹೇಳದ ಆಸ್ತಿಗಳು ಪ್ರತ್ಯೇಕವಾಗಿ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಒಪ್ಪಿಗೆ ಪತ್ರ ದಿನಾಂಕದ ಪ್ರಕಾರ ಎಂಆರ್ ಅಂದೆ ವಾದಿ ಅನ್ನೇಗೌಡ ಮತ್ತು ವಾದಿ ಹಿಸ್ಸೆಗೂ ಬಂದ ಮೇಲೆ ಹೇಳದ ಜಮೀನು ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ.
And AG accepts notice for respondent number 1, 2, 3 and 3. Issue notice to respondent number 4, returnable by 23rd September. The operation of the order dated 9/7/26 passed by the second respondent appellate authority in MAG HNAR 01/2025-26. He stayed till the next date of hearing, considering that prior to the gift deed executed by the petition number 1 in favor of petition number 2, petition number 1 derived title to the subject properties under a partition deed executed by the wives of respondent number 4, as regards which respondent number 4 is neither, as regards which property respondent number 4 is neither the owner nor a party to the partition deed. Process fee and copies to be furnished by end of day 13th August, failing which the interim order would stand automatically vacated.
Obliged.
And AGA for respondent 19th.
Proceedings under Senior Citizenship Act. Impugned order at page number 24. The award of interim maintenance of rupees 8,000 is under challenge. Kindly see page 84. Page number 24, Annexure A.
24.
Yes, Annexure A. Kindly see page 23, my lords, before one page. My lords, on 12/6/2026, my lords, got it. My lords, I myself has represented and filed a wakalat. My lords, next page.
You were respondent number?
1. There, my lords, in Soumya Lakshmi.
Yes, present.
Yes.
He wants to reside in a house located in Panajas.
Then, my lords, page number 24, very next page, on 3/7/2026, my lords. My lords, there is an order directing to pay maintenance of rupees 8,000 starting from July 2026. My lords, got it. My lords, again, in the very next page, posted for interim order, next hearing scheduled on 17/7/2026. Then, my lords, on the same page, on 17/7/2026 at last line, previous hearing posted for interim orders to be issued.
Like, do free from 3 years after death of an amount. Where is the actual order sheet?
Yes. My lords, order sheet, my lords may refer to page number 19. Last line ali, R1 directed to pay monthly maintenance of rupees 8,000 starting from July 2026, my lords got it. Next page. Next page.
These are his notes also found in the order sheet.
Next,
That's why it
next
did not
page,
make
another
any
page.
sense. These are his
Posted for
side
interim orders.
notes. This is not the way to maintain order sheet. Which is the direction, which is an order, which is a note, cannot be made out from this.
Or he's been trained.
Part of it is a note, part of it is a note. Like is noted from 3 years after death of husband residing with sister. That's a note. Stay in our own house is again a note.
All this is a note.
Then within 1 week, everyone is directed to ensure something. Resides in our own house situated at Panaje, Grama. That is also a note only. CDPO police to submit. Okay. What is it that you want to say on this?
My lords, this order directing to pay monthly maintenance to be is under challenge in the writ.
8,000 rupees.
Yes.
That was passed on 3/7/26.
Correct.
What is your vocation?
Please, my lords.
What do
There
you
are
do?
two daughters, my lords. Daughters.
What do you do?
My lords, housewife. Housewife.
What does your husband do?
Lords, husband is a advocate, my lords. My lords, she was been brainwashed by her sister's husband. My mother has been brainwashed by her sister's husband.
By your sister's husband or her sister's
Her
husband?
sister's husband.
Your aunt, maternal aunt.
Yes.
She likes you a lot.
Fake love has been shown to knock out the property.
So how many children does your
Daughters, my lords. Petitioner is one of the daughter and respond number 3 also is a daughter.
So both of you put together is 8,000 rupees only.
We have no difficulty. My lord, the prayer is, my lords, in the prayer column, the petition is to file with a prayer to give a possession, not to give a trouble
Mr.
and protection
Sachin,
order,
can't
compensation
your
from the
client
daughter.
pay 4,000 rupees to her mother? You won't stay this. And AGA for respond number 1, issue notice to respond number 2 and 3, written by 22nd September.
Insist me to pay maintenance for 4,000.
Continue paying. 4,000 rupees a month between both of you.
My
4
lords,
plus 4.
let other daughters pay another 4,000. I have been burdened with 8,000 rupees. There are two
There's no particular direction for both of you, Alva.
ಇಲ್ಲ ಇದೆ
Jointly.
only ಒಬ್ಬರಿಗೆ ಮಾತ್ರ
ಎಲ್ಲಿ?
R1 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ನೋಡಿ.
All the produce taken by R1, therefore 8,000. So you have taken the produce.
Please
pay for 2 months. Let them come.
My lords, now the matter is posted for orders on interim order. My lords, whether the AC has passed an order considering the interim prayer or not, we not aware.
To see what it is, this is an ad interim order which has been passed. Take into consideration that you have taken the produce. It must have been heard now, and by the time it comes, there would have been a reasoned order.
Please.
This is only to protect our interest.
Against both the daughters. Petitioner
Let us
and
see what the final interim order is going to be.
My lords, there is already a money which is also deposited in the bank, which she has received 11 lakhs rupees. We have no difficulty in paying the money.
Then
the
pay
reason
it.
is that why I'm insisting is that, my lord, she has been brainwashed by her sister's husband.
That we'll hear after she comes. If you want us to pass an order on interim order, rejecting it, we'll pass the order. You want us to reject it now? 4,000 rupees we won't.
Date may be fixed, my lord.
22nd September.
Date fixed.
AGA for response 19th.
Custody for 8 years.
19th.
For the petitioner, Your Honor.
Yes.
Seeking for the writ of mandamus and to direct the respondent to release the contractual amount of rupees 1 crore 5 lakhs, Your Honor. Your Honor, I had participated in a tender.
Where is Mr. Dodwad? And AGA for respond number 123. Vaishali Hegde for 4. Dodwad for 5. Petitioner is before this court seeking for the following reliefs. The petitioner claims that a work order having been issued to the petitioner in person with tender issued on 16/4/23. The petitioner has completed the work and raised his invoices, despite which payments not having been made. Petitioner had submitted his representation on. Where is your representation?
Your Honor, at page 364, Your Honor, 28/7.
28/7.
26.
26. Annexure number? What is the page number?
Page 364, Your Honor.
364. 28/7/26 at Annexure Q, despite which no action has been taken. It is in that background that the petitioner is before this court seeking for the opposite relief. Whenever any work is completed in pursuance of an agreement and or a work order, it is but required for the state as an employer to make payment of the due amounts thereon in terms of the contract and in terms of contractual agreements. The petitioner claiming that he has completed the work has been waiting for the last 2 years for the said payment. It was for the respondents to have either accepted the representation made by the petitioner or rejected it, in either case accompanied by reasons. Neither of them having been done, this court passes the following order. Writ petition is allowed, a mandamus is issued, directing the respondents to consider the representation of the petitioner dated 28/7/26 at Annexure Q series within a period of 4 weeks from the date of receipt of a copy of this order. It is made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be considered on the basis of the contractual agreements entered into between the parties and in accordance with law.
Your Honor, same matter, Your Honor, but in this case, there are 8 work orders total.
Good.
Pertaining to MP election, Your Honor, Lok Sabha election.
In none of them they have paid. AGA for respond number 1, 2, 3. Vaishali Hegde for 4. Dodwad for respond number. Vaishali Hegde for 4 and 5. Dodwad for respond number 6. Work orders.
At page
18/23, 25. One work order on 18/23. 4 work orders on 25/8/23. One work order, following work order, you don't care somebody table throw. Tender was issued as per the table. Work order was issued as per table, page 7. Where's your representation?
Representation is at page 88, Your Honor. Annexure G.
28/7/26 at Annexure G and H series.
Yes, sir.
Same order.
Much appreciated.
Yes. Yes, Mr. Manoj.
The case where the petitioner has been ordered to externment order, ordered to remove him from Srinivaspura Kolar police.
Were you served with the notice?
Jurisdiction to be there.
Were you served with the notice?
Yes, yes, yes.
You appeared before the authority?
Yes, yes.
Then you have to file an appeal.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ Lord, absolutely there is no material to invoke the extradition.
Don't make us the appellate authority. You have an appellate remedy available. Go there.
No,
59 appeal
absolutely.
remedy.
Section 60 comes to the aid of the petitioner. 60 of the Act comes to the aid of the petitioner.
Manor, you have a statutory appeal which is available.
59 provision is there to prefer an appeal.
Go
But
there.
when there is no substance and absolutely there is no material,
Don't make this court a appellate authority. All external matters are coming here at the drop of the hat.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, ಒಂದೇ ಒಂದು ಪೆಟ್ಟಿ ಅಫೆನ್ಸ್ ವೇರ್ ಐ ಹ್ಯಾವ್ ಬಿನ್ paid 300 rupees penalty. 300 rupees penalty. Apart from that, absolutely there is no material against me. No cases are pending against me.
We won't open the floodgates here for these matters. You can go there, address your argument. If you're not successful there, you can come here. If you're successful there, it stops there. And AG accepts notice for respond number 1 to 4. Petitioner is before this court seeking for the following reliefs. What is being challenged is the externment order passed under section 55 of the Karnataka Police Act 1963. A parallel of the order indicates that the petitioner has been served with the notice as also has appeared before the executive magistrate and made a submission which have been considered by the respond number 2, though to the detriment of the petitioner. If at all the petitioner, the notice having been issued, the petitioner having been heard, the principle of natural justice have not been violated. The petitioner has a statutory appeal in terms of section 59 of the Karnataka Police Act, reserving liberty to the petitioner to approach the appellate authority under section 59. The petition stands disposed. Respondents are directed not to take any coercive steps or execute the order dated 21/7/26 at Annexure A until the appeal is taken up for consideration.
Public.
This petition also Milad eternament. This petition also potential
Notice I
notice I the cause of
you heard also.
Only thing Milad my submit
And AGA for respond number 1 to 3.
similar circumstance annexure D C Milad.
Merits now considered Malad. If your natural justice has been violated, we will intervene. File the appeal and until consideration.
My lord, one submission. In this, the 30 days, it's not implemented. 30 days time has been given for him to file that.
Don't implement until it is considered. I1 of 26 is allowed. Yes, Rajendra.
My lords, the petitioner herein is Archak at a temple in Maravante. And the incidental to the Archakship is preparation, distribution of Panchakajaya Seva. That is his hereditary right, my lords. In fact, it is settled before this honorable court in RFA 1021 of 2007, where the committee and Archak family have entered into a compromise. Now they are obstructing. Sorry.
Not matching what you're saying. Page number?
Page number, my lords. Now RFA page number is at 50, my lords. Relevant, it's at 43. Relevant paragraph is 50, my lords.
Page number?
It starts at the first appeal order is at 43, Annexure D.
Yes.
Here, the petitioner as well as the committee and other members are all parties to the proceedings, and they entered into a compromise. And it has been recorded. And here, my lords, at page number 50, 7 paragraph 7.
Yes.
In view of the aforesaid reasons, the appellants and first respondents have entered into an understanding and filing this compromise petition to modify the judgment and decree of the trial court in the following manner. The post of Kilu Shanti Archakas, that is the petitioner's, he is performing that Kilu Shanti Archaka. To do all sevas attached to the Kilu Shanti Archaks in Maharaja Swami Shri Varaha Temple, Maravante village, Kundapur Taluk, including performing Panchakajaya Seva to be treated as hereditary right of the appellants. Now, my lords, this is done, and now nothing had transpired after this for 4 years. All of a sudden, my lords, in the month of March, they passed a resolution at Annexure A saying that you can only perform Naivedya and you cannot, other things you cannot do. For the first time, they are introducing this. In fact, my lords, Naivedya distribution and also selling are all part of the.
Madam.
Lordships may kindly prioritize their prayer. Annexure A and A1. It is passed by the Adhyaksharu Maharaja Swami Paradevasthana.
By fifth respondent. You are not the person.
My lord.
I made representation at Annexure G, G1 and G2 to the AC, DC and also Commissioner, my lords, on 20th July 2026. I have made representations. Nothing transpired. So I am before your lordships, my lords.
They have written to the
Respond number one in RFA was a party to the compromise?
Yes, yes. Government advocate
Where
was
is the
represent-
compromise petition?
Government is a party.
Where is the compromise? Who are the signatories?
Compromise petition is not
Compromise
ready.
petition is signatories, but they are parties to the RFA.
They may parties to the RFA. Who has agreed with you?
Fifth respondent committee has agreed.
Where is the compromise petition?
Compromise petition is at page numbers, my lords, 66.
66.
Please, my lords. 71, it starts from 71.
71. Illappa. Where is the actual compromise petition? This is who has signed it for whom illa illi. Appellant number 1C has signed it and respond number 1. There's nothing else which is shown. The typed copy, the proper one, actual compromise petition illa. Certified copy thondilva.
Certified copy thondidini.
They torsi certified copy. Who are the signatories to the compromise?
Not produced.
Because only they will be bound by it.
Your fifth respondent is a party because what happened, I gave representation.
We are not able to make out from here. If you show it to us, we can see who is the party. Then we can pass some interim order if they are signatory.
That is recorded in the judgment itself, my lord.
Judgmental has been filed and ashte.
Illi ಏನಾಗಿದೆ paragraph 40, page number 49, paragraph 5.
Appellant and respondent have filed a joint compromise with the document and same are received on record. Joint compromise reads as under. Who is the signatory to it?
Non-representation ಕೊಟ್ಟೆ representation resolution pass ಮಾಡಿದ್ರು fifth respondent ಅವರು.
ನಿಮ್ಮಲ್ಲಿ ಇಲ್ವಾ ಇವಾಗ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇದೆ ಸ್ವಾಮಿ annexure, that is page number 70, ಅದನ್ನೇ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲ, ಇಟ್ ಇಸ್ ಓನ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 who has signed ಅಂತಿದೆ ಅಲ್ಲಿ. The truncated document or the whole document ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನಮಗೆ. ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ತೋರಿಸಿದ್ರೆ
I'll produce relevant ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್.
ಪಾಸು ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ತರ್ಸ್ಕೊಂತೀನಿ ಸ್ವಾಮಿ.
ಮಧ್ಯಾಹ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ?
ಮಧ್ಯಾಹ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಪಾಸು.
On representation, my lord, they have answered, they have replied to the temple, my lord, to act in accordance with the.
But if the temple is a signatory, they'll have to comply with it.
Basically, notice has.
If
to
it is
go
only
down.
between the
Yes.
family members,
Please.
temple is not bound by it.
Please.
The temple is to recognize as hereditary, not among themselves. Adike temple is a party, nan keltare.
It's a party, fifth respondent committee.
If they have signed it, show it to us.
Please,
Pass
please.
Minutes. Seeking mandamus minutes against jurisdictional sub-registrar minute without insisting a Lebanese sketch minute to register a sale deed.
Is it a compromise or a
Minutes,
decree?
in this case, minutes, there is a decree. Minutes, Supreme Court minute up to Supreme. Minute, kindly see minutes, page number 111 minutes.
111.
111, para 25 is relevant. Merit minutes.
A specific performance.
Suit for specific performance. Minutes, in the suit minutes, there is a decree. First appeal filed minute, first appeal is dismissed. Second appeal is filed minute, second appeal is reversed the order passed by the both the courts minutes. Again, we filed a appeal before the Supreme Court. Supreme Court minute, set aside the second appeal order and confirm the decree minute. Minutes, page number 111 minute. May I read minute? Court suggested to give 1 lakh as additional sale consideration.
You'll have to register it. Give one sketch from.
Minutes. We applied it for money. We applied. There is a difficulty.
Sadhik, you give a license surveyor sketch so that it becomes part of your sale deed. The identification of the property will be a problem. Because you are 29 bar 2, 14 guntas.
Minutes. There are 7 items. Minutes. 7
ಅದಕ್ಕೇನಪ್ಪ ಇವಾಗ 29 ಅಲ್ಲೇ ಒಂದು 5 ಐಟಮ್ ಇದೆ.
Yes. We applied.
You identify the
We
problem.
applied it for minutes. We applied it for annexure H malad 142 page number.
If you have applied for it, then you'll have to go under KLR and get an order, not
No
here.
minutes. What has happened minutes? We filed an application before the executing court minute to direct the revenue authorities to prepare a revenue sketch minutes. The court dismissed my application minutes. Thereafter.
In which? In a writ petition or?
No minutes. In the executing court, court directed.
Executing court cannot direct.
But minutes, there is a judgment by this honorable court in a compromise decree minute without insistence.
That is fair enough. We'll order that.
Yes, ma'am.
But you are inviting more litigation.
Yes.
Get ready for more litigation because your property is not identified. That is a KLR jurisdiction, not our jurisdiction.
Possession is already delivered, my lord, under the agreement itself.
And AGA accepts notice for respond number 1, 2. For the petitioner is aggrieved by the demand made by the respondent for furnishing of a 11E sketch for the purpose of registration of a sale deed in terms of a decree, judgment decree passed in OS number 18 of 1996 by the Civil Judge Senior Division JMFC Unsur on 30/8/2000, confirmed by the First Appellate Court in RA number 54 of 2000 and affirmed by the Honorable Supreme Court of India in Civil Appeal number 1402 of 2024, void its order date 31/24, except for a direction to make payment of an additional amount of rupees 1,00,000,000.
Same has been deposited.
This court has, in a catena of decision, held that when a sale deed is presented in terms of a decree passed by the court, there won't be a requirement of furnishing a 11E sketch. Such being the situation, the respondent number 4 could not have in the sketch. Though learned AGA submits that the requirement of furnishing 11A sketch is for the purpose of identification of the property to avoid future litigation. That aspect is left to the discretion of the petitioner. Hence, this court passes the following order. Writ petition is allowed. A mandamus is issued directing respondent number 4 to register sale deed as prepared by the executing court and made available for registration without insisting for 11 is made clear that the registration of the sale deed shall not in any manner amount to verification or identification of boundaries. That is at the sole risk of the petitioner.
The information of the court, with the kind permission, submit this. But what has happened is now the survey department has come up with a scheme called as a Swavalambi scheme. It's something like a self-declaration where the party himself can declare the boundaries of the property.
It won't help.
But what has happened is now the government has mulled an idea where the retired surveyors and other licensed surveyors are called as survey assistants. My lord. So these survey assistants can assist the person. He can file an application himself, the self-declaration, which will be verified with the department.
We do the self-declaration, but we get
And I agree.
from the, if it goes, this one goes out of this door, we'll get 100 from this door. Because either 7 numbers.
To resolve this 11E sketch issue, my lord,
You should move the matter and finish that matter. This is just adding to litigation.
That matter, my lord, that's the Swavalambi thing, my lord. One of the matters, my lord, I will place it before the court.
ಇನ್ನೊಂದು ರಿಲೀಸ್ ಮಾಡಿದ್ರಲ್ಲಪ್ಪ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಏಕ ವ್ಯಕ್ತಿ ಪೋಡಿ ಅದ್ರಲ್ಲೂ ಸೆಲ್ಫ್ ಡಿಕ್ಲರೇಷನ್
ಅದಕ್ಕೆ ಸದ್ಯಕ್ಕೆ ಸ್ಟಾಪ್ ಮಾಡಿ
ಅವ್ರು ಹೋಗ್ಬಿಟ್ಟು ಸರ್ವೆ ನಂಬರ್ 100 ನನ್ 4 ಗುಂಟೆ ಅದು ಸರ್ವೆ ನಂಬರ್ 100 is 100 acres 4 ಗುಂಟೆ ಇಲ್ಲಿದೆ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿ ಕೊಡೋದು.
as of now they have stopped it.
ಅದು ಫುಲ್ 100 ಅಲ್ಲಿ 100 ಜನನು ಒಂದು 100 litigation.
Single window podi.
All that is, it doesn't help. You'll have to verify what is the location.
The physical inspection, notice to the neighbors and all.
In fact, if you look at the ಇದೇ ಬೇಕಾದ್ರೆ ತೋರಿಸ್ತೀನಿ. ಆಸ್ ಎ ಇದು ಲಾಯರ್ ಆಗಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡುವಾಗ each sale deed had a sketch, survey sketch which was there. The survey sketch was drawn on cloth, not on paper.
Yes, sir, cloth. Mostly in that North Karnataka, your lordship was sat in Kalburgi bench. Most of the records and
No,
surveys are
Bengaluru
in the
alone, no.
muslin, it's on a muslin cloth.
Muslin in Bangalore cantonment area, everything was on
Muslin cloth.
the cloth with a indelible ink. It would never tear, nothing would happen. Some of the vendors or the purchasers would keep a copy. It was a little expensive. Otherwise, it was only with the sub-registrar's office. That it was on a cloth which would not tear, which would not.
But this issue requires to be dealt with. 11 is sketch. Appropriate proceedings are required.
MG Road and all was the lot of litigation which got sorted out because of that sketch. Otherwise, it could never have got sorted out. Come back.
Actually, ನೀವು ಓದಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಕೇಂದ್ರ ಬಿಸಿನೇ ಜೆರಾಕ್ಸ್ ತಗೋಬೇಕಾಗಿತ್ತು ನಮಗೆ ಅದನ್ನೇ ಕರೆಕ್ಟ್ ಮಾಡಿ ಹಾಕಿದ್ದೆ. ಅದೊಂದು ಜೆರಾಕ್ಸ್ ತಗೊಂಡಿಲ್ವಾ ನಾನು ಕೊಟ್ಟಿದ್ದ ಕಾಪಿನ? ಇಲ್ಲ, ಇದು ಕೈಯಿಂದ ಬರ್ದಿದ್ದಿದೆ. ಅಮೆಂಡ್ ಅಲ್ಲಲ್ಲ, ಇದು ನಾನು ಫ್ರೆಶ್ ಕಾಪಿ ತಂದ್ಕೊಟ್ನ ನಿಮಗೆ. ಫ್ರೆಶ್ ಕಾಪಿ ಕೊಟ್ನ ಇದು. ಐ ಗೇವ್ ಯು ದಿಸ್ ಫ್ರೆಶ್ ಕಾಪಿ ಪ್ರಿಂಟ್. ಅದನ್ನ ಹಾಕಿದ್ದೆ ತಾನೆ. ಇದು ನನ್ನ ಹಳೇದಿದೆ, ಅದನ್ನೇ ಕೈಯಲ್ಲಿ ಬರ್ತದೆ. ಅದ್ರ ಸ್ವಲ್ಪ ಅದು ಜೆರಾಕ್ಸ್ ಎಲ್ಲ ಮಾಡಿಸ್ಬೇಕಾಗುತ್ತೆ. ಇದು ಒಂದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಏನು ಹಾಕಿಲ್ಲ ಅದನ್ನ. ಜೆರಾಕ್ಸ್ ಇದು See, ನನ್ನ ಸ್ಯಾಲ್ರಿಗೆ ಐ ಗೇವ್ ಯು ನ್ಯೂ ಕಾಪಿ. ಅದು ಕೋರ್ಟಿಗೆ ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀರಿ. ಕೋರ್ಟಿಗೆ ಹಾಕಿದ್ದೀರಲ್ಲ ಫ್ರೆಶ್ ಕಾಪಿ. ಅಲ್ಲ, ಲಾಸ್ಟಲ್ಲಿ ಏನು ಇದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಲ್ಲ? ಅಲ್ಲ, ಅಲ್ಲಿ ನೀವು ನೆಕ್ಸ್ಟ್ ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ನ ನೀವು ಇದು ಮಾಡಿದ್ದೀರ ಕೈಯಿಂದ ಬರೀತೀರಿ.
Limitation disposed.
petition came to be filed, claim petition came to be filed by the wife and children of the deceased.
Limitation period.
Although ESI
ಇಲ್ಲ,
Act,
ಇದು ECA.
under the ESI Act, Your Lordship, they have to file within 2 years from the date of offence as per section 10(1), Your Lordship. The present claim petition has been filed after 5 years without any documents, Your Lordship. Though the claimant wife has filed an affidavit along with the condemnation of delay
Issue
application.
notice to the respondents returnable by 23rd September. The further proceeding in ECA number 158 of 25 pending on the file of the MACT SCCH3 at Bangalore. The state till the next date of hearing. Process fee and copies to be furnished by end of day 13th August, failing which the interim order will stand automatically vacated.
Lordships, petition by the claimants, my lord. Lordships may kindly see page 9, my lord. This is the claim petition, my lord, filed by the
Yes.
claim petition, my lord, is filed by the wife, minor children, and mother of the deceased, my lord, on account of death of Chandrappa, who died in road accident, my lord.
Yes.
My lord, if my lords may kindly see annexure B, which is at page 15, my lord. My lord, there is a note in the cause title, my lord, why I have not made the other claimants party, my lord. Claimant number 3 and 4, my lord, in page 9, they had filed application, my lord, for release of fixed deposit amount, my lord. As such, my lord, I have not made the other claimants as party to the present petition, my lord. Now, my lords may kindly peruse page 15 is the order passed by the tribunal, my lord. Relevant portion, my lord, at page 27, 7,71,500 was awarded, my lord. In that, my lord, since petitioner number 2 and 4 who were minor, my lord, the tribunal, my lord, ordered for the entire amount to be kept in a nationalized bank until they attain majority and reinvest further for 5 years, my lord.
The apportionment was 15%.
Please, my lord, apportionment was
15%.
Please, my lord, to the minor children.
Yes.
Being aggrieved by this, my lord, appeal was preferred in page 29, my lord. My lord, this court, my lord, enhanced the compensation, my lord. 4,47,500 was enhanced. If my lords may kindly see page 43.
Yes.
Page 42, last paragraph,
For
my
the
lord.
interest till they attain 21 years. Yes.
Page 42, my lord, last paragraph. A sum of 75,000 with proportionate interest shall be invested in a fixed deposit in the name of each of the appellant 2, 3, and 4 in any nationalized or scheduled or Grameen bank till they attain 30 years. Now, my lord, the claimant number 3 and 4, my lord, they filed application, my lord, under 151 for release of the fixed deposit, my lord, which is at page number 45.
What is their age now?
Now, my lord, they are 20, my lord.
20.
Please, my lord.
But till they attain the age of 30 years.
My lord, tribunal, my lord, at page number 51, 59, my lord, had ordered for premature release in other minor, my lord, who had not attained majority. If my lords may kindly see page 59. Lord, this is for their marriage purpose, my lord.
I understand, but there is a specific
Page 49, 59
in
may
the
kindly be
MACT
perused.
appeal, there is specific direction that till they attain 30 years, it will be, and they will be entitled only for interest once they attain 21 years.
Page 57, my lord.
ಇದರಲ್ಲಿ modification ಕೇಳಬೇಕು, writ petition ಮಾಡಕ್ಕಾಗಲ್ಲ. There is a judgment passed by.
Tribunal had earlier released in favor of other.
Maybe, but here you have an order passed in MFA number 10171. Any order passed.
Amount is meager.
It may be. It would amount to modification of that order.
For a moment, if my lords may kindly see page 57.
File an application in that matter and it will be done.
That bench is.
Royal Sundaram Mayor.
Pradeep, my lord.
Pradeep, for respond number 3, notice to respond number 1 and 2 is dispensed with in view of the proposed order to be passed. Petitioners are before this court seeking for the following reliefs. The petitioners
Dispensation.
father filed along with the mother and other siblings in MVC number 1043 of 2012, which came to be awarded in favor of the claimants. However, the claimants, being aggrieved by the quantum of compensation awarded, had approached this court, where the compensation was enhanced 2015. The petitioner had made an application for release of the money, which came to be rejected by the impugned order on the ground that in MFA number so and so, there was a direction that the deposit has to be made in a nationalized or a scheduled or Gramina bank
Please, no.
till they attain 30 years. It is challenging the said order, the petitioner is before this court. There can be no infirmity found in the said order passed by the MACT, inasmuch as it is the direction issued by this court in MFA number 10171 of 2013, which was being implemented. If at all, though the learned counsel for the petitioner submit that the monies are required for the purpose of marriage of the petitioners, and there is a good ground for release of at least a part of the amount.
Marriage is already performed, application at that time to repay the said amount.
The marriage having been performed by taking loans, the said amount is required to discharge the loans. The relief which have been sought for by the petitioner cannot be granted in the present writ petition. A modification reserving liberty to the petitioner to file necessary application for modification in MFA number 10171 of 2013, the petition stands disposed.
Okay.
19 ಮತ್ತೆ ಯಾರು ಲಿಮಿಟೇಷನ್ ಲಿಮಿಟೇಷನ್ ಅಲ್ವಾ?
Apologize, Your Lordship.
Huh.
That is not a case of limitation. That is not a case of limitation.
6 Rule 70.
Please, Your Lordship. My Lord, that stage when the matter was posted for arguments, Your Lordship, claimants filed application for amend the claim petition.
What is the
ಮಾಡ್ಲಿಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತಾರೆ ಅದನ್ನ ಟ್ರಿಬ್ಯುನಲ್ ಫಸ್ಟ್ ಟೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ ಸರ್.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್
ಅಟ್ ಅನೆಕ್ಸರ್
page 38.
ಪ್ಲೀಸ್ ಇಲ್ಲ
ಎಂಟೈರ್ ನಂಬರ್
ಅಗೇನ್ ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಮೇಲೆ ಮತ್ತೊಂದು ಐ ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ, ಅವಾಗ ಅಲೋ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಟೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದನ್ನೇ ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಸೇಮ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ಅಲೋ ಮಾಡ್ತಾರೆ.
15L7245 by 20EF85. Issue notice to the respondents returnable by 23rd September. The further proceedings in MVC number 1179 of 2019 pending on the file of the senior civil judge and additional MACT Kundapura is stayed till the next date of hearing, considering that the entire details of the offending vehicle are sought to be amended stroke substituted by way of the amendment application. Process fee and copies to be furnished by end of day 13th August, failing which the interim order will stand automatically vacated.
Much sir.
Yes, Mr. Manjunath.
My Lord, in this case, the government notification has come. Government notification has come with respect to the qualification of inspectors.
They issued a new notification.
I think they're referring to the central government.
The draft was produced at the time of filing the writ petition. It was not yet approved. In fact, at page 31.
Yes.
The matter can be straightaway taken to objections of the respondents. Paragraph 16, my lord. I'll just draw my.
Let's if, I just point out. Let's earlier they had relied upon a draft rules in terms of the Drugs and Cosmetics Act. Notes as per the qualifications of the inspectors, we had posted the inspectors. Affidavit is also filed as on the law, as was prevailing as on that day. They had relied upon a draft notification of the central government to say that no, the persons who as qualified in the draft should be posted. But this honorable court did not agree for that, my lords. And now, my lords, they are saying that the draft has been finalized and the notification has been issued. So we'll have to, I'll just take instructions on this and come back.
So you'll have to act as per this now.
We have to act, this is a law, my lords, because the central regime is what Drugs and Cosmetics. I'll just take instructions on this.
So when was this notification published?
Maybe they've already implemented it on 24th July
2026.
And they would have communicated it, my lords, to the, we'll just take instructions on this.
In fact, para 16 of the objections, my lord.
That was before the amendment.
Learned AGA, sorry, Learned Counsel for the petitioner has filed a memo enclosing a notification dated 24 July 26. On the basis of said notification is submitted that now the qualifications have been approved by the, which department?
Ayush department. Ayush.
By
Qualification has been changed, it's not a
Government of India, Ministry of Ayush.
Ayush.
And it is this qualification which would be applicable for all the post subject matter of the above writ petition. Shri Ruben Jacob, Learned Additional Advocate General, would seek for a week's time to obtain instructions as regard the implementation thereof, as to whether it's already been implemented. If not, by when the said notification would be implemented.
Please.
Released on?
Let's give us 15 days.
Released on 24th at 2:30 p.m.
Please, Mr.
We'll just record your submission.
Please, Mr.
Much.
There's no
interim order granted on 23/8/25 ಅಂತಿದೆ.
No, interim order was specifically rejected.
They were granted on 23/8.
Oh, there is a direction to file affidavit.
But interim order was rejected on that.
The note on the
After considering the contentions,
interim order. Released on notes.
Grateful.
He has approached the bank, my lord, for financial help, my lord. The bank is now taken order under section 14, contrary to the sale deed, contrary to the measurement, my lord. They are directing me to get a modification of the order from the magistrate with regard to the measurement of the property, my lord.
How do you ask for a mandamus for this? You are asking for a modification of the order in criminal misdemeanor number 7204.
I am permitted to approach the magistrate court for getting necessary orders.
Modify ಮಾಡಕ್ಕಾಗತ್ತೆ.
ಅಲ್ಲ ಹೌದು ಹೌದು. That's what. I am permitted to approach the Reverend Magistrate for correcting the order dated.
Punjab National Bank. Francis Xavier for respond number 5. Notice to respond number 6 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the petitioner having sold a portion of the property belonging to them to respond number 6, respond number 6 having availed a loan from respond number 5, the property which has not been sold by petitioner to respond number 6 is also sought to be taken possession of under section 14 of the Surface Act in terms of the order dated 1/6/26 and criminal misdemeanor number 7204 of 23. The submission of Learned Counsel for the petitioner is that this aspect having been brought to the notice of respond number 1 to 4 police authorities, they have not taken any action but are seeking to implement the order dated 1/6/26 and criminal misdemeanor number 7204 of 23. When an order has been passed by a court, it is required for all to implement the said order. The jurisdictional police, in this case respond number 1 to 4, cannot seek to override the orders and or substitute the order on the basis of a representation submitted by the petitioner. If the petitioner were to be aggrieved by the order dated 1/6/26, it is always available to the petitioner to avail of,
I may permitted to approach the competent court for modification of the order in accordance.
avail of such remedies as may be available, including seeking for modification of the order, reserving liberty to the petitioner. Such modification ಬರುತ್ತೆ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ.
Correction of
such available remedies as are permissible under law, reserving such liberty, petition stands disposed.
Please, ma'am. My lord, instead of that, my lord, I may be permitted to withdraw the writ petition
Yeah.
with liberty to approach the magistrate, my lord.
We have passed the order.
Please, my lord.
My lord, 1 week time may be given for filing objection, my lord. It's with regard to the procurement of the fire rescue.
Interim order is there. Now, the AGA seeks fund is granted a week's time to file a statement of objections. Released on 27th August, interim order earlier granted is extended till next year. Anyway.
Seek your lordship's kind permission to address, my lord.
AD.
That's where advocate who's discharging his duty as an advocate. We are also expressed our apprehension that one of the opposite client who have been dealt with this crime also. We also complained to the jurisdictional police as well as to the commissioner. So when we ourselves personally approached the commissioner, there was a protection.
Lord, the investigation is under process, my lord. FIR was registered on 10/7/2026, my lord.
Yes.
Till date, my lord, they have recovered, checked the CCTV footages. They have given a checklist of what they have done. They need another 3 weeks to complete the
CCTV
investigation.
footage is secured,
Please, my lord, they have secured.
available with you.
Please, my lord. CDR and analysis is done, my lord. Tower dump analysis also is done, my lord.
CCTV, CDR and
Tower dump analysis, my lord.
tower dump and
And they have
CDR.
recorded statement of 7 suspects.
But yeah,
They have also provided gunmen, my lord.
the gunman who was provided, it appears these persons are from outside Karnataka, my lord. The persons who chased him that day. There is a video also where they have chased him with these weapons, weapons to kill him, virtually. The person, then we spoke to the DCP, they provided the gunman protection. He writ ಹಾಕಿದ ತಕ್ಷಣ they withdrawn the gunman. DCP ಗೊತ್ತಿರಲ್ಲ.
ನೈಟ್ ಅವರಿಗೆ ನೈಟ್ ಬಿಟ್ ಸಿಸ್ಟಮ್ ಮಾಡಿ ಸರ್ ಪರ್ಮನೆಂಟ್ ಆಗಿ ಅವ್ರ ಮನೆ ಹತ್ರ ರಾತ್ರಿ 2 ಸಿಬ್ಬಂದಿ ಡ್ಯೂಟಿ ಹಾಕಿದೀವಿ ಸ್ಪೆಷಲ್ ವೈಸರ ರೌಂಡ್ಸ್ ಹಾಕಿದೀವಿ ಸರ್ ಇದರಲ್ಲಿ ನಾವು ವೈಫೈ ಕಾಲ್ಸ್ ಸ್ವಲ್ಪ ಪೆಂಡಿಂಗ್ ಇದೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀವಿ
ಅಲ್ಲ till they apprehend them.
Now you will do completed in 3 weeks.
Please, my lord.
Till they apprehend, Lord, at least a gunman provide ಮಾಡಿರೋ gunman because I'm living in
already
fear.
recorded the statements of those 7 suspects.
ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ, but the assailants have not been nabbed still. Those persons ಯಾರು assailants ಇದ್ದಾರೆ main.
ಆಮೇಲೆ ಯಾರು ಏನ್ ಮಾಡ್ತಾರೆ?
ಕೊಟ್ಟಿರೋ gunman writ ಹಾಕಿದಕ್ಕೆ ತೆಗೆದುಬಿಟ್ರು ಅಂತಂದ್ರೆ it is exactly coincidental on that date.
ತೆಗೆದ್ರೆ
ನೈಟ್ ಬಿಟ್ ಸಿಸ್ಟಮ್ ಮಾಡಿದೀವಿ ಸರ್ ಅವ್ರ ಮನೆ ಹತ್ರನೇ ಸ್ಪೆಷಲ್ ನೈಟ್ ಬಿಟ್ ಸಿಸ್ಟಮ್ ಇಬ್ಬರು ಪೊಲೀಸ್ ಡೈಲಿ ಡ್ಯೂಟಿ
ಏನಾನ ಆದ್ರೆ ನೈಟ್ ಬಿಟ್
ಇವಾಗ ಅರೆಸ್ಟ್ ಮಾಡಿದೀರಾ ಇವ್ರನ್ನ?
ಯಾವ್ದು ಅರೆಸ್ಟ್ ಇಲ್ಲ ಸರ್
ಅರೆಸ್ಟ್ ಮಾಡೋವರೆಗೂ ಕೊಡಿ, ಅರೆಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ
ಎಸ್
ರೈಟ್
and AGA submit that the CCTV footage has been secured and stored
Please, my lord.
for the purpose of investigation. So also call detail records have been secured and tower dump analysis has been made.
Please, my lord.
As also the statements of 7 suspects have been recorded.
Please, my lord.
A submission on instruction of the investigating officer is that the investigation will be completed within 3 weeks' time. Since the accused have not been arrested and they are still at large, there being a danger to the life and liberty of the petitioner, the respondents are directed to provide adequate security
Please.
to the petitioner. The submission made that there is a night beat patrol which has been given effect to, and there are police beat constables
Please.
who call upon the house of the petitioner and the office also. Office go why do you want police to come to your house and office?
ಮನೆ ಆಫೀಸ್ ಒಂದೇ, 7 kilometers ದೂರ ಇದೆ ಮನೆ ಆಫೀಸ್, ಹೌಸ್ ಅಂಡ್ ಆಫೀಸ್ 7 kilometers apart.
ಆಯ್ತು, ಅಲ್ಲಿಗೆ ಯಾಕೆ why do you want them to come?
ಅಲ್ಲ ಸೆಕ್ಯೂರಿಟಿ ಕೊಟ್ರೆ ಅದನ್ನ beat
My instructions are that, my lord, as such, there was no attempt of any assault. They have only chased the petition.
Why would anybody chase, madam?
No, my lord, among the, apart from petitioner, my lord, there was one person named Madhu. It appears, my lord, he had secured loan and not repaid. Maybe that might be the motive for the
if I'm
chase.
representing him, ಅಲ್ಲಿಗೆ ಮಿಸ್ ಆದ್ರೆ there is no case ಅಂತ ಹೇಳ್ದಂಗೆ ಆಯ್ತು.
Mr. Reddy, you will not as appearing in this matter, but in your other capacity, you will have to take it up because there are quite a few matters coming up before this court also.
Where they
has clearly observed there are some 40 matters about advocates' involvement there. They have in fact, the court has directed there to secure details of all matters where advocates are accused.
Chennai.
Madras have ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲೂನು this must be the 7th or 8th matter which is coming up.
ಅಲ್ಲ, ಇಲ್ಲಿ he represented one ಮಧು. ನೀನ್ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೆ? ಹಿಂದಿನ ದಿನ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರು. ಯಾಕೆ? Because he appeared for.
We can give you all the stories which come before us. You need to probably
sorry. Apart from this case,
educate the lawyers to be careful as
restrained
to
and
who they have to. In one matter, we had the lawyer who introduced a person who gave them a loan on the basis of the land being given on mortgage, and that loan was used to make payment of the fees to the lawyer.
Oh, such things we will never.
And thereafter, the lawyer did not appear in the matter or something, so they started asking for the refund of the money. The property was sold by the mortgagee.
Lord, we will not support. In fact, anta instance namak sikkidre, we will notify members.
Nobility and the reputation of the profession
Yes,
has to be
yes.
maintained. It's all in all your hands only.
ಇಲ್ಲ, ನನಗೆ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಡಿ. We'll notify the members. ಈ ತರ ನಡೀತಾ ಇದೆ ಅಂತ.
Adradu anta don't make it an example of that. Guide youngsters especially.
Nurturing.
Many of them are in a big hurry.
Big hurry. Correct.
Everything is not McDonald fast
To
food.
have flashy cars.
Inna nam Janardana Dose hotel. So it has to be done in the proper manner. You will have to guide them. You are the leaders of the bar. Released on 25th August. ಅದು ಹೇಳಿದ್ವಲ್ಲ. Hmm. 26. Yes. Yes. Where's the application?
They filed an application.
IA 1 of 26 has been filed to implead who are these two? In which matter? The IA number 1 of 26 has been filed to implead two societies as party petitioners. The first of them is stated to be appellant in cooperative appeal 21 of 24, and the second of them is stated to be respondent in cooperative appeal number 126 of 25. Accepting the reasons stated in support of the said application, being of the considered opinion that there's no conflict of interest in the existing petitioners with that of the proposed petitioners, and that the proposed petitioners are being represented before the Karnataka Appellate Tribunal by the petitioners. The said application in IA 1 of 26 is allowed counsel for the petitioner to carry out necessary amendment and file amended cause title. They're directed to make payment if they're directed to make payment of court fee, applicable court fee if not already paid. Considering that there is no reference made by a bench to refer the particular matters to a full bench, and the appeals as detailed at Annexure D have been referred to the full bench without such reference by the chairperson, without there being a reference made by the bench seized of the matter. The operation of Annexure D is stayed till the next date of hearing.
Please.
Process fee and copies to be learned. AGA accepts notice for respond number. ಆಗಿದೆಯಾ ನೆನ್ನೆ ಅದು?
Matter is,
you will be for state of Karnataka. What about the tribunal? The AGA for respond number 1, issue notice to respond number 2 and 3, written out by 22nd September.
Direction is necessary. Let him communicate the order to the registrar.
This will be uploaded. You can go and give the order copy.
ಅದು 4 o'clock ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಇವತ್ತು
ಇವತ್ತು 4 ಗಂಟೆಗೆ ಇಟ್ಟಿದ್ದಾರೆ.
ಒಂದು ಕೇಸ್.
And AGA is directed to inform respond number 2 and 3 about the above order.
But we are facing some difficulty with this chairman because at the time of admission itself he dismisses matters. ಇದು ಒಂದು.
ಇಲ್ಲಿಗೆ ಬರಲ್ಲ.
ಇನ್ನೊಂದು ಗೊತ್ತಾಯ್ತು. ಇನ್ನೊಂದು ಏನಂತಂದ್ರೆ bulk of matters he posts like this as question of law without there being a question of law, and then he offhandedly disposes of. We are facing a lot of difficulty with this.
They are closing it down.
ಅಲ್ಲ ಅದು ಇದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಇದನ್ನು ಮಾಡ್ತಾ ಇದಾರೆ, ಇದನ್ನು ಮಾಡ್ತಾರೆ.
ಇದು ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ, ಎಲ್ಲ ಟ್ರೈಬ್ಯುನಲ್ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ. ಅದನ್ನೆಲ್ಲ ಇಲ್ಲಿಗೆ ತರ್ತಾರಂತೆ. RFS
ಅಲ್ಲ, ಒಂದ್ 8,000 RFA ಹೋಯ್ತು, 2 ಕೋಟಿಂದ 8,000 ಬರುತ್ತೆ.
8,000 ಹೋಗಿ 1 ಲಕ್ಷ ತಗೊಂಡ್ ಬರ್ತಾರೆ.
1 ಲಕ್ಷ ತಗೊಂಡ್ಬರ್ತಾರೆ. ಪ್ಲೀಸ್.
Yes. Name of the organizers of ready my lord.
Where is Banu Prakash?
Pass on already. Pass on.
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಇಲ್ಲ, ready.
ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Along with the memo.
ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ನೋಡ್ಬಿಡಿ ಅವ್ರು.
Furnish. List of organizers. List of organizers. The office copy ಇದೆ? ಇಲ್ಲ, ಇದೆ. Register in the connected matter.
One is of 24, the other is of 25.
WP 815 is filed by the company, my lords, where allegedly there are some,
So which one has to be taken first?
815.
They can be taken up together, my lord. 815 can be
We
started.
can't open both the files together.
We can start, my lord.
Yes, so you will start.
Please, my lords.
Plus both of them taken up to, whole list will take it up.
This is
Yes.
not included. Lord, there was some unfortunate incident, my lords. While cleaning, my lords, clarified.
Amended memorandum, yes.
Clarified water tank, my lords. And when tank was being cleaned, my lords, they were using submersible pumps, my lords. After cleaning was over, all the water was pumped out. Pump was stuck, my lords, inside the tank. 2 of the workmen, my lords, went inside to check, my lords, that tank, what is the status of the tank, why it has stopped working. Then, my lords, they died in the tank. They were removed outside. Immediately, my lords, an FIR were registered under, my lords, prohibition of employment as manual scavenging.
There's a textile company.
Please, please.
Post before a bench of which SGRJ is not a part. Can't tell.
Interim order arrest.
Interim order earlier granted is extended till next date.
Unfortunate thing, my lord, is the compensation has still not been paid.
No, no, 10 lakh, my lords, on the first day itself, my lord, we have paid 10 lakh rupees.
We can't say anything.
Please, my lord.
And we filed IA to release that amount also, my lord. Not that we are coming in the way of.
Next.
I appear for petition. Previous state, my lord. This honorable court direction to ADLR for report, my survey report.
This is at IOCL.
I apply for the respondent.
Where is the survey?
For respondent number 4, your lordship.
That's in the
Jaffer?
Government.
reports,
Survey.
sir. ADLR reports.
ADLR.
Report was to be submitted by 8/7/26.
How?
Cell number 29, AGA ಹೆಸರಿದೆ. Password, just verify.
Please.
Copy ಕೊಟ್ಟಿದಾರ ಬಂದಿಲ್ಲ.
No.
Password. Mr. Jayadeva?
R2 and R5.
You are appearing for?
R2 and R5.
2 and 5. You are Zamir Pasha.
Zamir Pasha.
See, Zamir Pasha and where is Mr. Paso?
But in order to confirm whether there is encroachment on the plot allotted to the petitioner, my lord,
yes,
direction was given to ADLR to have inspection, my lord, of the plot. And I'm told that reports have come.
Where is the report, madam?
The print.
ಸರಿ ಏನು ಮಾಡೋದು ಏನೋ ಸ್ವಲ್ಪ ಒಂದು 2-3 ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ ಬಟ್ ಏನು ಮೆಜಾರಿಟಿ ಇಲ್ಲ ಬರುತ್ತೆ.
You given them the copy now?
Yes, no, my lord, we have taken the print also.
You have got it.
They participated in this.
So they knew about it then.
ನಮ್ಮ ಅಫಿಷಿಯಲ್ಸ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಸರ್ ಮಹಾಸರಲ್ಲಿ ಬಟ್ ಓನ್ಲಿ ಮಲಾಡ್
ಹೆಸರು ಕೊಡಿ, disciplinary proceedings initiate ಮಾಡೋಣ. If they are not participated, they are not participated.
Not disputing it.
We have said if you make that issue,
Yeah,
disciplinary
report is
proceedings.
ready, my lord. We have to, my lord.
There is encroachment, 3 encroachment.
Clearly, my
Lord, one encroachment is, my lord, that is, my lord, the house. But, my lord, 2, my lord, the only sheds, sir. Not
Remove
even
them.
Lord, that those sheds, my lord, after, my lord, the possession was handed over, my lord, that.
Show us the photographs of the, when you handed it over, that this was not there. We are getting enough and more number of matters of KIDB where everybody claims nothing is there, no road is there, no water is there, encroachment is there, the old farmer is still
This is not
sitting
such
the
case, my
land.
lord, but absolutely, this is not such case.
Everything. ನೀವು ಇರೋದ್ ಬರೋದೆಲ್ಲ ಇದೆ.
In fact, the photographs clearly says that there are permanent structures that has come up.
And look at the, ನೋಡಿ photographs. Last time ನೋಡಿದ್ರೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ನೋಡಿ, ನಾನು ನೋಡಿ.
ಎಷ್ಟು ವರ್ಷ ಇರ್ಬೋದು ಅದು? ಒಂದು 30-40 ವರ್ಷ ಹಳೆ ಬಿಲ್ಡಿಂಗ್.
ಆಶ್ರಯ ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ ಏನಾಗಿದೆ, ದೇಸ್ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಆಫ್ 8 acres. ಅವರು ಸ್ವಲ್ಪ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿ ಈ ಜಾಗದಲ್ಲಿ ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಕಟ್ಟಿ.
ನೀವು ತೆಗೀರಿ ಅದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್. You are KIDB, all powerful.
Instead of removing the encroachment, they have cancelled me allotment.
Lord,
despite me telling that I am ready to pay the difference of cost which has been awarded 100%, Lord, 1,000 times.
Lord,
We'll ask you to give him a plot here in Bangalore.
ಬೇರೆ ಪ್ಲಾಟ್ ಅವೈಲಬಲ್ ಇಲ್ಲ ಸುಮ್ಮನೆ ಅಲ್ಲಿ.
Discharge your duties properly. Why do you put people into trouble?
Like, that is the case, Lord. Lord will refund with interest. If that is the case, Lord will refund with interest, Lord. That we can, Lord.
Then we'll direct a plot in Bangalore. If you can be unreasonable, we can also be unreasonable.
Not premium inna kattilla sir. Full cost is not paid full.
I am sorry, my lords. 1,50,000 was the allotment amount. I paid 1,48,000.
If you want to argue, please argue. In these facts, if you want to argue, it's a wrong choice.
Premium katbekala sir. At least this.
Argue, madam.
But I am ready to
If
pay
that
that.
is- Argue with him.
Aye, sir. Next week.
The report has been filed by the ADLA, which categorically indicates that there are 3 encroachments in the plot allotted to the petitioner. Faced with the above situation,
More, my lord, submission, my lord, that is, my lord, left to the court, my lord. As per the report, this, my lord, encroachment of, my lord, not more than 3,000 square feet. Lord, excluding that, my lord, he can, my lord, ultimately, my lord, this 1 acre of land we have given.
This is
Lord,
an
the entire
industry
extent, my lord, will not utilize, will not construct building. As per the, my lord, the.
do one thing. The Rashtrotana building on Rupatunga Road, there's a building. Use half of that floor. for your industry. You use half of that building.
Next.
Look at the location.
Yes, my lord.
How do you do this?
Now
Three
there-
different places.
There is a demand for 11,90,000 additional cost, my lord. Even
That-
that I
that-
have expressed, I am ready to make the payment. Please
That
remove
will
the
come.
encroachment.
Now, what do you want to do? You want to remove the encroachment or you want to
That
give a
I'll get
fresh?
instructions.
6 point is granted a week's time to obtain instruction, make a submission as to when the encroachments would be removed and or a new alternate site allotment would be made to the petitioner of similar dimensions of the property. Released on 20th at 2:30 PM.
Acknowledgements.
Kindly record the editor report as well.
We have recorded that.
Acknowledgements.
We have recorded that three, that is why he has to say. It's Mamata, Passover, ಯಾರಿಗೆ? 32.
32 pass.
Passover.
In this case, a patrol bunk, my lord, which is established within a radius of 300 meters, my lord. They have given NOC to this person, but on the very same road, my lord, they have declined to issue this thing. And also it is next. Please.
Report ಬರ್ಲಿ. Copy ಬಂತಾ ನಿಮ್ಗೆ?
Just received it myself. Court says, my lord, that this 300 meters can be relaxed if, my lord, a service road is constructed in front of a in front of a petrol bunk. There should be a 7-meter gap. That is sufficient. Now, my lord, these petrol bunks are opposite each other. Proposed to be constructed opposite each other. If your lordship sees page number 2, is the sketch.
Yes.
The one on the left side, my lord, is the proposed bunk. Right is the petitioner's bunk. They are not at 300 meters distance. About 200 meters is, my lord, the distance that is there. Now, my lord, at page 4, my lord, point
Yes.
number 6. Says, my lord, distance between two fuel stations, undivided carriageway, that is, my lord, if there is a divider. If there is no divider, my lord, 300 meters. If there is a divider, my lord, 1,000 meters. Including deceleration and acceleration lanes. However, the restrictions shall not apply in case access ingress for all such fuel stations for provided through common service road of 7 meters width and not directly to NH. Further, access to fuel stations at close proximity than above distance may be allowed, provided that entry and exit of both fuel stations are provided through service road of 7 meters, width having sufficient length. Further, additional length of such service road shall be constructed at the cost of the later fuel station company seeking grant for permission of access. They may not have said that they will construct a 7-meter service road. Therefore, my lord, we've given them the NOC. They have
Who
land-
has said that they'll construct this road?
The respondent number 7, my lord.
NHA or private
No,
party?
the private person who, the second petrol bunk.
How can private party do the service road to NHA?
They will, my lord, they will let go of that much land
The
in
road
their
has-
property.
The service road has to be designated to be so by the NHA. Otherwise, they will do it 300 meters in front of their property, then it
Hello,
won't
this is
have continuity.
My lord, this is a state highway. State
Highway also, if they do it, that is why this, of course,
The
it is
point
not
of
very
this is, my
clear.
lord, that to have
With having
easy-
sufficient length, what is sufficient length is not clear. But sufficient length would presume that it's a regular road which will be accessible for various other things, not only for that property.
Lord, their property, my lord, now abuts the state highway. They will, my lord, forego 7 meters there in length
In their property.
in their property.
That's all.
Thereafter, my lord, they'll construct the petrol pump. So therefore, the only aspect of that is.
Shaman,
have
that would be
ease and-
like saying
Yes.
that I have a property with 30 feet road, which keeps on coming up where you have appeared.
Yes.
A 30 feet road, FAR is 1.25.
Yes.
My length of the depth of the property is 200 meters. I leave 20 meters out of my property, make it into a road frontage of 200 feet, give me
And get
FAR
a
of
higher
4.5. That logic will not apply. Then everybody will do whatever they want with their property and claim that. It has to be institutionalized.
This, in fact, if your lordships were to go on any highway, your lordships would have seen petrol bunks next to each other, and they end up treating them as similar petrol bunk. I mean, as a single plot.
Your law is there what to do. If this issue were their good friends, it would not have come. They are very good friends, that is why it has come. For that, we'll have to apply the law. If you were to form a service road, that is different. Each person cannot form a service road in front of his property.
Can I just verify whether we will be not constructing that service road?
And it
or
can't
my
be
lord?
only in front of his property.
No, it
They have
is,
to
the
interpret
point
this-
of that 7 meters is to make sure that there is ease of ingress and egress into the bunk without, my lord, stopping traffic.
Further
On
additional
the
length of
highway.
such service road shall be constructed. It will become a lay-by, not a service road.
7 feet.
Lay-by is only getting into the petrol bunk, getting out.
Yes. Yes.
It won't be a service road. You have to have a service road.
Now it says service road of 7 meters. That's what is mentioned here. Your lordship sees
Width.
the last 4 lines.
Width of 7 meters.
Width of 7 meters.
Width of 7 meters is for 2 vehicles to pass through.
Yes.
3.5, 2.8 meters per vehicle for a truck.
And it says, my lord, at the cost of the.
For that, but it should be sufficient length. It can't be only for this property. And AG has filed the inspection report, the same is taken on record. The submission of that AG is that if there is a service road of 7-meter width, and that since respond number 9 has made available a service road in his own property measuring 7 meters width, and is also willing to bear the cost of formation of such road, a NOC has been issued. In this regard, clause 6 of appendix 1 of the guidelines stroke norms for grant of permission for construction of access to fuel station, wayside amenities, connecting roads, other properties, rest area complexes, and such other facilities is relied upon. A perusal of the said clause indicates that distance between two fuel stations should be at least 300 meters if there's undivided carriageway and 1000 meters if there's a divided carriageway, including deceleration and acceleration lanes. However, the restriction would not apply in case of access stroke egress, for all such fuel stations are provided through a common service road of 7-meter width and not directly to NH. The common service road would necessarily indicate that the petrol stations, fuel stations on that side of the road should be serviced by a common service road. In the present case, the fuel stations are located opposite to each other.
Diagonally opposite.
Diagonally opposite to each other. And for that reason, Learned AG refers to the further provision in clause 6, which states inverted commas, further, access for fuel station at closer proximity than above distance may be allowed, provided entry stroke exit for both the fuel stations are provided through service road of 7 meter width. This is, I think we are reading it wrongly. Just think about it. The distance seems to be on the same side, not on the opposite side. Further access for fuel station at closer proximity than above distance may be allowed provided entry exit for both the fuel stations are provided through service road of 7 meter width having sufficient length. Both. So it has to be on the same side that this would apply.
Yes,
If it on the opposite side, this distance provision will not apply.
not apply.
You are
Oh, close.
read it properly, get instruction because it seems to be the other way around. If it is only on the same side, this will apply ex facie, subject to what both of you say.
But one more this thing, but ಅಲ್ಲಿ ನಾಲ ಇದೆ, ನಾಲ ಪಕ್ಕದಲ್ಲಿ ಮಾಡಂಗೆ ಇಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟಿದೆ. That is in my additional documents, page number 78. ಅಲ್ಲಿ ತುಂಗಭದ್ರಾ ನಾಲ ಇದೆ, ನಾಲ ಪಕ್ಕದಲ್ಲಿ 50 meters ಒಳಗಡೆನೆ ಇದೆ.
ಎಲ್ಲಿ?
Page number 78, in my additional documents. Filed on 18/7/24, page 78,
Additional documents.
ಅದು filed on 18/7/24, page number 78. ಅದರಲ್ಲಿ all the surface water bodies, irrespective of, your lordship got it, all the surface water bodies irrespective of utility shall be protected from any possible contamination. This land includes lakes, ponds, streams, rivers, wetlands, canals and creeks as per the revenue records. Retail outlets shall not be located within a distance meters from the nearest point of water bodies. Idalli lordship
Culvert over Tunga Canal. Located next to Tunga Canal.
Right, I may permitted to produce the photo. ಅದು I may permitted to play the drone camera ದಲ್ಲಿ ಇದು ಮಾಡಿದ್ರು.
Drone camera.
Your lordship kindly
Full
have a
technology.
look at this.
ಸೋಮಶೇಖರ್ ಅವರು ಫುಲ್ ಟೆಕ್ನಾಲಜಿ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
I may permitted to your lordship kindly have a look at this.
ಸೊ ಇಲ್ಲಿ ಎಲ್ಲಿ ಲೊಕೇಶನ್ ಅದು?
ಇದು ಇಲ್ಲಿ ಪಕ್ಕಕ್ಕೆ ಇಲ್ಲೇನೆ ಇದೆ.
ತಗೊಳ್ಳಿ. ಇಷ್ಟು ದಿನ ಎಲ್ಲ ಐಪ್ಯಾಡ್ ಕೊಡ್ತಾರೆ, ನೀವು ಕಂಪ್ಯೂಟರ್ ಕೊಡ್ತಾರೆ, ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡ್ತಾರೆ.
ಅದು ಬಿಲ್ಡಿಂಗ್ ಕಾಣಿಸ್ತದೆ, ಅದು ಪಕ್ಕದ ತುಂಗಭದ್ರಾ ಕ್ಯಾನಲ್ ಅದು. ಅದ್ರ ಪಕ್ಕದೇನೆ, ಪಕ್ಕದ ಲ್ಯಾಂಡನೇ ಅವರು ಪ್ರಪೋಸ್ಡ್ ಬಂಕ್ ಇದ್ ಮಾಡ್ತಾ ಇರೋದು.
ನ್ಯಾಷನಲ್ ಹೈವೇ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ನ್ಯಾಷನಲ್ ಹೈವೇ ಇದೆ, ಅದು ಪಕ್ಕದಾಗೆ ಅದು ಕ್ಯಾನಲ್ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. ಬ್ರಿಡ್ಜ್ ಆಗ್ತದೆ ಕ್ಯಾನಲ್, ಅದು ಪಕ್ಕದ ಮರಗಳೆಲ್ಲ ಇದೆ, ಮರದ ಪಕ್ಕದೇನೆ ಇವ್ರ ಲ್ಯಾಂಡ್, ಆ ಕಡೆದು ಕ್ಯಾನಲ್. ಫಸ್ಟ್ ಅಲ್ಲೇ ಇದೆ.
ಇದು ನ್ಯಾಷನಲ್ ಹೈವೇನಾ ಇದು?
ಹೌದು, ಅಲ್ಲ ಸ್ಟೇಟ್ ಹೈವೇ ಇದೆ, ಸ್ಟೇಟ್ ಹೈವೇ. ಅದು ಕ್ಯಾನಲ್, ಅದು ಕ್ಯಾನಲ್ ಪಕ್ಕದ ಲ್ಯಾಂಡೇ ಇವ್ರದ್ದು. ಅದು 50 meters ಒಳಗಡೆನೆ ಇದೆ ಇದು. As per this, my lord, there is no provision for establishment of the bunks, my lord.
ನೀವು 50 meters ನಿಮ್ಮ ಪ್ಲಾಟೇ ಹೋಗ್ಬಿಡತ್ತಪ್ಪ. If you measure 50 meters, your plot will be in that 50 meters. From what we see of this.
Even NOC 50 meters ಇದೆ ಅಂತ ಹೇಳ್ಕೊಟ್ಟು they have
50 meters ಒಳಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಹೊರಗಡೆ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನಿಮ್ 50 meters ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ it will be outside your property.
reduced it off.
The vehicle passing through would indicate that your entire property cannot have width more than 30 meters or 40 meters maximum. ಹಿಂದ್ಗಡೆ ಅಂತೂ 10 meters ಇಲ್ಲ. Frontage may be around 40 meters. ಕೊಡಿ ಶಮಂತ್ ಕೊಡಿ ನೋಡ್ಲಿ.
ಅವ್ರಿಗೆ ತೋರಿಸಿ.
Frontage is only a small portion. Rest of it is. The first one he may not succeed, but second aspect he looks like he will succeed. Can't be 50 meters. The report has been filed by learned AGA. The same is taken on record. And AGA seeks for and is granted a week's time to obtain instruction as regards the distance of the property and measurement of the property of respond number 9 vis-a-vis the Tunga Canal located abutting the property of the respond number 9, and whether it is distance one. So relist on
Not have that distance. Yeah, page 2, the sketch itself which I made.
distance illa alli. You'll have to get the distance.
But it seems like it's executed, but even in the sketch view.
50 meters, there can't be anything. No underground tank, no nothing. If that is not there, nothing can be done in this property in respect of a fuel tank. Released on 20th August.
For the petitioner. But the petitioner was awarded 4 contracts by the railway. Petitioner has awarded 4 contracts.
Railway, not election commission.
No.
2 more we have ordered today. You're not paid in any contract, is it? Election commission?
No, probably,
Idralli-
it's not election commission.
Not this. There were 2 more today where we have directed.
Lord,
it to
what
us.
happens, my lord, in election, those matters, my lord, the respective district election officer is the we have authorized him, and he has to look into the bills, my lord, and pass the orders. My lord. And after the elections, my lord, the officers transfers, my lord. The incumbent officers will not take any action because something happens to come on us. That's the
3 years in the pending idre hengappa.
Lord, I just true, my lord, even the
Yeah,
coordinator
you
bench
can't
too has filed this.
Anyway, these are different. Yes.
Please, madam. Here, out of these 4 contracts, my lord, in one of the contract, there was an allegation against the petitioner for that there was some bribe was given for awarding of the contract. And in respect of that, my lord, there was a FIR is filed against him by the CBI. And CBI, it seems, has filed addressed a letter. The lordship may kindly see that letter at saying that the payments to the petitioner may be withheld until that the inquiry is
Page number
concluded. Please, madam, that, but that is at page 37, my lord, annexure J.
Page 37 is annexure J.
Annexure J, madam, yes.
Annexure J is not 37.
This is addressed by CBI inspector. No, they say they refer to the
J
letter
is
of
page 40.
Please, Thereafter, we filed a writ petition where direction was issued to consider my representation and pass appropriate orders. Now, after this representation, my lord, they have given me this annexure M endorsement, saying that they have invoked clause 18 of GCC, and therefore payment is withheld. That is their endorsement.
Yes, they passed this. Now, if you have to recover any money, you file arbitration clauses there.
Well, arbitration clause is there, correct, but there is no dispute as such with regard to the quantum or this thing. They only say they are not taken that objection that this is a dispute which has
They have not processed your bill because of CBI inquiry pending.
Yes, ma'am. What's all that was their contention. CBI has in turn told them to withhold if there is any recovery against me from the bills that has to be processed. Therefore, they have asked them to withhold. No, there is no
allegation even made against the railway employees that your contract which has been awarded is for monetary gains by the railways.
No,
Yes,
that is only in respect of one contract.
Yes,
But here there are 4 contracts are there. Other 3 contracts is free from any. There is no allegation about that, and all monies cannot be withheld. But only in respect of one contract, their stand can be sent.
This cannot be considered in a writ petition.
But this is in respect of 4 contracts. All contracts have stopped. All payments have been stopped. The allegation is in respect of one contract.
Correct. If you have to recover money, you have to go there. Consideration is what was directed by this court. They have considered it and they have rejected it.
But they have
rejection cannot, in a contractual matter, can you challenge the rejection in a writ petition?
I'm saying what they have said is they have exercised power under clause 18 of GCC. You last time for a moment see the clause 18. That power is not vested with the officer who has given the endorsement. Your last time they have filed objections. Clause 18 is given. Objections. For illegal gratification, page 9 ಅಲ್ಲಿ start at clause 18.
Page 9.
Page 9.
Yes.
Clause 1. Clause 1. Any bribe, commission, gift or advantage given, promised or offered by or on behalf of the contractor or his partner or agent or servant or anyone on his behalf any offer, subject contractor to the rescission of the contract and all other contracts with the railway, and to the payment of any loss or damage resulting from such decision of the railway shall be entitled to deduct the amount so payable from the contractor's bill or security deposit or any other dues of the contractor with the government of India. Next, any contractor shall not lend or borrow from to have or enter into any monetary dealings or transaction either directly or indirectly with any employee of the railway, and if he shall do so, the railway shall be entitled forthwith to rescind the contract and all other contracts with the railway. Any question or dispute as to the commission of any such offence or compensation payable to the railway under this clause shall be settled by the general manager of the railway in such manner as he shall consider fit and sufficient, and his decision shall be final and conclusive. In the event of rescission of the contract under this clause, the contractor will not be paid any compensation whatsoever except payments for the work done under up to the date of rescission. This is the clause.
This is all facts. So you file your arbitration clause for recovery of money, you can go there and establish all these things.
Yes, there is no dispute as to they have not rescinded the contract. Only thing is dispute.
There's a dispute, my lord, in the FIR.
He is saying he has not said anything and objections.
Only thing that we can do when payments are not made is direct them to consider the representation.
No,
they have considered the representation, they have passed this order. If you don't like it, you cannot come back before us for a contractual recovery. You'll have to use your arbitration clause or civil court, you'll have to do that.
That is, if there is a dispute as to the quantum, or if I'm asking for damages, only for refund of
How much
security
is
deposit.
undisputed amount? If they say whatever undisputed amount they say, we'll direct them to pay.
But I have to take instruction regarding whether there's a dispute and
My
what
lord, the
in the lordship
security deposit,
mechanism,
my
my
lord, there is no
lord, in
dispute
the
about
charge sheet, my lord, they have in the
And clause 18.2 says,
Yeah, after this.
Can't be, Mr. Bapat.
My lord,
my lord, you last time I kindly see for a moment. Clause 18.2 says, general manager has to decide what is the compensation payable by the contractor to the railway, that amount he has to determine and recover from the contract. So that is such situation also not arisen. And whatever money due to the contractor has to be paid. That is the clause which permits the general manager not exercise.
Not in a writ petition.
Even submission to my lord says, even my lord, his forged documents are accepted.
Petitioner is before this court seeking for the following.
My lordship may kindly see for just
The
for
petitioner had been awarded works by the railways in pursuit of a tender floated by the railways. Letter of acceptance has been issued on 29/4/2019. It is contended that the respondent had completed most of the works and raised his bills, which had not been paid. In that background, the petitioner had earlier approached this court
my lord, there is
seeking for
my
a
lord,
mandamus.
for a moment. My lord.
Huh.
On the similar set of facts, there are four contractors against whom charge sheet is filed. Only I have come before the court and other three have not gone to the court. On the basis of order in my writ petition, one of the contractor is paid, but not they have been processed his payment. My lord.
That file of public interest litigation will consider it there. Had approached this court in WP number 5962 of 24, seeking for mandamus to consider, directing the respondent to consider the bills which had been submitted. This court, while its order dated 28th August 24, had so directed, in pursuance of which the bills have been considered by the respondent and endorsement issued on 39/24 at Annexure M. It is challenging the said endorsement that the petitioner is before this court. A peril of the endorsement stroke reply dated 39/24 indicates that there is a CBI investigation pending in respect of irregularities in awarding the contract to the petitioner, and hence the final bills and the bills are kept pending till finalization of the investigation so as to enable recovery, if any, from the contractor. The railways, having called upon the CBI, inquiring as to when the investigation would be completed, it is stated that an investigation has been completed and a charge sheet has been laid in RC 15(A)/2022 before the Special Judge for CBI cases, Bengaluru. Wherein the petitioner as also several officers of the railways have been arrayed as accused. It is stated that there is a clear and categorical allegation that Mr. Venu Madhav, proprietor of the petitioner, had given undue monetary benefit to the public servants who were involved in the tendering and execution of the work awarded to the petitioner, and that the contract had been obtained on the basis of forged documents. In that view of the matter, exercising the power under clause 18(1) of the general condition of contract, the railways have withheld the payments pending ascertainment of the amounts, if any, due to be recovered from the petitioner. The submission of Sri Sampath Bapat, learned counsel for the petitioner, is that there is no dispute as regards the amounts which are due. The withholding
no recovery is proposed with
the withholding is only on account of the pendency of those proceedings. There is no recovery which has been proposed or notice issued by the railways to the petitioner, and as such it is deemed that the bills which have been submitted by the petitioners are accepted by the railways and the entire amount be directed to be paid by quashing the endorsement dated 30/9/24. This court is unable to accept the said submission of the learned counsel for the petitioner, inasmuch as it is not only an investigation, but a charge sheet has been laid by the CBI in the aforesaid proceedings, making the allegations, substantiating the allegations made against the petitioner. Insofar as the recovery is concerned, the recovery would have to be resorted to only after the proceedings come to a conclusion in those proceedings. Inasmuch as a charge sheet having been filed, the trial is yet to be concluded. It is only thereafter that inquiry into the recovery of amounts and the damages caused would have to be resorted to by the railways. The said submission, in the considered opinion of this court, is premature at this stage. As regards the contention that the withholding is on the basis of the instructions issued by CBI, and that it is deemed that the bills are accepted by the railways, this court is again unable to accept the said submission, since the very processing of the bills has been withheld on account of the pendency of the proceedings. The bills have not been processed, let alone been accepted by the respondent. In exercise of writ jurisdiction on Article 226 and 227, this court cannot entertain disputed question of fact, much more so as regards contractual arrangement between the parties. The contract admittedly being governed by an arbitration. Invoke the said arbitration clause.
Clause 18 comes in accepted matter, therefore pointedly they have not
Or
taken such a.
If any of the issues come within the ambit of accepted matters under the GCC, the petitioner would always be at liberty to approach the jurisdiction civil court, reserving the liberty to the petitioner to approach the appropriate forum. As applicable, the petition stands disposed.
Thirty-five.
I appear for petitioner, my lord.
Number two, madam.
Yes, madam.
I submitted the other day before you last is that cancellation by them, the allotted.
Flats are available under Karnataka Chief
ಅಲ್ಲ, ಅದು
Minister.
ಅವರಲ್ಲಿ
1 lakh.
ಹೋಗಿದ್ರು ಅದು ಯಾವ್ದು ಸೆಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ನನಗೆ ಅಲಾಟೆಡ್ ಸಹ ಇದನ್ನಾದ್ರೂ ಕೊಡ್ಲಿ, ಫ್ಲಾಟ್ ಆದ್ರೂ ಕೊಡ್ಲಿ, ಇಲ್ಲಾಂದ್ರೆ ನಾನು ದುಡ್ಡು ಎಲ್ಲ ಗೊತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ವಾಪಸ್
ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಡವಾ?
ಫ್ಲಾಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ. ಯಾವ ಕೊಡ್ತಾರೆ?
But without interest, my lord, they have accepted
As per the terms of your.
Please, madam.
ಅಲ್ಲ ಅದು ಇಂಟ್ರೆಸ್ಟ್ ಪಾರ್ಟ್ ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್ ಇಸ್ ಮೈ
As per the terms, whatever is there, you are entitled. That is what we have been trying to tell you. Take a.
Kindly see the term also. For
Show
a
us the
second.
term.
Kindly see the term also. They have produced that copy of the application there, and along with that term is attached, page 8 of their reply statement. Page 8 of their reply statement. They draw the dependency factor on item number 10 there. I will read that. Your lordships are getting that on page 8 of the reply statement.
Only direct them to refund as per what it is. If you want all these things, you'll have to go to a civil court. This is a writ jurisdiction. It's a limited jurisdiction. We cannot decide how much interest.
No, my
what
submission
to be
is
paid.
let them return the amount first, whatever the amount I have deposited.
They are ready to do
And
that.
then interest part as such, your lordships may either, your lordships can choose that. It can be granted by your lordships only. Otherwise, if your lordships feel any other forum, your lordship may direct that.
If we grant you 6%, you can't ask for more, Ramela.
Plus,
If we grant you 6% interest, which normally this court grants only 6%.
whatever interest your lordships will grant, I am satisfied.
6% to you.
Interest, my lord, the page number 8.
I am satisfied with that because my amount is held up by them.
You have not completed the construction.
Well,
You were thinking if he goes to the civil court, he'll get around 18%. He's happy with 6%.
My lord, with interest will not issue, my lord. Only the amount will refund. Otherwise, alternative
We are
flats
not
are
asking your
available.
consent for 6%. madam. We are only directing you to pay. Petitioner is before this court Because he had asked for 18%, that is why we thought
No,
we
no,
may want a liberty.
whatever
to
your losses will find it reasonable, because I can't insist on 18%.
Normally
It's
grant
not a
only-
commercial transaction.
High Court will bury 6% ಅಷ್ಟೇ ಕೊಡೋದು.
I am grateful.
Petitioner is before this court seeking for the following reliefs. A scheme was propounded by the state government, which is notified in the Prajavani newspaper on 19 September 2010, inviting applications on a lottery, which would be chosen on a lottery basis for allotment of flats in the said scheme for construction of 1 lakh flats in Bangalore.
1 lakh housing scheme.
1 lakh housing scheme in Bangalore, but then you made it into flats only. Housing scheme in Bangalore. The petitioner had been informed that she had been allotted flat number 37 in C block ground floor at Talaguppa in Ramnagara district, in persons of which the petitioner had made various payments. The allotment letter came to be issued on 8/1/2012. In all, the petitioner ಎಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ? Made a payment of a sum of rupees 12,21,500. Already paid 288 plus 1221, Mr. Kulkarni.
But totally ಎಲ್ಲ ಸೇರಿದ್ರೆ ಅದು 15 lakhs, 15 lakhs.
All the amount is not paid in the one shot, my lord.
ಅಲ್ಲ ಯಾವಾಗಿಂದ
Petitioner
ಕೊಡ್ತಾರೆ
made
ಅವರು?
a payment of a sum of
15
rupees.
lakh 10,000 my lords, whatever is paid.
ಅದಕ್ಕೆ ಮುಂಚೆ. Initially, the petitioner had been asked to make payment of sum of rupees 5,25,000. Subsequently, on 4/12/2021, the petitioner was informed that the revised flat value was rupees 15,10,000. And by another communication, dated 19/8/22, the petitioner was informed that the final flat value is 13,25,000. The petitioner had initially made payment of a sum of rupees 2,88,500, made a balance payment of rupees 12,21,500, further payment of 12,21,500 on 11/3/2022. Much prior to the communication dated 19/8/22, wherein the amount was reduced. Though the said amounts had been received by the respondent did not complete the construction of this aforesaid project. The petitioner followed up with the respondents to hand over the said apartment stroke flat, but since it was not ready, it was not handed over. In that background, that the petitioner had submitted a representation seeking for refund of the monies paid by the petitioner to the respondents. The said refund also not having been made, the petitioner is before this court seeking for the aforesaid relief.
We have replied it, my lord. Annexure J, page number 28, this 13 lakhs 25,000 is the amount. Without interest, we'll refund it. I have to produce the documents, my lord.
15,10,000, yes.
The page number 28, Annexure J is replied by us, my lord, saying that you have to produce the documents,
He will
that
produce the
allotment
document.
letter and affidavit
That
and
I will
bank
do.
passbook,
That-
Aadhaar
That
card.
he will
No
give
issue
you.
at all.
All that he will give you, don't worry. ಇನ್ನ ಇಂಟ್ರೆಸ್ಟ್ ಜಾಸ್ತಿ ಮಾಡ್ತೀರಿ, 9% ಮಾಡ್ತೀರಾ, ಅದು ಕೊಟ್ರೆ ಹೇಳೋಣ. ಪಾಪ retired people, you are making them run around.
Due to technical reason, we are unable to complete. 75% is already completed. Only thing is stay irodrinda we are unable to complete it.
We'll direct you to register under RERA now.
It's a government project, my lord.
Ongoing project, ಅದಕ್ಕೆ
The nominal
register.
amount we are taking and through government amount we are
Register under RERA,
constructing.
then you will pay properly there.
Due to stay, my lord, we are unable to complete. 75% of building has
Will
been
that
already
apply to a
completed.
private builder, madam?
Please, ma'am.
Why should it apply to you that a stay is there? having been made, the petitioner is before this court seeking for the opposite relief. When the matter was taken up for hearing, learned counsel for respondent had submitted that there are various other projects which have been developed by the respondent, and if the petitioner were interested, one of those apartment stroke flats could be allotted to the petitioner. It is in that background that the details were provided to the petitioner who had gone and visited the said apartments and found them unsuitable for their requirements. It is in that background that the petitioner, Shri P. A. Kulkarni and counsel for the petitioner submits that the apartments not being suitable, the refund of their monies with interest at 18% be ordered. Undisputably, the respondent has not completed the project towards which the monies were paid, though there are several reasons or justifications made out as regards pending litigation and or the like. The fact remains that the petitioner has not, respondent has not completed the project despite the petitioner having paid the monies way back in the year 2022. On the basis of the facts and record, it's also unlikely that the said project would be taken up and completed in a reasonable period of time, and it is in that background that the petitioner is not interested in continuing with the allotment made by the respondent, but would seek to withdraw the amounts and buy an apartment or flat elsewhere. There can be no fault found with the prudence exhibited by the petitioner in doing so, when the mistake is with the respondent in not completing the project. In that view of the matter, this court passes the following order. Writ petition is allowed. A mandamus is issued directing respondent to return the amount advanced by the petitioner with 6% interest per annum calculated from the respective dates on which the amounts were paid till the date of refund of the amounts.
Time for compliance.
Needless to say, the petitioner would have to place on record before the respondent the details of the payments made with appropriate proof of such payments. Respondent shall consider the said documents and refund the money within 30 days of the said documents having been submitted by the
As per Anik they have to produce the documents.
Serial number 36, Gopala HM.
Lordship direction, I have filed the application to implead all the petitioners who are represented to the petitioner now. The application has not been.
Who have you? Yeah, who have you?
I implead the application I have filed, my lord, to implead the.
Implead who?
All the persons who have.
In respect of members. Last time your lordship directed to implead members.
Members of the, because society could not
please.
maintain it.
Can I make a submission, my lord? Mandamus is, my lord, to allot sites in survey number 158, representation to that effect. This land has not yet been allotted to the panchayat itself, so it's premature. Deputy Commissioner has not done anything, he's not notified it, my lord, and handed it over to the panchayat.
Consider their representation, pass an order so that they will know what is exactly it is.
You'll have to, my lord, reject and say it's premature, and then whenever, my lord, applications are made, we'll consider it as when the committee is constituted. Because once the land is.
Yes. The problem is when applications are filed, immediately if you communicate, then people won't wait for it.
We'll communicate.
Take action.
We'll communicate.
This representation is on 10/7/24.
We'll communicate, my lord.
Communicate.
15 days, my lord.
Since 2016, my lord, representation have been given to the authorities since 2016. Finally, that 2024 final representation, my lord.
They're particularly asking under survey 158.
Or consider it, you tell them if it can be considered.
Vacant land is available.
We'll do that.
IA 1 of 26 has been filed to implead the members of the petitioner who had made applications to the respondents for grant of house sites under the Ashraya scheme. Accepting the reasons stated in IA 1 of 26, the said application is allowed. The person named therein are brought on record as petition number
215, 260, my lord.
260.
Petitioner, yes, my lord. 259 caught for impleaded.
260. Please counsel for the petitioner to carry out necessary amendment and file amended cost title. The petitioners 260 had earlier made representations in the year 2016 for grant of housing sites. When the Deputy Commissioner had issued direction to the Tahsildar to ascertain if any sites are available and allot the same. Thereafter, the petitioner had been following up with the respondents when it was indicated that respondent number 5 has been constituted for that very particular purpose, and all the Ashraya schemes are now consolidated under respondent number 5. Hence, the petitioners followed up with respondent number 5 for grant of the said housing sites, which is also not, where there is no progress made. And it is in that background that the petitioner is before this court seeking for the aforesaid relief. Now, counsel for the petitioner submit that from the year 2016, the petitioners have been running pillar to post.
Please,
without their representation, I mean, considered by a respondent, no order, I mean, passed by a respondent. They have no recourse available under law. Learned AGA submit that the representation which had been made by the petitioner was for allotment of land in a specific survey number, namely survey number 158 of Kuruburalli village, Tavarekere, Bangalore, South Taluk. The said survey number is not in the custody of the respondent number 5, nor is any proposal pending as regards formation of Ashraya sites and or allotment of Ashraya sites. Even if that were to be so, it was for the respondents to have replied to the representation submitted by the petitioner, indicating this fact, instead of making them run from pillar to post and wait with a fond hope of allotment of a site, which the Deputy Commissioner had indicated would be so allotted in view of the direction issued to the Tahsildar. If at all the land in survey number 158 is not available and any scheme has been propounded by the state or respondent number 5 for formation of sites under the Ashraya scheme, the applications made by the petitioner could always be considered in those schemes on the basis of seniority or the date of application having been made. In either case, the respondents could not have sat over the representation made by the petitioner and not passed any orders for the last more than 2 years. Hence, this court passes the following order. Writ petition allowed, a mandamus is issued directing the respondents to consider the representation of the petitioners dated 10/7/24 at Annexure X and pass necessary orders within 30 days from the date of receipt of a copy of this order in terms of the observation made here and above. Court fee ಕೊಡಬೇಕಾಗುತ್ತೆ. ಮಿಸ್ಟರ್ ಗೋಪಾಲ, ಇದು ಕೋರ್ಟ್ ಫೀ ಕೊಡಬೇಕಾಗುತ್ತೆ. ಬೇಡ, ಯಾಕೆ ಪಾಪ ಅವ್ರು ಕೋರ್ಟ್ ಫೀ ಕೊಡೋದು? ಅದು ಐದು ತೆಗೆದುಬಿಡಿ. ಕನ್ಸಿಡರ್ ದಿ members of the petitioner. In 259 ಅಂದ್ರೆ you will have to, ಬೇಡ. No need to pay. We are not allowing your IA. We are just taking it on record.
37, Leela Pidevadiga.
Yes, Mr. Panindra.
The petitioner, my lords, has challenged the endorsement of the notice, my lords, at Annexure J.
Notice?
It's a communication, my lords, at page 56 by the Deputy Conservator of Forest addressed to the Deputy Commissioner. Lords, seeking that the conversion order be cancelled on the ground that the area, the village in which the conversion is granted falls within the eco-sensitive zone, my lords. That the eco-sensitive zone was declared on 6/6/2017. I purchased the property on 17/10/2018.
It was declared prior to your purchase?
My mother's purchase.
Yes.
Then, of course, my lord, the conversion was on 23/12/2020. At page 22, your lordship should get the conversion order.
Page?
Running page 22.
Where is the notification declaring it is?
My lords, that your lordship should get, my lords, at page 36.
36. This is 6 June.
Mallinathpura.
Yes.
Lords, we applied for
The
conversion.
entire village is part of the.
No, my lords, we applied for conversion. Conversion order was granted on 23/12/2020, page 22 ಅಲ್ಲಿ ಇದೆ. For a residential purpose, my lords, for 4 acres. Residential layout.
Yes.
Thereafter, my lords, the layout was also approved. Plan was approved
By?
on 11/5/22. Page 31 by the Assistant Director, Town and Country Planning, Mysore.
Page?
Lords, 31, running page 31, Annexure D. Then, my lord, so cause notice came to be issued by the DCF on 3/12/24.
We will come back.
Sir, continue.
Is a senior citizen? Nothing. Why he can't fight?
230 matters.
Why he cannot fight?
Secondly, start with.
Lords, may I make one request, lords. I'm told 230 matters will be taken up first.
Yes.
On 3:30 I have to leave. Some other day. 3:30 I have to.
You have to go somewhere.
Go to Delhi.
ಯಾಕೆ ಬಿಡ್ತಾ ಇದ್ದೀರಾ?
First ಹೇಳಿದ್ದೆ 3:30.
37 at the request of the council for the
Serial number,
petitioner. Relist on 25th, interim order earlier granted is extended till next day.
Please.
38 copy has not been served.
My lord, withdraw ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
38 withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಎಲ್ಲ withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಕೇಸ್ withdraw ಮಾಡ್ತಾ.
ಎಲ್ಲ withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Up to serial number. 38.8 withdraw.
Petitioner is before this court seeking for the following reliefs. Memos of withdrawal has been filed in each of the above matter which reads as under. Accepting the memo, petition is dismissed as withdrawn.
Serial number 43, my lord. Serial number 43, my lord.
43.
Please to allow my IFR early hearing.
What, Mr. Dasdagir?
Serial number 43, my lord. Your lordship has been pleased to allow my IFR early hearing. But every time it is not reaching him.
There are so many matters. When it reaches, it will be taken up.
After list.
46. At the request of counsel for the petitioner, relist on 23rd September.
68, my lord. 68, my lord.
68. ನೀವು ಯಾರಿಗೆ? petitioner ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
ಹೇಳಿ. JM ಪಾಟೀಲ್ ಇಲ್ಲಿ ಶ್ರೀದೇವಿ ಅನ್ನೋರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ. ಅವ್ರು ಯಾವತ್ತೂ ಬಂದಿಲ್ಲ. JM ಪಾಟೀಲ್ ಅವರು ಶ್ರೀದೇವಿ ಅಂತ ಒಂದ್ ನಿಮಿಷ ಇದ್ಬಿಡಿ. ಅರ್ಜೆಂಟ್ ಅಂತೆ. 39 ಅರ್ಜೆಂಟ್ ಅದು 22nd ಆಗಸ್ಟ್ 97 ಇದೆ. ಏನು ಬೆಳಗ್ಗೆ ಮೆಮೊ ಮತ್ತೆ ಕೊಟ್ರ ನೀವು? ನಾಳೆಗೆ 2:30 ಹಾಕಿದ್ಯಾ? ಒಂದ್ ನಿಮಿಷ ಅವರು ಮೆಮೊ ಬುಕ್ ಕೊಡ್ತಾರೆ. 2:30 ಬರ್ದಿದೀವ ನಾಳೆಗ್ ಬರ್ದಿದೀವ ಗೊತ್ತಿಲ್ಲ. ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಬರ್ತಾರಲ್ಲ, ಬುಕ್ ಇದೆ, ಮೆಮೊ ಬುಕ್, ಮೆಮೊನಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿರುತ್ತೆ ಎಲ್ಲ. ನೋಡೋಣ ಅಲ್ಲಿ ನೋಡೋಣ ಏನ್ ಬರ್ದಿದೀವಿ ಅಂತ ನನಗೂ ಗೊತ್ತಿಲ್ಲ. ನಾಳೆಗೆ ಅಂತಾನೆ ಲಿಸ್ಟ್, ಇವಾಗ ಅದರ್ ಸೈಡ್ ಗೊತ್ತಾಗಲ್ಲ ಲಿಸ್ಟ್ ಆಗೋದು. ನೋಡ್ತಾರೆ, ನಾನು ಇಲ್ಲಿ ಇನ್ನೂ ಬೇರೆ ಉತ್ತರ ಕೊಡೋದು ಇದೆಯಲ್ಲ, ಅಲ್ಲಿ ಅವ್ರು ಬರ್ತಾರೆ, ಬುಕ್ ಕೊಡ್ತಾರೆ, ನೋಡ್ಕೊಳ್ಳಿ. ಹೇಳಪ್ಪ. 7 ಅಲ್ಲಿ ಆ ಪಾರ್ಟಿಗಳು ಹೇಳಿ ನನಗೆ. ಅಲ್ಲ ಅಲ್ಲ, R1 ಯಾರು? ಬೇಡ ಬಿಡಿ, ಅವ್ರ ನೋಟಿಸ್ ಆಯ್ತಾ? R1 ಶಿಲ್ಪಾರಾಣಿ ಇವಾಗ್ಲೇ ಇದ್ರು ನೋಡಿ, ಅವರು. ಆಮೇಲೆ R2 ಬಂದ್ KV8 ಅಲ್ವಾ? R3 ಯಾರ್ ಪಾರ್ಟಿ? ಅದೇ JM ಪಾಟೀಲ್, ಶ್ರೀದೇವಿ. ನಂಗೇನಪ್ಪ ಗೊತ್ತು, ನಾವ್ ಇಲ್ಲೇ ಇರ್ತೀವಿ ಅಷ್ಟೇ, ಯಾರು ಎಲ್ಲಿರ್ತಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಶ್ರೀದೇವಿ ಅನ್ನೋರು ಇರ್ತಾರೆ, ಅವರೇ ಬರೋದು ಕೋಟಿಂಗ್ ಜಾಸ್ತಿ. ಲಿಸ್ಟು ಫಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಯಾರದು? ರೇರಾ ಗೌತಮ್ ದೇವ್ ಸಿ ಉಲ್ಲಾಳ್. ದೇವ್ ಸಿ ಉಲ್ಲಾಳ್. ಹೋಗಪ್ಪ, ನಾವೆಲ್ಲಿ ನೋಡಿರ್ತೀವಿ ಅಷ್ಟೇ ಅವ್ರನ್ನ, ಸ್ಪೆಲ್ಲಿಂಗ್ ಎಲ್ಲ ಹಿಂಗ್ ಗೊತ್ತಿರುತ್ತೆ. ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲ, ಫುಲ್ ಆರ್ಡರ್ ನಾನ್ ಬರ್ಕೊಳಲ್ವಲ್ಲ, ಬರೀ ನಂಗೆ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಗೊತ್ತಿರುತ್ತೆ ಅಷ್ಟೇ. ಬ್ರಾಂಚಲ್ಲಿ ಕೇಳಿ ಯಾಕೆ ಅಂತ. ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ. ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ಯಾ ನಿಮ್ಗೆ? ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕೊಳ್ಬೇಕು ಅಂದ್ರಲ್ಲ, ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ಯಾ? ಅಲ್ಲ ಆಯ್ತಾ ಆಗ್ಲಿಲ್ವಾ? ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಲಿಲ್ಲ. 88 ನಿಮ್ದೆ ಸರ್, ನಿಮ್ದೆ 88 ನಿಮ್ದೆ. ಏನು?
November.
ಚಾರ್ಜರ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ಆಗುತ್ತಾ ನೋಡಿ ಫಸ್ಟು. ಆಗುತ್ತಾ ನೋಡಿ. 6 matters.
Anjali, we should start taking one set of all decisions that we want for ourselves. Then we'll start arranging it. No, that's what I also said. According to the dictation, I think research more is required on the rule making and the legislation presumption.
First second list or
If it is a country, I'm just waiting.
Okay.
If it is a country, the rules will apply.
No, that is you have to do it. No, correct.
ನನಗೂ ಗೊತ್ತಿದ್ರೆ ನಾನು ಅಲ್ಲಲ್ಲೇ ಹೇಳ್ಬಿಡ್ತೀನಪ್ಪ. ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲಾನೇ ಅನ್ಬೇಕು. ಎಲ್ಲಿಂದ ಸೃಷ್ಟಿ ಮಾಡ್ಲಿ ನಾನು?
Standing the repeal it. Because it's executed. The repeal of the statute will not affect because it's safe. Specifically it is safe. It was not safe. Then it will not. The instrument.
ಇಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ನನಗೂ ಗೊತ್ತಿರುತ್ತೆ. ಇಲ್ಲ ಅಂದ್ರೆ ನನಗೂ ಗೊತ್ತಿರಲ್ಲ. ಅಲ್ಲ ಬೇರೆ ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಕೊಟ್ಟು ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಯಾರು ಕೊಟ್ಟಿಲ್ಲ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ
saves section 6 saves. Correct, no, Jack? No, you should also look at transfer property. Also aware, also is aware that this is the statutory release. First, keep the list two only.
Leave is subject to the rules and the amendments made.
That's all it is. It has to be like your minds. This because under your minds, you revise the royal it becomes applicable to the existing rules. So since it's part of the rule itself, so therefore we are saying that it is part of the rule itself. And the power to alter the rule means power to alter the terms of these rules.
Lordship, serial number 110, my lordship suggested you will take up at 2.
We'll take it up when just take it up.
Serial number 88, B group matter. The author have been posted in preliminary hearing.
Brief matter, whatever, when it is taken up, not otherwise. ಯಾವುದು? 68. ನೀವ್ಯಾರಿಗೆ? The request of council for respond number 3 released on 24th September, interim order earlier granted is extended till next date.
Lord, the matter was last week posted in the fresh matter. Some students are there, Lord, they are not getting the hall tickets.
You want it to be posted, you want adjournment
Lord, I don't want any adjournment. They posted in the preliminary hearing.
on 24th September.
I will be waiting till.
Yes, let's see then.
That is 88 years. I have informed Mr. Jagdish also.
Yes, please.
List number 2, serial number 1, Vinay N.
Yes, please. This is a surfing matter, Lords.
Bronze medalist.
But the
No. Yesterday you were supposed to give it. Have you given it to the
yes,
petitioner?
yes, they have served a copy.
Otherwise you would not accept.
There, Lord, it's a shifting of blame. It's not.
He's got a bronze medal and you don't do it. What is this? And you select a person who has not even got a medal. Yes.
Lord, the Lords would turn to Lord page 30. But this is the Asian Surfing Championship of 2025. But which is held not in Tamil Nadu, India. This is where not the first not is from other country, Korea, etc. I am at serial number 3.
This is the bronze medal that
This
you
is the bronze medal that I got.
Yes.
This is Asian Surfing Championship 2025. But the selection policy, Lord, is at page 31.
This is Asian Surfing Championship.
Please.
Conducted by?
Lord, this is conducted not by the Asian Surfing Federation.
Posted by the respondent before.
Asian Surfing Federation, Lord, which is 4th respondent.
No, Asian Surfing is the other one. I'm Surfing Federation.
Federation of India conducts this. Who conducts this?
My lord, it is conducted by the Asian Council of Surfing. My lord, I posted it in Mahabalipuram.
You are?
My lord, I am the National Sports Federation for Surfing.
So you are the Surfing Federation of India.
India.
Respond number 4.
Yes.
So hosted by respond number 4.
Yes, but it is under the aegis of the Asian Surfing Council.
All of you are nobody. It's everything IOC. Under IOC this. So everybody goes back to IOC. You don't want to take credit for even hosting it. Yes.
Lord, annexure B, page 31, Lord, is a selection
Because Ajay
policy.
knows the next question that will come to him. So he's distancing himself.
Lord, taking cue from that, Lord, all these respondents are now taking, Lord, escaping from one another by saying it's not my responsibility, the other person who does all this. I'll show the
Let's see.
objections.
Let us see.
Page 31, Lord, is a selection policy. But if you also turn to page 35, Lord, there is an appeal mechanism and then there is a replacement policy at serial number 12, bottom of page 35. Now, please see Lord, clause 12, replacement policy. Athletes may be replaced with the bench athlete if injury, doping, violation, code breach, ineligibility or withdrawal.
Now, how is the selection to be done? This replacement will come to later.
Yes, Lord.
You said there is a violation of the selection.
Yes, Lord. There is a committee, Lord, that is.
You won a bronze medal. What we remember is only three, four things.
Yes.
Bronze medal, you were being selected. One of the selection members, there was a tie.
Yes.
One of them said, I can't accept it. It is arbitrary.
Yes.
She resigned.
Yes.
And sent one nice mail.
Yes.
And then thereafter, somebody else was selected who
Yes.
has not won any.
Yes.
Now you have to take us through
I'll only
each
show that.
individual thing as to what is the selection process, who is to recommend.
Yes. The
How does
selection is done by the selection committee. Not a committee will be constituted. It will consist of various experts.
Shows the
I'll show that.
applicable also.
Which is that? Which is the page? But page 32, Lords. Eligibility, pool ranking, selection pathway, modules and timelines.
As of 30th September.
Yes. As
Top,
that's also top 8 men and top 8
SFI National Surfing Federation of India's
India.
ranking.
National rankings.
So
by
ranking
which
is done by
forms-
SFI.
Please, Milord. From the selection pool, ties so also resolved by head to head in 2025 events. Higher best single event points, second best single event points, coin toss in presence of SC and recorded on video. Eligibility conditions, Indian passport, so and so, but I'll skip that portion. Then Lord, Module 2, centralized to day assessment camp, conducted no later than 31st of March 2026 at an SFI approved venue, mandatory attendance unless medically exempt, components so and so not are set out, then not weightings published, etc. Then output, then last selection pool can be reduced under the discretion of the head coach and SFI selection committee. Then Lord, Module 3 refers to reduction of competition squad plus bench based on Module 2 scores plus 2025 ranking points. SC reduces the squad by 30th April 2026 to the following numbers or lower as determined by the selection committee. Top 3 men plus 2 up to 2 bench athletes, top 3 women, etc. Then tiebreakers,
Why
mirror
is
model.
this reduction number or lower as determined?
Please, Lord.
Why not more? Why is it lower?
I will explain all that.
You will explain.
I'll explain that.
Yes.
Then Lord's module 4 is team camp and qualification, alignment, etc. But then page 34. But can I, Lord, skip this and request Lord to turn to Lord one directive Lord which they have produced as annexure R1 to their objection, that is objections of respondent number 4. Because Lord, there is a directive issued not by the government.
Respondent number 4.
Respondent number 4's objections, Lord, page 16, annexure R1.
Who is respondent number 4?
Lord, that is Federation.
Ajay, yes, R4.
Page 16, Lord, have it, Lord?
16.
16.
Yes. Yes.
Lord, this is dated 5th of March 2025. Lord, can I request the court to please turn to para 2. The revised instructions have been formulated keeping in view various development and experiences related to selection of athletes and coaches, judicious use of public resources and benefits available to NSFs and athletes, and with the desire to upholding the principle of objectivity, fairness and transparency in selection process with no scope for bias, so that no talented sports person is deprived of having a fair chance at the selection trials. 3. Instructions related to selection of sports person and coaches bar support staff are given as under. Selection of sports person. Selection of sports person participating in international events shall be the responsibility of National Sports Federation concerned in terms of selection policy bar criteria prescribed by NSF. The Government and Sports Authority of India will not have a direct involvement in the selection process. Selection of athletes should be done in a fair and transparent manner and in terms of the policy bar criteria formulated in advance. NSFs should have standard selection policy for all events as well as national camps if organized by NSF and any other events where selection of athletes is deemed necessary. This standard policy laying down selection norms should be uploaded in NSF website, and any amendments to the policy should be done at least 3 months in advance on the subject event. Selection policy by criteria should also be sent by email to all members of units of NSF and SAI. Not then, Lord, my Lord should turn to page 20, my Lord, of same. Para 5. But if the ministry bar SAI is not satisfied with the selection of athletes recommended by NSF on grounds of fairness and transparency, ministry reserves the right to approve participation at no cost to the government. As Milords are already seeing, Milord, the objections that they have filed. But can I just
What
show,
does
Milord,
this mean, Mr. Manmohan? Is not satisfied with the selection of athletes recommended by NSF.
it will approve, Milord, the participation, but government will not bear the cost. Now here, Milord, there is a situation of this nature.
Not satisfied with selection, the cost will be borne by the government.
Oh, that's right.
Athletes can participate voluntarily, my lord. Athletes can participate at their cost voluntarily. If they think that they can participate
Where
and
they
win the
said
medal.
selection is not
Athletes are representing the country. They cannot be doing on their own.
Yes, ma'am. This is a
That will be
safeguard-
chaotic.
safeguard
That is why we are asking if what is this will have to be explained by.
I think there are certain events, which probably India doesn't participate in. Like for example, snowboarding, etc. Now, for those things, if I want to participate, just for them, it's not related to this. So if I want to participate, say in snowboarding, India doesn't have a team, doesn't have a national sports body, etc. For snowboarding because we don't have snow regularly. So what do we do then? In fact, that's exactly what Surfing Federation did. We started.
Who appears for the Union of India? You appear.
I appear.
You will have to explain this. So this is washing off. If you don't, you're not agreeable to their recommendation, you can go on, but you will spend the money. What happens to a deserving candidate?
Then I'll have to seek instructions on this one.
You'll have to get instructions because this doesn't sound good, nor read good.
My
Yes.
instructions are very limited to the, so I'll respond.
You are.
I understand, I'll.
But as my lords are already seeing the objections, can I just show one more document before I go back to the petition? Lord, can I request not to please turn to page 86, Lord, annexure R12 in that objections. Not this, the fourth respondent not writes an email. I'm sorry, this is the Olympic Association. Lord, they write an email on 1st of July, 2026.
This is IOA.
Yes, Lord. They write it to
SFI.
SFI. This is reference to the communications issued by Ministry of Youth Affairs and Sports, letter dated so and so. Not, I'll skip that portion. Then after para 2, in compliance with the aforesaid instructions and based on final entries by name submitted by your federation participate in Aichi Nagoya Asian Games 2026. The entries have been jointly scrutinized by the Indian Olympic Association, the Sports Authority of India, and Ministry of so and so, with reference to prescribed eligibility and performance benchmarks. Upon scrutiny, the following athletes or teams have prima facie been found not to satisfy the prescribed eligibility criteria for inclusion in the Indian contingent. This is a statement not made by the Olympic Association in response to the names that is sent not by the federation. Now, my lord, please permit me to just show but what is that is then not responded to at page 88 by the federation.
Where is this annexure 1 list of athletes found ineligible?
Sorry, my lords.
Annexure 1 is a list of athletes found ineligible.
Not sir, reference.
Everybody except Mr. Kishore Kumar. I think, that I missed attaching that. There were a bunch of attachments. I missed attaching that. But it is everybody except Mr. Kishore Kumar. That is all the two women athletes as well as Shivraj, who is respondent number 5. In respect of them, they've asked for justification. That members have provided.
Who is Kishore Kumar?
Kishore Kumar is the first selected athlete.
He has been approved by the IOC.
Yes.
No, this one.
As of now, from the counter filed by the IOC, all 4 which have submitted have been. As of now, this was when I filed my counter on 20th of June.
Yes.
Lord, I'll skip the rest of it. Lord, I'll not trouble the court now. Please turn to page 88. The reply that is now given not by the federation. In response to what not at page 86.
The 1st July.
Lord, can I request the court to please turn to the part A in that email at page 88?
Yes.
The Shivraj Babu.
86.
My lords have it, Lord?
Just one.
Please.
Yes.
Lord, part A refers to Shivraj Babu. Please permit me to read this note. SFI wishes to place on record at the outset that it does have an athlete who meets the MYAS benchmark prescribed under letter dated so and so namely Mr. Ramesh Budihal, who won the bronze medal, third place of 48 competitors at Asian Surfing Championship 2025. Mr. Budihal is included in SFI's submitted list as a reserve athlete. I'm not, they say you don't have anybody eligible. These people say you have one.
Ineligible, and we have put them in
Yes,
reserve.
I have put in reserve. But this shows, Lord, how Lord I have been treated. But this doesn't stop them, Lord. What happened was my application, in fact, earlier also, Lord, this very year, I was not selected. In the sense, again, Lord, somebody else was given, this Shivraj Babu was given. I had filed an appeal before the appeal committee, pointing out these that the selection has not been done according to the criteria prescribed. In that, Lord, the order was passed by the appeal committee. Lord, can I request Lords to please turn to Annexure D, page 48 of the writ petition.
Yes.
The order is dated, Lord, 10th of June 2026. Lord, the relevant page is at page 61, para 22. Any other 55. Yes. In view of the panel, MYS directive dated so and so requires the Asian Championship benchmark to be a significant and mandatory consideration, but does not prescribe a fixed numeral weight or required it to be outcome determinative. The panel further notes that this issue could also be put to rest by seeking guidance from MYAS or resorting to relaxation of criteria in para 5. In view of the panel, detailed and substantial reasons would be required to be recorded in the event there is a deviation from the benchmark prescribed in MYAS directive dated so and so. The panel notes that this is completely absent in the SC meetings, minutes that have been placed before the panel. SC minutes also records the HC's presentation and voting, but very little in terms of deliberation and reasoning. The panel also considers it appropriate to record that primary objective criteria should be used and performance in Asian Championship given due weight. The panel debated trying to set out some form of weightage for this, but was unable to come to a definitive conclusion in this regard, and ultimately was of the view that it would not be appropriate to do so since MIA's directive dated so and so does not set out any numeral weightage. The panel further notes that a gut feeling cannot form the basis of selection, but this is precisely what they have done now, even after this order. However, the panel also accepts that given the knowledge, experience, and interaction with athletes by the head coach, his subjective decision could fairly be used in a situation when all objective criteria are equal and in order to break tie. Where reliance is placed on competition relevance, international readiness, medal potential, or similar qualitative factors, the SC should identify how those factors influence the final ranking. To merely say it is holistic may not pass muster of the standards required for any administrative decision under Article 14 of the Constitution. In addition, the minutes of the final SC minutes placed before the panel do not show actual comparison of data across athletes. The separate results of each athlete could have been compared against one another and evaluated numerally. The result would have been given a good criteria for selection. Absent this and merely saying that data was considered holistically would not only leave an athlete struggling to understand why he was not selected, but also make any objective review by way of appeal very difficult. The panel notes that the surfing is not a purely measurable sport and some degree of subjective evaluation by judges, coaches, and selectors is inevitable. However, where objective performance indicators exist, such as ranking, competition results, championship placings, and assessment scores, these should ordinarily form the primary material for decision making. Subjective assessments such as mental potential, suitability to anticipated conditions, competitive temperament, athlete mentality, or coaching judgments can legitimately be taken into account appropriately in cases where prima facie objective performance indicators are close. But all these observations, Lord, are made. Then, Lord, please turn to page 64, the final portion or directions. The respondent shall disclose to all participant athletes the minutes pertaining to reduction to competition squad as required under clause 5, module 3 of the selection policy. The respondent shall constitute a SC in accordance with clause 10 of the selection policy to retabulate and take a fresh decision. In doing so, the SC will give due weight to the performance in the Asian Championships and set out detailed and clear reasons if there is any deviation from this. All international events starting from 1/1/2025 shall be taken into consideration while making the selection. This order not has attained finality. But after this, the meeting is held at Annexure E on 20th of June 2026 by this federation.
The selection committee.
Selection committee. Now please turn to page 66.
Why is it called a special selection committee?
Because it is for the Asian Games.
Is the same as the other selection committee which is there, or there's a special selection committee constituted for?
Constituted only for the Asian Games. For every time we have to constitute a fresh selection committee because there will be conflicts of interest, etc. When I'm making my submission, I'll point out.
Yes.
Note that para performance analysis note is done at page 66. Para 5 note starts.
It's a public survey. I have produced the entire actual minutes.
So refer to his minutes. They are different for public consumption. They are different.
They are not there. I don't know Lord, how it can be done. But what is hosted?
Let us see what he is.
He cannot supply Lord reasons thereafter.
Page number?
It's page 45.
24 alva. 24 is
Page 45.
very well. Now page 40 to 8 June. But page 45, annexure R7. But at page 46, serial number 7 onwards. Page 46, not para 7.
Yes.
The committee extensively deliberated upon the methodology to be adopted for athlete comparison. Ms. Nitisha So-and-so raised concerns regarding the treatment of athletes who had participated in differing numbers of international competitions. Suggested consideration of alternative approach includes a possible drop-off mechanism. Mr. So-and-so advised that exclusion of particular events would inevitably introduce subjectivity and expose the process to criticism and possible challenge. He recommended that all available data be retained and that athlete performance be assessed through percentile analysis, which reflected performance relative to the field of competitors at each event. Following discussion, the committee generally agreed that percentile-based analysis provided a useful method of comparing athlete performance across different events and varying fields of competition. Members acknowledged that percentile analysis could assist the evaluation process while also considering other performance indicators and selection criteria contained in the policy. The committee further reviewed additional performance indicators, including podium finishes, international heat win percentages, advancement rates, best wave so-and-so, and clutch wave statistics. Mrs. So-and-so suggested inclusion of additional metrics such as best heat totals, average heat totals, etc. Lord, I'll skip that portion. Then, Lord, please turn to the page 48, Lord.
Yes.
Discussion regarding weightage of events. The committee deliberated upon relative importance of national and international competition performance. Ms. So-and-so submitted that equal weightage should be assigned because the selection policy prescribes no hierarchy amongst the criteria. Several members agreed that assigning equal weightage would be the safest and most defensible approach from the standpoint of transparency and consistency. The committee also discussed the directions issued by the appeal panel concerning the Asian Surfing Championship and requirement to accord due or considerable weight to performances at that event. Different views were expressed regarding etc. etc. Then para 23, no consensus was reached on a numeral formula for ASC weightage. However, the committee agreed the ASC performance was an important factor which members were entitled to consider during the overall assessment. Then Lord, page 49, Lord, they have categorized first not the Kishore who is there. Then at page serial number 32 is one Shrikant. Then not page 30, page 50, para 34.
Yes.
Principal discussion centered around Mr. Ramesh and Shivraj Babu. Arguments advanced in favor of Ramesh include stronger overall statistical profile, greater consistency, etc., etc. I'll skip that portion, or should I read it? This says not all the criteria, etc. Then para 36. The Ms. So-and-so expressed reservations regarding the averaging of percentile score where athletes had participated in different numbers of competitions, submitted that such methodology could potentially affect comparative outcomes. He suggested that alternative approaches and additional performance metrics may also merit consideration. Committee deliberated upon these observations together with different views expressed by other members regarding methodology and weightage to be assigned to various performance indicators and reviewed the available information before proceeding further. While committee acknowledged the relevance of percentile analysis, one of the available assessment tools, no unanimous consensus emerged regarding the methodology or the relative weight to be assigned to particular metric. Then page 51, note para 39. Mr. So-and-so resolution to off deadlock. Mr. Adil So-and-so advised, given the absence of consensus, the committee should formally acknowledge the tie and seek clarification regarding the applicable procedure for resolving such deadlock. Committee agreed that Kishore stands selected, Shrikant stands selected. A tie exists between Ramesh and Shivraj Babu for the second confirmed position and first reserve position. Committee shall reconvene after consultation with the relevant authorities and stakeholders. Clarification shall be sought regarding tie-breaking procedures and possibility of involving an additional member if required. Any final decision shall be taken collectively with all members present. Then, Lord, committee was para 40, Lord, they say that no, not to make public announcement regarding selections to maintain confidentiality, etc.
Yes.
But this was on this page 52, Lord. This, in fact, this minutes is actually dated 20th of June. If my lord should see page 52, it is shown as 24th of June 2026.
Meeting happened on that day. It was finalized on 24th.
Minutes were fine.
Minutes were finalized is what it shows, but what is uploaded not is slightly different from this because
that is a summary.
Summary, very well, but I don't want to get into those nitty-gritties.
No, then
But
there's
then
one
please
more.
then
Next day.
yes, I'll go to that. Page 53, Lord, is on 21st of June 2026. But here, notes, please turn to page 57, 55. But page 55, I'll not read it. Not it only talks about head-to-head comparison to be done at page 55. I don't think I'll have to read all these
Because there
things.
was a tie.
Because of the tie. But at page 57, para 26, again, they acknowledge Asian Surfing Champion performance not constitute important factor. Then voting process, para 27. After completion of deliberations, the committee proceeded with voting between two remaining athletes under consideration, namely so and so. Chair requested each voting member to state his or her vote together with the objective factors. Then para
Why don't you
31.
send both of them? If you are so.
Up to me, it's up to the IOA to decide, or and the Surfing Federation. I have a very limited role.
You expand your role now. and tell them you're getting good athletes. There's a possibility of 2 medal prospects. Why don't you send both? That lower, that is why we asked you. You'll have to explain that. You, you're working on a least common denominator. You can't work on LCM. You have to work on HCF. You have to see if how many good people are there to send.
There's already one that is selected. I think in the competition only 2 can participate. So it's for the second spot in the selected and then the reserve category.
Or
There's already
he
one
can't
who's-
participate. He can't participate in the event.
Can I
Only, I
just?
think only 2 can participate and 2 are reserved.
Because there are only 2 slots available, and those slots are won on a basis of overall performance of the country as a whole. 2 slots are available. Because I'll have a small list.
No heats or anything.
Melodies heats are there, domestic heats are there, ranking
Are
system.
there.
No, we have Melodies as a. I think Melody.
Yeah,
I don't want to
you
interrupt.
you
sir.
finish your.
Please. Lord, page 57, Lord, bottom refers to the voting done by one Mr. Shamanth selection committee. But he selects Shivraj Babu. The criteria, Lord, is at page 58. Serial number 32. Lord, I don't think I'll read all these things. May not be required, not for the present.
Even voting, there's a tie. Next, what is the process?
After this, what happened was, Lord, then there's another
Means
meeting
was a
held.
tie. Voting is a tie.
Voting is a tie. Lord, then at page 64, annexure R8, Lord, they seek for extension of time. I'm sorry, can I request Lord to please turn to page 61 before that, not?
Yes.
Page 61, the conclusion note that they arrived at para 55. After considering the discussions held and votes cast, the chair recorded that the committee remained deadlocked regarding the selection of the second athlete and first reserve athlete. Ms. So-and-so had verbally expressed the intention to resign from the committee. Guidance was sought from the Surfing Federation of India regarding the implications of the said resignation. Then not 4 views expressed by the members regarding possibility of a surf-off would also be communicated to Surfing Federation of India. The matter would thereafter proceed in accordance with directions issued by the competent authorities. Now, this was a decision taken, Lord, on 21st. But this is also not shown to be dated 24th. Probably the minutes are recorded, not all simultaneously. I don't want to get into nitty-gritties as to how everything was done on the same day. Then, Lord, please turn to page 66. 66, Lord. Annexure R9. On 22nd June, Lord, the Federation, Lord, writes to the Olympic Association. But one, Lord, I write in my capacity so and so. Squad is mentioned. Para 2, Lord, they say this submission is made in compliance with so and so, dated 5th of May, so and so, which requires no changes to be made to be submitted list after 23rd June 2026. Given the proximity of this deadline, I set out in full the procedural history that has been led to submission of federation selection, etc. Lord, they point out as to how, Lord, this selection has been made. Then, Lord, at page 69, para 10, on the totality of this record considered as a whole and not on the basis of single criteria, the Federation is satisfied the selection of Shivraj Babu for second confirmed position is justified, notwithstanding Mr. Bodihal's ASC 2025 bronze medal, which the Federation has weighed in the manner directed by the appeals panel, but does not consider on the complete record to be determinative of the outcome. To the extent that the benchmark prescribed under the ministry's directive dated so and so is engaged by this selection, the Federation respectfully draws the ministry's attention to para 5 relaxation clause of that directive, and out of an abundance of transparency request the ministry's concurrence on the basis of the record set out above. So they want to relax a lot of criteria so that Shivraj Babu is selected. And Lord, what is interesting is, Lord, I'll take Lords now back to the petition, Lord, document where the selection is made after this discussions, etc., and one of the members, Lord, resigns. But please then turn to page annexure H, Lord, which is at page 78 of my petition. So, full produce 23rd. ಅವ್ರು produce ಮಾಡಿದ್ದಾರೆ.
Yes.
But page 78, not after the summary, etc. Not, I'll not trouble reading all this. But please turn to page 79. But first para refers to the appeal, etc. I'll skip that also. Second para refers to reconstitution of a selection committee convened on 20th and 21st to reconsider the matter afresh in light of the panel's directions. Notwithstanding a full review of the objective record, the vote on men's second confirmed position tied. Neither the selection policy nor the appeals panel's directions prescribed any further mechanism for resolving a renewed tie at the selection committee level. The IOA's deadline for submission of name was not capable of extension. A further reconstitution of selection committee was considered and found not practical. An internal surf-off was equally considered and not found viable in the time available. In view of these circumstances, solely to ensure compliance with the mandatory submission timeline and to safeguard India's participation quota, the matter being placed before the council, SFI's executive council, not kindly note this, not by the selection committee. This is done by SFI's executive council. Took an executive call to finalize the selection of the complete record before it and submitted the names on the selected candidates to IOA together with the explanation on the basis of selection. That explanation is summarized below. My lord, one lord, how could the executive council select? Selection panel lord has to decide. So they were hell bent on seeing that lord, this particular person is sent. Appeal order lord is brushed aside. The directive of the central government is brushed aside. Then not page basis of selections, not please turn to at bottom of page 79. The federation
Page
79, same continuation, basis of selection.
Yes.
The federation has given due and careful weight to Mr. Ramesh Budhihal's bronze medal finish at Asian Surfing Championship 2025, a genuine and creditable result, and the only Asian Championship medal won by India, an Indian surfer to date. But I am the only one who has won till date. That is also recorded. Then, Lord, on review of the complete record since 1st January 2025, however, the Federation is satisfied that the totality of evidence supports selection of Shivraj Babu. With the following considerations to effectively break the tie between the two athletes after selection committee votes: national ranking, national and international direct record comparison of results, podium finishes and wins. On a totality of this record, considered as a whole, the federation is satisfied that selection of Shivraj Babu is justified, notwithstanding Mr. Budhihal's Asian Championship bronze medal, which has been weighted carefully, but it is not on the complete record determinative of the outcome.
It doesn't have a cost at least.
So first, Lord, the executive committee could not have selected. Policy says the selection committee. So the very
in future, we will only pass that order. You have weighed it carefully, appeal allowed, writ petition allowed, objections dismissed. What kind of an order is this?
I'll explain.
You will explain.
But I'm told on 24th they sent the name. This is not on 23rd, 24th they have sent the names. And in fact, it is uploaded much thereafter. Is this order, a public summary, is uploaded thereafter. Uploading this summary. But I submitted page 81. Not I submitted a representation, not to the authorities, not including the Olympic Association, saying that the injustice is caused to me, the policy, etc., the order, etc., is not followed. There is no response to this.
So even the first selected candidate is not a medalist. Only you are the medalist.
I am the only medalist, but Kishore Mlot is at serial number 1. He has been selected. I was now shown as not serial number 3. So first reserve.
Has Kishore won any medals?
No, he has not.
Yes.
And Lord, more importantly, from their own reply that they gave to Indian Olympic Association, I'm the only one, my lord, who complies with the criteria. So when I comply with the criteria, I'm the only one amongst all that I comply with the criteria. But I am made to sit as a first reserve. But they cannot supersede the criteria that is fixed by the central government. So they are bound to follow it. When the selection committee does not come to a conclusion, despite there being an order by the appeal order, which says this is how you have to do it. But again, they decide what is a yardstick. No, they cannot again change the yardstick. What is already fixed in selection policy and what was directed by the appeal committee, they were bound by it. But they again say, no, there is no consensus as to what we have to consider. And then, Lord, they come to this tiebreaker. And that is when, Lord, one of the selection committee members also resigned, saying this is not the way you can carry on with the selection process. But after she resigns, this decision is taken, saying that executive council will go ahead and do this.
She was voting in your, she had voted in your
Yes,
favor.
two people had voted in my favor. Two people.
It becomes 2-1 now.
Is not?
2-2 has become 2-1.
No, this is by the executive council.
Even otherwise
Yes.
it is 2-1.
No, then there was no selection committee. It has to be reconstituted. That has to be done.
Yes.
If I'm not on the face of it, not my submission is this complete non-application of mind. There is what is apparent is they have not followed the selection policy, nor the order, and not there is some kind of favoritism that is shown to somebody else instead of following the directives of the central government.
What has happened on this appeal that you submitted? Representation?
Nothing happened, Lord. I have not got any response.
Anything else?
Not Becca. It's okay. That is all.
Who will start?
Can I start? Just for the aid of the court, I made a short list of dates.
Yes.
Lords, asked the first question my lords had asked was, why is it that only 2 men and 2 women? My lords, that is explained in some detail in page number 92 of my statement of objections. My lords, were to just take my statement of objections, my lord.
Yes.
My lords, at the bottom of the page, my lords, see, this is an email sent by the Surfing Association. At the bottom of the page, respected sir, we write to place before you scrutiny, context, etc. My lords, find it. It's at page number 92, at the bottom of the page. My lords, India's 2 men and 2 women quota places for Asian Games 2026 surfing competition we earn through the qualification pathway set out in OCA ACF Memorandum of Understanding dated so under which ACF Surfing Championships 2024 and 25 together constituted recognized qualification events. SFI secured 1 men's and 1 women's place at each edition. 2024 ASC Tulusudu Maldives through top overall 7 ranking route and at 2025 ASC through regional representation as the highest ranked South Asian NOC in both categories. This is independently confirmed in ASF's own published qualification results based on. So, my lords.
So this was because of the Asian Surfing Championship, which was held in Mahabalipuram.
Yes,
in 25.
Yes.
So the qualification.
That is the exact reason I wanted to bring it.
The qualification for India to get two slots was because the petitioner earned the.
Not just the petitioner.
Then who else is?
What is the top 7 finish? Top 7 finish. Just there are 2 events. Can I just answer?
Did respondent number 9 finish in top 7?
My lord, respondent number 5, he was not allowed to participate in that event. That is the reason.
So the person who participated and who won a medal in that particular what is this championship?
Yes.
Who was the cause for you to get qualified to get 2 seats?
Yes.
2 slots.
No. My lords, again, I'm clarifying.
Tell us how you qualified to get 2 slots.
My lords, what I'm saying is that there were two events in 2024 as well as in 2025. My lords, we finished in the top 7 in both the events. Therefore, we got the slots. That's what I'm trying to say.
You finished top 7. Who were the people?
24 and 25.
who are the people who finished in top 7? Who are the athletes who were instrumental in finishing in top 7 in 24? Who are the athletes who were instrumental in
Melody,
finishing
I'll
top
give you
7
the Melody
in
insofar.
25?
Yes, I'll give the names. Melody, those athletes are not there in the except those athletes.
That is
None
why we
of those
want
four
to-
athletes are there in this.
That is why we want to know who are the athletes
Melody, I'll give the names.
who helped India achieve that.
Melody, I'll give.
And are they being given their due credit?
I'll
Or you are shifting it to somebody else after they did the hard work to qualify that?
I understood. Melody, I'll answer that. Melody may now take Melody the Maya circular at serial number 2. Melody.
Page.
Melody, that's at annexure R1, page 16. Melody.
If you have selected the people in the top 7 in both the places, there's no problem.
But Melody, based on current form. I'm on current form. I'll show the material for current.
Yes,
form.
please.
I'll show the material for current
Yes.
form. That is Melody, that is where I am.
Hmm.
Melody, this Melody is the criteria on the basis of which Melody. Before this Melody, can I just explain two other aspects?
Which page do you want us to take?
Melody, before I come to page number 16, Melody, just
16 of your objections.
statement of objection.
Yes. Before that, what do you want to say?
Melody, what I want to say is that surfing, we were constituted as an NSF only in the recognized by the government of India only in the year 2025. This, my lords, is the first time that surfing is being held as an Asian in the Asian Games, being held in the Asian Games for the first time that India is participating in the Asian Games. Now, my lords, for this purpose, we were governed by the 5th March criteria. Now, my lords, the petitioner is relying on a subsequent Maya circular, which he is saying is binding on us. My lords, that has not been read to my lords. This document, my lords, is providing the basis on which the selection criteria had to be formulated. I formulated my criteria based on this. I will show my lords why the appeals panel interfered with my criteria. That aspect I have to point out. That's why, my lords, if my lords were to see page number 16,
Yes.
lords, at page number 18, if my lords were to see, my lords, page number 18.
Yes.
Composition of selection committee shall be decided by the president of the NSF. Selection committee should ideally be headed by high performance director, chief coach, foreign former international player, etc. Sports persons of outstanding merit who must have retired from active sports. Selection committee may include, among others, coaches, SOM, ex-international player, members of executive committee not more than 2 on rotational basis as nominated by the president/NSF. Then, my lords, based on this, my lords, I was supposed to formulate my selection criteria. My lords may now take the selection criteria which I have formulated, which my lords will find in the in annexure, my lords, annexure B.
Page.
The writ petition, my lords. Annexure B in the writ petition.
Page.
My lords, page 31, my lords.
31 is your selection policy. Yes.
Selection policy. Yes. No, my lord, this, my lords had asked a question. Why is it a special selection committee? My lords, recollect, my lord had asked a question. Why?
Yes.
That is because, my lord, this selection policy has been formulated for the 20th Asian Games 2026 itself.
Yes.
My lords. Then, my lords, there are two aspects which I want to just point out, my lords. In point number 5, my lords were to just take for a minute. As of 30th of September 2025, top 8 men and top 8 women in the SFI rankings shall form the selection pool. So, my lords, how I start the process is, I have a ranking system, which ranking system is based on, my lords, domestic performance in competitions across India, whatever points they score. My lords, what happens is that for first place, 1000 points, second place, 860, third place, my lords, 700 change, then 500, so on and so forth. So that way, my lords, I have been maintaining rankings.
So who are the top 8 men?
My lords,
not concerned with the women now.
My lords, I produced a ranking. May I just show my lords the? I'll just show it. Just 1 minute. My lords, I have produced it from 2022 onwards, my lords, at annexure R13. My lords, have annexure R13, my lords.
Page. Unless you tell us the page, we won't have anything.
Sorry, my lords. Page 95. Page
90?
95. My lords, this is of 2022. My lords have 2022.
Yes.
My lords will see Ramesh Budihal is at 2000.
He is number 2.
He's number 2. My lords, then my lords, Shrikant, who's the 4th reserve athlete, is at number 7.
Where is respondent number 5?
12. And my lords will see Kishore, the first rank athlete, is not there in the top 10, 15. He's not there in the top 10.
Yes.
He's there in serial number 14. My lords have that. My
Yes.
Now, my lords, please turn over to the next page, my lords, which is, sorry, page number 100, my lords. My lords have page number 100.
This is 23.
23, yes, my lords. My lords will see in 23, Shrikant is number 1. Ramesh Budihal is number 2. Kishore Kumar is number 3. Shivraj Babu is number 4. Shivraj Babu is respondent number 5.
Yes.
My lords, next year, my lords, 2024, my lords, page 105. My lords will see Ramesh Budihal is 1.
Petitioner number 1.
Petitioner is 1. Kishore Kumar is 3. Shrikant is 4. Shivraj Babu is 6.
Yes.
My lords, now 2025, my lords. 2025, Kishore Kumar is first, Shivraj Babu is second, Shrikant is third, Ramesh Budihal is fourth. Then, my lords, 2026, my lords, I have the updated 2026 results, which I, my lords, had filed along with a memo. My lords, may I just take that memo for a minute, my lords?
You filed a separate memo.
Sir, I filed it on the last date, my lords. My lords, I have the, well, can I just pass across?
Sorry.
Input.
Adena,
This is as updated as of yesterday. I'm just giving it so that my lords have a.
we don't need it as of yesterday. We want it as
Then, my
on
lords,
the
2026.
date of the meeting.
My lords, that page 114.
Don't give us anything after the meeting.
My lords, page 114. Page
Yes.
114. My lords have page 114. Man.
Yes.
My lords will see Kishore Kumar is first jointly with Shivraj Babu, who's respondent number 5. Both are jointly first. Shrikant, who's the second reserve athlete, is third. Ramesh Budihal is fourth. Is being relied on, the ministry circular which is being relied on by the petitioner, my lords. My lords will find that at page 43, annexure C1, my lords. May I request my lords to come to page 44.
Just a minute. Annexure C, page 31.
Annexure C1 at 43 minutes. Annexure
43.
C1 at 43.
Yes.
My lords. My lords, may I request my lord to come to page 44 in that.
Yes.
My lords, paragraph number 4, benchmarks for individual sports and events and team sports and events. My lords, surfing is a non-measurable individual sports and event, my lords, because the marking is subjective.
Yes.
Where senior Asian championships are held within 12 months preceding the upcoming Asian Games, the world rankings are promulgated regularly. NSF will be eligible to nominate an athlete either in a weight category / event. Athlete has achieved 6th or better finish in that category event in the last 12 months held in the last Asian Championships held in the last 12 months, or his world ranking is among the top 6 Asian nations in international rankings as of 10 days from a submission deadline of final list finding. So therefore, my lords, I have the right to select automatically, my lords. I don't need to even follow selection. I don't need a selection criteria. Without even a selection criteria, my lords, directly, if under this circular, I am eligible to nominate the petitioner, if I so choose, because that is what the
You are the all in all.
I'm sorry.
You are the all powerful. We understand. Yes, let's go ahead.
My lords,
we have put you on notice earlier. Without the athletes, you are nobody. Don't try to be overrun above the athletes. You are only to maintain decorum. You are only to maintain discipline. You are only to maintain that things are done in a proper manner. You are only acting in a managerial capacity. Nothing more, nothing less. Don't try to say like this that I am entitled to do whatever. That is not something that will be tolerated by this court.
I apologize. I apologize.
As simple as that.
I fully.
Without them, that's why we asked you, who are the 7 people?
I'll
He is
give- I'll-
the only reason why we are hearing so much on this is because he is the only bronze medalist. Nobody else has got any medal. And you are treating a person who was the reason for you to get the slots.
He is not the reason, my lord. It's a team event. My lord, my lord,
Show us the names, Mr. Ajay.
I'll give the names.
Show us
My
the
lords,
names.
on that aspect, my lords, by tomorrow morning, my lords, I'll give the names. I'll file whatever.
Show us the names.
I'll give them. Yes.
Asian Games happen once in 4 years.
Yes. Yes. My lords, now, my lords,
Can I
may I request my lord to kindly see page 45, my lords.
Yes.
Relaxation clause. If, in the opinion of the experts of specific sports disciplines and SAI, participation of individuals and teams in relaxation of the above criteria is recommended with justifiable reasons, same will be considered in the ministry for an appropriate decision.
Experts of the specific sports discipline,
Yes.
not by the executive committee.
Yes.
Your experts.
My lords, I have not taken the. I have made a request. That's all. I made a request.
Your experts, there's a tie. So what is the procedure in a tie?
My lords, I'll address that. I'll address. My lords, can I just take my lords back to the selection policy again, my lords, because this was subsequently modified. What my lords, what Mr. Manmohan read was subsequently modified. But the reason why it was modified was because
When was it modified?
My lords, it was modified by way of an addendum, which my lords will find at page 37, which was issued on 16th of May 2026.
When was the selection made?
June.
When the tie and everything happened after the appeal order.
No.
When was the appeal order?
My lords, appeal order 16 June. Appeals order 16 June. My lords will find that at serial number. My lords will find that at serial number 16 in my 17 in my dates. My lords have serial number 17 in my dates.
When is the appeal order? June 26.
Yes.
Yes. Where is the modified?
My lords, my lords, can I just take my lords quickly through the dates? I'll explain. In dates, I'll banbide. May I request my lord to just take the dates? My lords, serial number 8, if my lords were to take, my lords. My lords, once I issued the selection criteria, my lords, there was a process in which I had to follow. My lords will see the dates, etc., which are given in the. My lords, in the policy itself, I have written the dates, etc. My lords, I am supposed to do some things by a particular date. My lords, module 2 by 31st of March. Then, my lords, ranking, etc. Then
where are you reading? What do you want us to say?
My lords, what I want to say is that thereafter, the IOA issued a communication, which my lords will find at annexure R2, wherein they said that we have to complete
page number.
R2 is at page number 21. My lords.
Whatever you want to refer, please tell us the page number.
Yes. R2 is page number 21. My lords have page number 21.
Yes.
This is with reference to the IOA email dated 5th May regarding the final entry by name for Asian Games. Indian Olympic Association is pleased to share the final entry by name form. All concerned federation are kindly to fill up the entry by name form and send it back to IOA with the ideal certificate on or before 10 June for onward submission to the organizing committee. It has been confirmed, etc., by the Asian Games organizing committee that the final selected athletes must be included in the accreditation long list. If selected athlete is not included in the ACR long list, his entry cannot be submitted. Therefore, federations are required to ensure that the ACR long list is duly considered before finalizing the entries. It is confirmed by so and so that there will be no entries or changes to the existing entries after 23rd June. Therefore, IOA will not be able to add or modify entry on behalf of the federations after the deadline. Therefore, we should do everything by 10 June. Based on this, my lord, I was forced to issue an addendum. Now, my lords may take the addendum which was issued by me, which my lords will find at page number 37, my lords. My lords have page 37 of the writ petition, my lords.
Of the writ petition?
Writ petition, yes. Writ petition, page 37.
Yes.
My lords, it says, recitals, my lord. Whereas IOA has official communication dated 5th May notified the SFI of the following directives. Final list of athletes selected for participation can be submitted no later than 10 June. That after 23rd June, no changes shall be accepted, etc. Now, based on this, my lord, I amended the selection module, which my lord will find at page 38. First list of 2 male athletes and male reserves and second list will be submitted no later than 5th June 2026. Changes, if any, to the selected athletes will be made no later than 20th June. Then, my lords, selection of the athletes shall be made on the basis of the following data and criteria, which are listed in no particular order of priority or weightage. Rankings from the National Surf Series 2026 as of 1st June 2026, counting all competition results in 2026 with no drop-off events. Data and assessments from national coaching camps, selection camps conducted between 22nd September 25 and 15 June 26. Results and performance at international competitions during the relevant period, if any. So, my lords, I modified what my lords see there in the original criteria, my lords, that stood modified.
What is the modification?
The modification is that, my lord, I am taking into consideration 3 factors. First factor that I am taking into consideration is the rankings in the domestic series.
And that is what it is as of 30th September 25, top 8 men and top 8 women.
No, my lords. Yes, that was initially for the cause. That was only for the.
So 30th September, you have taken 1st June 26.
Yes.
Data and assessment from national was also there.
Your Lordship, one submission, Your Lordship. This aspect of the matter is already been discussed in appeal, Your Lordship. Page number 55 of my writ petition.
I'll show that also.
Yes.
It's reasoning. What the
You can make your submission in your reply.
So therefore, there are 3 criteria which have been considered by me.
Yes.
Based on these 3 criteria, my lords, I carry out selection. My lords may now take annexure R3 at page 24, my lords.
Yes.
My lords, this is the minutes of the first selection meeting, my lords, on June 3rd, 2026, which was subsequently set aside by the Appeals Council. My lords, in this, my lord, please see the analysis, etc., has been done in terms of what was discussed, what is shown in the addendum, which my lords will find at page 25, 25 onwards, my lord. They have done some level of analysis on how exactly it has to be done. Then, my lords, the voting, my lords, will find at page 26. Now, my lords, if my lords were to see the constitution of this selection panel, my lords, this was not in accordance with my own selection guidelines. Page 24, if my lords were to see the attendees, my lord.
You have 4 of them from the executive. President, Director, General Secretary, Vice President.
My lords, that is not the problem. The problem was that they didn't have a vote. The issue was that they didn't have a vote. That, my lords.
As per your own policy, it was only 2 executive members. Rest of them have to be experts.
Rest of them are experts.
You have 4 of them here in this committee.
Yes. My lords, the committee member means, my lords, committee member means selection committee member. It's not committee of executive.
The designation is President, Director, General Secretary,
Yes,
Vice
lords,
President.
First 2, my lords, are the members of the executive council. They can be there. As per the Maya circular, they could have been there. But as per my selection policy, they could not have been there. That is exactly the reason why the appeals panel, my lord, sets it.
You have expressly violated it, is what we say.
Yes, it is violated. My lords may now take.
This again gives the same impression that the executive is trying to.
My lords, I fully follow what's
next.
There is one other aspect, my lords, on which the petitioners have not been candid, which is that the person who is resigned is from Surf Kerala Association, which is the petitioners association, and I'll show the minutes. What was not read, I'll show my lords that.
Yes.
Please, my lords. Now, my lords, may kindly take the appeal order, which my lords will find at page 48 of the writ petition.
Yes.
My lords may take at page 57, paragraph number 13, my lords. Ex facie, this violates the selection policy and vitiates the decision taken. 8 votes have been cast when the selection policy only provided for 4 votes. HPD and ethics advisor being non-voting members. This is not a mere error in reasoning, but goes to the identity of the decision maker itself. When the selection policy prescribes the composition of body entrusted with selection, and compliance with such composition would be a condition precedent to the exercise of power to select, the decision taken at this meeting should be set aside and the matter considered by SC constituted in accordance with clause 10 of the selection policy. Panel considers it has the power to issue such a direction to the respondent in terms of its power to order retabulation. Retabulation can only necessarily be performed by a body designated by selection policy. So on this ground, my lords, it is set aside. Then, my lords, on the aspect of what should be considered, what are the criteria to be considered, my lords, the appeals panel modifies my selection criteria. That I'll just show you how it is modified. My lords, paragraph number 16, my lords.
Para?
16, paragraph number 16.
Yes.
The next issue to be considered is what is meant by relevant period in the addendum. The addendum specifically requires that the results and performance at the international competition during the relevant period are taken into account. The panel finds that the relevant period is not defined in the selection policy. The last Asian Surfing Championships was held in August 25, and the relevant period must necessarily include this event. The panel further understands that international bodies such as the International Surfing Association and the Asian Surfing Association run their events on a calendar year basis. Further, the selection policy itself prescribes the use of events from 2025 as the first step in the process to determine the selection pool. In right of the above, the panel is of the view that only fair interpretation of this relevant period would be the relevant period should commence on 1/1/25. This would give SC the ability to consider all international events for a full calendar year plus 6 months preceding the selection. This interpretation would also mean that ensure that no athlete is unduly disadvantaged by non-participation in an international event owing to causes beyond their control, as the data set will be sufficiently large to account for such absence. The aforesaid interpretation of relevant period also ensures that the Asian Surfing Championship is taken into consideration, ensures that the selection policy is intra-vires the Myers Directive. It is settled principle of interpretation that to the extent possible should be interpreted in a manner so as to avoid making it ultra-vires a binding statute or directive that sits above it in hierarchy. Absences from international event could, by way of example, be accounted of using a drop-off method. If there are a total of 10 events and athlete A has participated in 9, B in C, C in 7, and D in 6, this means that all athletes have competed in at least 6 events. Therefore, a drop-off performances of each athlete from the data set could be made. For athlete A, this means that drop off 1 of their absences and 3 worst results. Athlete B drops 2 of their absences and 2 of their worst results. Athlete C drops 3 of their absences and worst results. D drops all their absences. This method avoids the need to discount entire events from the data set solely on account of athletes' participation, while simultaneously permitting strong performances by other athletes at the same events to count towards their overall assessment. The result is an equal number of events considered for each athlete, rendering the data set objectively comparable. The issue of Myers Directive dated so and so is taken up. To be noted, it is issued to all NSFs recognized by the ministry and is consequently binding on the respondent. Selection 2 of the policy makes it clear, makes such directions for Myers binding. One thing is absolutely clear from the directive that the performance of the Asian Surfing Championship and in particular a top 6 finish is relevant criteria to be taken into account. The last question that needs answering is whether a top 6 finish in the Asian Surfing Championship entitles an athlete absolutely of selection. If not, what is the specific weightage to be given? The wording of Myers Directive is somewhat ambiguous. The panel notes Asian Surfing Federation's qualification pathway only determines the number of quota spots provided to each Olympic association, not the individual selection of athletes to be chosen for these quotas.
Yes.
This, my lords, is the reason what it was a team quota. That was what I was trying to point out. That was it.
But who was responsible for you to get that quota?
My lords, I'll explain. Para 2, my lords, my intention, my lords, is to get the person who is best suited to get a medal. If I'm able to demonstrate before that.
So far, you have not been able to. We are still hearing.
Yes, my lords, that is the, my lords, I have not yet gone to on the aspect of how performance has to be evaluated. What we said, I'll show that. Para 2 indicates the overarching intent and purpose of Myers directives is to ensure selection of athletes who have the best chance of getting a medal. This must be borne in mind while interpreting any ambiguity. Para 3 provides that participation in multi-sports events shall be primarily guided by qualifying benchmarks. The use of the word primarily indicates the qualifying benchmark is not only criteria but of considerable weight. To be noted, Myers directive itself does not provide any numerical weight to be given to qualifying benchmarks prescribed. Para 4.12a is the applicable portion for surfing, which would be a non-measurable sport as results are by judging and not reduced to any fully objective benchmark. This relevant portion of the paragraph provides that the NSF will be eligible to nominate an athlete, either in weight category, event category, if the athlete has achieved a 6th or better definition that category event in the last issue. This phrase is capable of being read as identifying benchmark performances that presumptively establish eligibility and medal potential. The language does not expressly state that the athletes who do not satisfy the benchmark are ineligible for nomination, nor does it prescribe any consequences of non-compliance. Usually when intent is to exclude, negative or stronger language will be used, such as shall not be eligible or only athletes meeting the benchmark shall be nominated or no athlete shall be nominated unless. Paragraph 5 is a relaxation clause that allows criteria to be relaxed based on opinions of experts and side. This again indicates that the benchmarks is not the determinative factor. Para 8 provides that Asian Championships conducted within 12 months prior shall be considered for determining eligibility. This makes it mandatory that the Asian Championship results are to be taken into account, taken into consideration, but does not again say it should be the determining factor. Purposive interpretation can be used when language is ambiguous or literal interpretation leads to absurd results. The ultimate intent of the Amayas directive is to ensure that the athlete with the best chance of a medal would be selected. If the top ranking athlete missed out on Asian Championships, say through injury, would he be excluded from consideration from Asian Games? Would Mayas desire such an athlete to be excluded? Would this in any way further the prime objective of choosing the athlete with the best chance of a medal? The panel is of the view that the answer to all of these questions is no. This is what I'm emphasizing on to say that there is absolutely no doubt that the petitioner is among the top surfers in the country. But as of current form and his participation in all the international events, if cumulatively taken together, what my learned friend is.
Unfortunately, that is not what the experts have said. We would have agreed if the experts have said that. You would not get into the decision. Decision is yours. Only we are concerned about decision-making process. Here, the decision was not made by the expert. It was made by the executive committee.
I'll explain. That aspect, I have to address.
That is what we have been asking you from that time.
Should I just address what is? I'll just leave this. I'll answer that first. I'll come back to this. I had to submit the names by 23rd of
time is irrelevant. The process that you have to follow, decision-making process is relevant.
Yes, sir.
Because the time is not there, I'll send somebody is not the answer that we can
that's
expect.
not what I'm saying. No, what I'm trying to point out is that 20th and 21st, 2 days they sat and
We'll be hearing you till 4:45 and then we'll say it is 4:45, time is over, therefore we are allowing the petition. Is that what you want us to tell?
I'm not saying that.
That is why don't take, you show us that your decision-making process has complied with the requirements of your own policy. As amended by you, subsequently the appeal committee has told you what to do. Have you complied with that? So far, it doesn't seem to be. So show us that.
Yes, I'll show. My lords, this aspect, why I'm bringing it out to my lord's notice is that I'm trying to say that overall cumulative number of results, international events, the petitioner has in all the international events in the relevant period, petitioner with the exception of Asian Surfing Championships, every other event he's been eliminated in the first round, whereas other athletes have done better.
Show us the consideration, Mr. Ajay.
My lords, I'll show them. My lords, I have to. My lords, the factual aspect is a little complicated. That's why I'm just bringing everything on record.
We are only concerned with the decision-making process, not the decision. We are in 226, 227. If your decision-making process is flawed, it goes out of the window.
Yes.
If your decision-making process is proper, we are not concerned with the decision.
My lords, may then just take page number 45 of annexure of my statement of objections.
Yes.
My lords, once the appeal panel was ordered to be reconstituted, we brought in 2 new people and we removed the rest of them. My lords, may just see the composition for a minute, my lords.
And now you made it coach, surf coach, senior judge, surfing federation,
yes,
athlete representative, high performance director,
yes,
ethics and legal. Now it is more proper.
Yes, my lords. This Nitisha Setia, my lords, she belongs to Surf Kerala Association.
Who appointed her?
Well, I only. I'm not.
Then
I'm not.
you can't. Then if you take up that contention, your panel itself is wrong. So we cancel the panel.
I'm not saying that. What I want to say is that I told them how to there is a procedure given for elimination of tiebreak. That elimination of tiebreak procedure was not followed by the selection.
What is the elimination of tiebreak procedure?
My lords, please see, my lords.
As per your original policy, it
yes,
is
head
off, what surf off.
Just one. No, my lords, it's not surf off. My lords may just take page number 32 in the writ petition, my lords. 32 in the writ petition. My lords have.
Ties at number 8. Head to head 2025 and best, highest best, second best, coin toss in presence of SC and recorded on video. That is what is the ties.
This is what is prescribed here, my lords. This is what is the prescribed. Now, my lords, on 20th of June, what happened is that they were not able to arrive at it. They arrived at a tie. They asked me for guidance. My lords may now go back to Annexure R7, my lords.
Yes.
Please see page number 62, my lords. Now, page number 62. They asked me for guidance. I wrote back to request for guidance from the committee, which has recorded a tie of the votes in the men's election select position, consequently men's first reserve, following the appeals panel's common order dated so and so. This note is intended to purely provide guidance and not a direction to the committee. Selection committee and its reasons for it remain entirely that of the committee, to be taken by the voting members, recorded in its minutes. And in applying for guidance below, committee should keep in mind its underlying purpose and these requirements go from the selection policy, binding order dated 6 June, Maya's directive dated so and so, and govern whatever method. Objective data is primary. Objective performance indicators should form the primary material for decision. Subjective assessment is permissible only when objective indicators are genuinely equal, and where used, its specific basis should be recorded. Asian Surfing Championship. ASC performance must be expressly considered as per this order. However, it is not outcome determinative and carries no fixed numerical. Reasons for any deviation. If the committee's decision results in an athlete who has met the ASC benchmark being placed below the selection line, then that is a deviation which requires detailed and clear reasons to be recorded. Full relevant period, all international events from 1st June 2025 to be taken into consideration. Then step 1, resolve on objective data first. The committee should first seek to resolve the position on objective cross-comparable performance data compiled and recorded athlete by athlete. As a results, ranking and related data and such as percentile finishes, event wins, podium finishes, head-to-head placings are generally regarded as more objective than heat or wave specific scoring, which depends on particular judging panel, wave conditions and weighing scales, and is therefore less directly comparable across athletes. Whichever way the committee decides, the decision should be reached and is justified from an objective standpoint. Reliance on more objective categories of data referred to above is accordingly suggested. No specific numerical weight or scoring formula should be assigned to any criterion, including the ASC. Appeals panel has declined to fix any weightage since Maya's directive prescribes none, and doing so now would invite a fresh challenge for arbitrariness. ASC 2025 should be expressly considered as one important objective input, considered along with the full body of objective data, rather than separately weighted data and determinative criteria. That not all athletes should compete in the ASC due to limited per country entry does not diminish the weight due to an athlete who did not compete in the medal. If the committee's assessment places the ASC medalist below the selection line, it must record detailed and clear reasons explaining why the fuller body of objective work outweighed the ASC result. If step 1 produces no clear outcome, position is decided, committee should record the comparison, its reasons, and need proceed no further. Step 2, apply the policy's own tie-break sequence. This, my lord, is what I read out there, my lords.
Yes.
Then, my lords, record. Then
is that being followed?
My lords, that is
your own policy's tiebreaker is not being followed.
My lords, that is not followed by the selection committee. My lords,
selection committee, is there a
delegate?
Where is the recommendation by selection committee?
My lords, that is there. Please see. My lords,
your final recommendation is by the executive committee.
No, one second, just one. Please 1 minute, my lords. Let me just read what exactly happened, my lords. Please see. Now, my lords.
While at this, you've been wanting to read. There are a lot of people waiting. We also have. You had time limit of what IOA's deadline. We also have deadlines. Now you tell us where is the recommendation by the committee? Where are the names of the recommended by the committee?
My lords, may I just take page 36 for a minute, my lords?
Yes.
My lords, before that, my lords, can I just request my lord to take page number 60?
First, answer our question. We have heard you so much. We have read all the mails, but you are not answering any of the questions.
Page 36.
Yes.
Page 36.
Where is the, again you are going to this. We are asking you the committee's recommendation. Where is the recommendation?
Committee said we will not committee sent the matter back to us, and if they fail to do so under the selection policy, I have the power to do so. Page 36.
Page 36. Yes, where does it say?
My lords, SFI reserves the right to amend, update, or unforeseen external circumstances.
This is amendment.
My lord, this is my lord, what has happened here is that
Mr. Ajay, please answer the questions that are asked. You can argue thereafter.
yes,
Three questions that we have put across till now, which have not got any answers, are number one, show us the compliance with the policy. Two, what is the policy as regards the tie break? You have shown us that policy. What is it that followed as regards the tie break? You have not shown us. Two, what is the recommendation by the selection committee which has been constituted? Now finally you said that there's no recommendation. Three, now you said that when the selection committee does not recommend, your executive committee has the power to do so. Show us from your policy where is that power of the executive committee?
my lords, to answer the first question, we recommended to the selection committee to follow a particular system.
You don't need to recommend anything. The policy is there. They have to only follow the policy.
That is it. They didn't apply it for reasons best known to them. They didn't apply it. Now, because they didn't apply it, I was at a situation where, my lords, either I had to not send because
Show us your powers from the policy.
my lords,
Where is your power to do that?
yes,
Not because you want to do it is different. You may want to do a lot of things. You may want to get all the medals in Asian Games. That is want. How to do it is as per your policy. There has to be, you have used the word transparency 100 times in all your correspondence. The transparency has to be shown from your policy.
can I just request for one day? I'll get all the answers on that aspect, my lords, on that one issue, my lords, tomorrow.
We have spent 1.5 hours on this. People are waiting for other matters.
Then just 2 minutes, my lords. I'll just point out two aspects, my lord. After that, my lords, I'll leave it.
You get back to us tomorrow because you get back to us tomorrow, but be brief on only on this decision-making process. We don't want you to be saying what all you do and all. You are SFI, everybody knows. There's no doubt about it. But as SFI, that this one is in, with great power comes great responsibility. You're powerful, but you come up with responsibilities. So that responsibility, have you discharged or not, is the question that we are asking. And these are issues relating to the athletes. And if you don't support them properly, they have to come to court. This is not, they are better to be there surfing, not surfing on the sea or wherever, not in the courts. If you do your thing properly, they don't need to come to court.
I follow. I'll address my lords.
If we find it lacking, we don't know what we can do with this one, but we'll definitely be taking action. Heard further arguments of Sri P.N. Manmohan, Learned Counsel for the petitioner, and part arguments of Sri Ajay Nandalke for respond number 4. He seeks for a day's time to get ready and answer the questions posed by this court today. Relist tomorrow at 2:30 p.m. Please.
Serial number 2, Vivek Holder.
Yes, Mr. Rohn. Mr. Ajesh wanted to make. Notes, Cody. Which petition do you want us to take, Mr. Ajesh? Give me one. 40364.
40364, man.
Notes, Cody. ಸ್ವಲ್ಪ ನೋಟ್ಸ್ ಇರ್ಬೇಕಲ್ಲ. Yes.
Please, madam. Lord, in this.
Why is this different from the others?
Yes, my lord. My lord, in this writ petition, we are challenging the report submitted by the second respondent. The second respondent being the conservator of forests, chief conservator of forests. The report is at Annexure N, page 219, dated 27/6/2013, where the finding is at ink page 223.
219.
Yes, ma'am.
Yes.
The finding is at ink page 223 to say that except 56.10 acres, the extent of land 600 odd acres is a reserved forest. The circumstances leading to this particular order, if I may be permitted to give a little background, my lord.
Yes.
My lord, in the first instance, there was a writ petition before the learned single judge, which is at ink page 48, Annexure G.
This is Bopana judgment.
Yes, my lord. My lord, in that, my lord.
48.
48, my lord. Yes. That, my lord, at page 84, that is running page 84. I'm only focusing on the aspect of the nature of land, my lord. Page 84. That is from the fourth sentence. There was a observation or finding by the learned single judge that apart when the lease deed dated 27/10 to 1913 itself indicates in the indenture that what is demised is reserved forest land, and without there being any other material to indicate that the tree growth has been removed by payment of timber value and that the property has been brought under cultivation, it is difficult to assume as to how it was shown as Paisari as on 24/11/1913 and immediately thereafter as redeemed Sagu. So this was the basis for the learned single judge coming to the conclusion, which, my lord, the eventual finding of the learned single judge is that page 1, running page 121, prayer 1.
Page?
121, my lord.
Yes.
Yes, ma'am. The orders dated so and so, respectively to the extent of declaring of the land in question is upheld, and it is affirmed that the said lands are parcels of the reserve forest. My lord, as against this, my lord, the petitioner before my lord went before the division bench, which is at ink page 124. Ink page 124.
Yes.
And at para 3, my lord, at ink page 126, if I may read, my lord, ink page 126, para 3, it is not in dispute that the learned single judge has granted the relief to the petitioner. However, appellant aggrieved by the portion of the order holding that the land involved in the present writ appeal is a reserved forest has preferred this appeal. In all other matter has been remanded to the concerned authorities to consider the matter in detail. Therefore, whether the land in question is a reserved forest or lost its character and has to be considered as a non-reserved forest can be determined by the authorities concerned by considering the material that may be placed by the appellants, and the counsel for the appellant as well as the government advocate has no objection to refer the matter to the competent authority to consider this point. In view of the submission, this appeal is disposed of by granting liberty to the conservator of forests to hold an inquiry in regard to the nature of the land in respect of the land in question in this appeal. This point shall be adjudicated by the conservator of forests within a period of 3 months after giving an opportunity to all parties. My lord, in this background, one of the contentions which I am taking before my lords is that the conservator of forests who had passed the impugned order, he was the person who had filed the objections in the writ petition, which is at ink page, connected writ petition, which is at ink page 128.
Which connected petition?
My lord, that is writ petition 4706 to 4710 of 2013.
4708.
Yes, my lord.
Serial number?
I'll just give, my lord. This page 128.
Page 128 of?
My writ petition.
This one?
Yes, ma'am. He has filed his statement of objections in writ petition 4706 to 4710 of 2013. Please see page 192, my lord. We have taken a contention of apparent bias. In page 192.
This is an objection filed by
the chief conservator of forests who had passed the impugned report. So we say that there is apparent bias.
Just one.
And his affidavit, my lord, is at ink page 192.
Just one. Page number?
192, my lord.
192.
Yes, ma'am.
This is
Mr. Brijesh Kumar Dikse,
Chief Conservator of Forest.
Yes, ma'am.
During that time, it was Chief Conservator of Forest or Principal Chief?
Chief Conservator of Forest.
So he is the topmost authority.
Yes, ma'am.
That time it was CCF.
No, for that particular region.
PCCF was, the region is CCF. For state, it is PCCF.
Yes, the head of the
For that
forest is PCCF, HOEF. PCCF,
Yes.
HOEF is the head of the forest.
What is HOEF?
Head, they are designated by that, this one, Lord, amongst all the PCCF, Lord.
There are multiple PCCF.
Head of forest force.
There are multiple
PCCF, yes, one for working division.
In 2013.
Yes.
Because this is all the new nomenclature came subsequently.
No, even then the PCCF
2013 there was a PCCF.
Yes, he was for that particular region as CCF.
So Madkeri region was CCF.
And in this background, please see the order, my lord, just for a moment. Ink page 223.
Just one.
It's by the same Chief Conservator of Forests. Ink page 223.
Ink page?
223, my lord. 220.
But he was the Chief Conservator of
Yes,
Forest at that time.
Our submission is that there is apparent bias. The person who has filed the
But the
objection.
objection you could have taken when.
We have taken.
You could have taken when the division bench passed that order
My
directly.
lord, we had filed an interim application, as I understand, before the division bench. But in the meanwhile, the order came. I'll show to my lord.
Because the division bench directed the CCF to conduct the inquiry.
My lord, the
You
division
are
bench
aware of
says shall be adjudicated by the conservator of forests within a period. It's not identified a particular person. And I would.
By the conservator of forest,
Yes.
not the chief conservator.
Yes. My lord, my submission is focused on the following, my lord, principally. One is the failure to follow the procedure as complied, as directed by the Honorable Court. That is one. The second is, my lord, that the authority had requested for certain documents to be furnished. I'll show my lord the date. And they did not comply with the said order and proceeded to pass the final impugned order. That's the second. Third thing is, I say that there's apparent bias. The fourth, my lord, is I say that there's constructive res judicata and issue estoppel insofar as what the earlier matters which they have not challenged the order of the learned single judge. My lord, my submission is prefaced on this, my lord. the British administration, my lord, created this Imperial Forest Department in 1864. And my lord, the first time they wanted to regulate these forests, so they enacted, my lord, the Indian Forest Act of 1865. My lord, I have prepared a typed note, my lord, but it doesn't have a cost title, but I'll just to assist, my lord. Give a copy to us.
Give a copy to
Yes,
Mr.
yes.
Gomes. Yes.
My lord, the British administration created this Imperial Forest Department of 1864. And the first act, my lord, to regulate the forest was this Indian Forest Act of 1865. The preamble of this act, my lord, was for the management, preservation and management of the government forest. Under section Roman numeral 1, the government forest, my lord, is defined as land covered with trees, brushwood or jungle, etc. And under section Roman numeral 2, the Governor General of India, along with the local government, is entitled to issue a notification. And this, my lord, was the first time where three kinds of forests were introduced. One was the reserve forest, one was the village forest, and one was the protected forest. The reserve forest, my lord, was to be controlled by the government. And section 4, my lord, I may be permitted to just read. Section 4 of the...
You have these acts, the Indian Forest Act and the amendment in 1878.
Yes, my lord. You
Give
have
us the
copy.
copies. You got one? Yes.
My lord, the Indian Forest Act, it's the second, it starts at 1878, section 3 of chapter 2.
1870, page number?
The page number is there.
Page 12.
Huh?
The Act 7
It's
of
unnumbered.
1878.
Yes, ma'am.
Yes, Act 7 of 78,
Yes, ma'am.
1878.
This is an act to amend the law relating to
Act
forests.
1878. It's
Yes, ma'am.
hidden somewhere here.
The transit of forest produce and duty leviable on tender.
Where are
Where
you
is,
reading?
my lord, the preamble of this 1878 Act.
Transit of forest produce and duty leviable. on
Yes,
hereby. Yes.
My lord, please see chapter 2 of reserved forests. Even though there's no specific definition of reserved forest, but here it says of reserved forests. Section 3, the local government may, from time to time, constitute any forest land or wasteland which is the property of government or over which the government has proprietary rights or to which the whole or any part of the forest produce of which the government is entitled a reserve forest in the manner hereinafter. And thereafter, my lord, it proposes like a preliminary notification under section 4, and under section 19, my lord, will be the final notification where it is required to declare that that's at page 62 of that particular act. When the following, my lord, please to get that. Section 19. So section 4 contemplates a preliminary notification, and section 19 is, my lord, when they may issue a notification by itself.
Yes.
Yes, ma'am. When the following events have occurred, namely, the period fixed under section 6 for preferring claims has elapsed, and all claims, if any, made within such period have been disposed of by the forest settlement officer, and if such claims have been made and the period limited by section 16 for appealing from the orders passed on such claims has elapsed, and all the appeals, if any, presented within such period have been disposed of by the appellate officer or court, and all lands if any, to be included in the proposed forest, which the Forest Settlement Officer has under Section 10 elected to acquire under the Land Acquisition Act, has become vested in the government under Section 16 of the Act, the local government may publish a notification in the local official gazette specifying definitely, according to boundary marks erected or otherwise, the limits of the forest which it is intended to reserve, and declaring the same to be reserved from the date fixed by such notification. Now, my lord, if my lord is pleased to turn the page over to section 23. What are the rights given by them?
Yes.
I'll just read 22 and 23, my lord. 22 says, no right of any description shall be acquired in or over a reserved forest except by succession or under a grant or contract in writing made by or on behalf of the government or of some person in whom such right was vested when the notification under section 19 was issued. Section 23, notwithstanding anything contained in section 22, no right shall be continued under section 14 clause C shall be alienated by way of, notwithstanding anything contained in section 22, no right continued under section 14 clause C shall be alienated by way of grant, sale, lease, mortgage or otherwise without the sanction of the local government, provided that when such right is appended to any land or house, it may be sold or otherwise alienated with such land or timber. No timber or other forest produce obtained in exercise of any such right shall be sold or bartered, except to such extent as may have been admitted in the order recorded in section 13. My lord, 26, my lord, because just to complete, section 26 provides for a denotification, which is not there in this case, but I'm just placing it for completeness of facts. Section 26, just before chapter 2.
Yes.
The local government may, with the previous sanction of the Governor General in Council, by notification in the local gazette, direct from a date fixed by such notification, any forest or any portion thereof reserved under this section shall cease to be a reserved forest. From the date so fixed, such forest or portion shall cease to be reserved, but the rights, if any, which have been extinguished shall not revive in consequences of such cessation. Now, my lord, this is one act which provides for the reserved forest. Section 23 provides for a particular method of lease as under the government. My lord, thereafter, in 1899, my lord, while we are this, chapter 3 provides for a village forest and chapter 4 provides for a protected forest, which we are not concerned in this case, my lord.
Yes.
My lord, the next act which we have, where is it? My lord, this is the Coorg Revenue Manual, which concerns, my lord, the Coorg Land and Revenue Regulations, one of 1899. This has been subsequently replaced presently by the Land Revenue Act, my lord.
Yes.
My lord, here what my submission is in the preamble. It says that whereas it is expedient to amend and declare the law in force in Coorg with respect to making and maintenance of record of rights in land, the assessment and collection of land revenue, and other matters relating to the land and liabilities incident thereto, it is hereby enacted as follows. Then if I request my lord to kindly see section 42, which may relate pari-materia to section 67 of the current Land Revenue Act under chapter 7. All public roads, etc., and all lands which are not the property of others belongs to the government. All public roads or thoroughfares, bridges, ditches, dikes, fences, on or besides the same bed of rivers, streams, nalas and tanks, and all canals, water courses, and all lands, and all standing and flowing water, and all lands, wherever situated, which are not the property of individuals or of aggregates of individuals legally capable of holding property, except in so far as any rights of such individuals may be established in or over the same, and save as may be otherwise provided by any law for the time being in force, are and hereby declared to be with the rights in or over the same, or appertaining thereto, the property of the government, and it shall be lawful for the, I mean, now it's been amended in 1940 as Assistant Commissioner, to dispose of such property as aforesaid in such manner as may be authorized by the government, subject always to the right of way and all other rights of the public or individuals legally subsisting. And the other section, my lord, is section 143. Power to make rules. That's at typed page 32, my lord. On the top, the typed page is at 32. Power to make rules. May I read, my lord? The state government may, in addition to other rules which may be made by it under this regulation, the state government obviously at that time was not there, which may be made by it under this regulations.
What was it prior to that? Assistant Commissioner in section 42, and what was state government prior to
Substituted
this
by
amendment?
AO, that will be by, I think, the chief commissioner. Chief commissioner, madam. By the chief commissioner.
Yes.
Yes,
Chief
ma'am.
Commissioner.
Chief commissioner. Chief. Yes. The state government, I'll just read it as it is now, but it's the chief commissioner. May, in addition to other rules which may be made by it under this regulation, make rules not inconsistent with this regulation or with any other enactment for the time being in force, prescribing the fees, etc. I'll be more relying on clause F, my lord. Generally for carrying out purposes of this regulation, because that is what is referred to in their notification. I request my lord to kindly turn back for a moment to section 39. That is at what is that other? 20 Gazette is? Gazette. Yes, no, that it has to be gazetted. My lords, please see section 29. I'm sorry, my lord.
29.
That is, yes. That is at chapter 6. That's inner page 7.
Making or revising.
Yes, my lord. Making or revising of record of rights for each estate. And the
For each estate.
yes, my lord. Definition is there, my lord. At
What is estate?
yes, my lord. Section 3, subsection 4.
Village or other area.
Yes. Any village means any village or other area, or for which a separate record of right has been framed, or which the state government, or that is then the maybe general rule or special set to declare an estate. Now, section 29, my lord, what is important is there shall be a record of right for every estate when section 29.
Yes.
When it for every estate, subsection 2, when it appears to that will be the chief commissioner, that a record of right for an estate does not exist, or that the existing record of rights for an estate requires special revision, the chief commissioner shall, by notification, direct that the record of rights be made, or that the records of rights be specially revised as the case may be. The notification may direct that the record of rights shall be made or specially revised for all or any estates in any local area. A record of rights made or specially revised for an estate under this section shall be deemed to be the record of rights for the estate, but shall not affect any presumption in favor of the government which has already arisen from any previous record of right. Here I'm just submitting for my Lord's kind consideration that they would require a notification to change it. Now, my Lord, after this, 1899, on 1/6/1904, where there's no dispute on facts, the Pattighat Reserve Forest, my Lord, was notified under section 19 of the 1878 amendment. I've placed it, my Lord. I had filed an IA 1 of 24 for additional documents. It's available, my Lord.
Pending? Or
No, my Lord has been pleased to permit me to give that.
One of
24. Extra copy. My Lord, I produced the notification at page
you filed that in this matter.
yes, my Lord. On 1/7/24.
1 of 25 is here. Is a memo, is there?
This is a notification.
ಇಷ್ಟೇನಾ ಫೈಲ್ ಇರೋದು?
And here the rules were.
1 of 25.
Okay.
Memo. Only 3 things. We don't have IA 1 of 24. We have only IA 1 of 25 here.
Oh.
24 or 25?
24, madam. I just see 24. 1/7/24.
That's the file. Everybody says. We don't have it here, Mr. Alish.
Don't have, madam. Don't have extra copy.
It has got mixed up in all these bunch of files. Probably.
Ask him if he has it.
In the other matter, there's a convenience set filed. In no matter is.
It's clear. Lord, we've taken it from a colleague. It's not sure if it's.
But we need our copy, right? So.
Go to page 178.
Yes.
Anantu, go to page 170.
Any other documents that you'll be referring to, or this is the only thing?
This is only one.
Yes.
Yes, ma'am. My Lord, in this, at page 178, is the notification.
178 is.
Sorry, 138, my Lord. 138. 138 is the notification published on 19th March 1904 by the Chief Commissioner. And the following page, my Lord, 139, where they declare this particular land as a reserve forest.
This is 19th March 1904.
Yes, ma'am. But on page 139, it shows the date is as 3rd May 1904.
That is notification number 26 is 19th March.
Yes.
Notification number 40 is 3rd May 1904.
Yes.
Yes.
My lord, based on this, this Pattighat forest was declared as a reserve forest. And thereafter, my lord, on 1/2/2009, that's at ink page 182, what's that? Ink page 182, at item number 14 at ink page 183, under section, my lords, please see on the top, under section 42 and 143(1)(f of the Core Land and Revenue Regulation 1899, the Chief Commissioner is pleased to make the following rules under which reserved forest and Paisari forest land may be demised for rubber cultivation. And this is not a free grant, my lord. Subsection 1 says the land shall be taken at an upset price of rupees 5 per acre. And
5 in 1909.
Yes.
Substantial amount.
Yes, my lord. And then the other terms are given, and the form of demise, my lord, is also provided at the bottom. That form of demise. And the second clause would say that it is witnessed that the lesser.
99 years.
Yes, my lord. Witnessed that, and just for completeness, just before the form of demise, the government reserves for itself to withdraw or alter the above rules from time to time as may be necessary. And then the form of demise is given, which is 999
years from now.
99 years. And just before that, my lord, subclause 7 says the lessee may cultivate such other crops as he desires in addition to rubber trees, but such cultivation shall be strictly subordinated to the cultivation of rubber trees. So there was a duration, there was a consideration, and there was a period. My lord, after this, in 1910, my lord, this revenue settlement of Coorg by Gustav Heller, which is commonly referred to by the revenue authorities also.
Going on giving.
My lord, this is a, madam. This is even referred to by learned.
Should make one compilation.
My lord, the reason is, my lord, they are such big books. I'm just referring to this, my lord, only for the extent of Paisari land and how it is defined. This is normally used by them. Please see page 60, my lord. I'm just referring to this for the definition of Paisari lands. So the definition starts at page 60 on the top. Paisari means, on the left side, my lord, Paisari, second after alienated Bane, on the right side. Sagu land, brackets, redeemed or unredeemed, according as timber has been paid for or not. So this is a manual, my lord, which has even been referred to in the judgment of Honorable Justice Bopanna as he was there. This particular manual. So my submission for my lords is that this Paisari land could be redeemed also by payment of if the timber value has been paid.
If timber value has been paid, it will be redeemed. If not paid, it will be unredeemed.
Unredeemed.
But irrespective, Paisari land is basically Sagu land.
Sagu
redeemed or unredeemed.
Yes.
Definition I also may be relevant.
I.
Government
Paisari. He is Paisari.
Yes. Now, my lord, the land in question.
Paisari is Sagu land. Government Paisari is Paisari land. So government A plus B equal to C. Government Paisari is Sagu land. It doesn't make sense. Then all Sagu land will become government Paisari. Sagu land is, the tenure is private tenure. Jamma is government tenure.
Yes. Paisari is government lands also.
Paisari is, the definition is stated to be Sagu land. The clause D, redeemed or unredeemed is also included. This you'll have to explain, Mr. Ajish.
I'll explain.
This is not.
No.
Must be some. There's explanation here at
Wording used
page 59.
But if my lord notices, the wording used, which was read, my lord, 1909, it says reserved forest and Paisari forest land. It just doesn't stop it.
You'll have to come to page 59, the clause D. Paisari as distinguished from government Paisari. These lands have all, the explanation is here. These lands have all been granted by government under the wasteland or other rules. If brought under the wasteland rules, they are held free from assessment for 4 years. Then they pay 1 rupee per acre from the 4th to 12th year. And from 12th year, they are allowed to pay the full rate, namely 2 per acre. All timber has been paid off and the holder has the right to sell and dispose of it. Government Paisari, these are waste.
It doesn't include forest, my lord.
Following lands. Devarakadus, Gurudes, and Urumbalas.
Yes. That's why I put it in the date sequence.
No, what you are reading, the table is only terms. Now we use terms to be used here after that. It's not definition. That table you will find at the bottom of page 59.
All designations used to represent tenure of these various classifications have been found to be found unsatisfactory. The following will be used in future in the settlement and revenue register.
So Paisari land, now it will be used as Sagu land.
Sagu land. And this
That
is all,
makes
my
sense.
lord, that's why I
That
put the
makes
dates. These are before the lease was executed in my favor.
This was Mr.
My lord,
Heller's
this
report
is,
was?
Mr. Heller's is 1910, my lord. 1910.
And your lease was 1917?
1913.
13. So this is prior to that.
Prior.
Yes.
In the definition that I had given, my lord, in my compilation, Paisari land is defined, my lord, all waste and forest lands.
Correct.
Which are declared by section 42 of the Coorg Land and Revenue Regulation to be property of the government and which have not been notified in the Coorg Gazette as protected forests under section 28 of the Act 7 of 1878 or as forests reserved under section 3 of the same act. Now we have Paisari land, which includes all waste and forest lands. And this section 42, which is now referred, my lord.
Page 59 is different, Mr. Ron.
My lord,
this chapter.
The caption itself, my lords will see, the rules itself says it is forest and Paisari forest land. It does not just say Paisari.
This appendix here. What is the purpose of making the submission, Mr.?
My lord, in the revenue records for two reasons. One is they executed this lease deed. I just wanted to give the background of the legal framework. In the background of this, because they had amended the revenue rules, regulations, they had executed these lease deeds in our favor for 999 years. Thereafter, my lord, immediately the mutation was affected. My lord, even though there is this presumption whether it is mutation can convert the land or not, why I relied on section 29 of the then revenue rules was that they would require to, if they are making any change in the notification, they would require to issue a notification to saying that this is no longer redeemed sagu. From 1913, after the lease deed, because I had paid the timber price, it was shown as redeemed sagu in the revenue records. So if it was shown in the revenue records as 1913 onwards as redeemed sagu, therefore, my lord, there was a formality as per section 26 of the then Act 1870 Act for them to issue a gazette, which they may not have done.
So in terms of this, Paisari would automatically become Sagu land.
Redeemed sagu.
Redeemed Sagu.
According to them itself. And if they subsequently wanted to change, because this is unique in terms of giving this notification, which is not there in the current Land Revenue Act. So if they wanted to change that from redeemed sagu to government reserve forest land, there's obviously prejudice to me. Therefore, the then rules said that issue a notification, which according to the records available with me, they have not done so. The then rules contemplated that if any revision of revenue records were to be changed from the nature of what it was, so from 1930 till 2006 and all, the land was always all these facts, my lord. I had produced all. Yes, my lord. My lord, in my that annexure IA1, that is ink page 149. What's it? Yes. What is it? Show? The color, my lord, picture at is that my lord has a color picture, my lord? I'll give my
working plan. This
yes,
is
my lord.
149.
152. Can I just show this, my lord? Yes. It's easier to. So even according to them, my lord, it is shown as 152. And under what section is this thing? And this is as per section 35 of the Karnataka Forest Act. Give me the Forest Act. This is it.
My lords may also see on the right-hand side. This is the total extent of the reserve forest and where their land is located.
That is the map of Coorg district where this is shown, or which?
No, this is with regard to Thompson
Called a working plan.
Pattighat Reserve Forest. The entire Pattighat Reserve Forest is about, I think, 41,000 acres.
The larger one which is shown here is the Patigar.
Patigar.
The much larger one where this is shown as part of on the
This
north, eastern, western side. What is that?
This is there with the code.
what I am instructed, my lord. My lord sees this. This is the entire reserve forest land.
Reserve forest.
Reserve forest.
Not Coorg.
No. And what is given is, my lords will see the portion,
Yes.
what is in
That
their
section.
possession, which is leased.
Yes.
So it's within the boundaries of the reserve forest, notification. And my lords will also see, consists what is given, evergreen forest.
And this is all, my lord, under this working plan. It's contemplated under section 35 of the Karnataka Forest Code of 1976. I've given this list of laws, my lord. It's there. I know, my lord.
Given.
No, I'll just extract all those relevant parts and make it in a short form. But I didn't want to selectively remove only one part. It may not be correct. It's at page 177, my lord. In this, which has the acts, the Indian Forest Act is the first one. This is the Forest Code, the fifth item. It starts from page 164, page 177. Page 177, it's like this, my lord, at the bottom. Page, section 35.
Working plans.
Yes, ma'am. So it says, a working plan is written scheme of management sanctioned by proper authority for the systematic treatment of a forest.
What is this document?
Please, madam.
What is this document? What is it called? Karnataka Forest Code.
Yes, madam. Karnataka Forest.
Every once in 10 years, my lord, there's a working plan division itself.
This is done under the Karnataka Forest Code.
Yes. And once in 10 years, they will survey the forest.
In fact, though I produced the portion, my lord, I got the whole book, which.
How many forests do you want, both of you want to destroy to give us all the papers? Yes.
My lord, even the rubber board, my lord, has recognized this and they have given a certificate, which is at ink page 145 to the IA. My lord is pleased to see that IA copy. Where's my copy? My lord, both the copies are now with my lord. Yes. Page 145.
Yes.
This is on 1385.
This is with regard to your rubber
Yes,
plantation.
madam. Yes. My lord, this and all such and more material was available with me to be placed before the adjudicating authority.
This is Cochin Malabar Estate. That has been changed to Thompson?
Yes, my lord. My lord, they had gone through, they defaulted in debt and then they had sold the property through me to a debt recovery tribunal proceeding.
Yes.
My lord, in this background, in the first instance, my lord, because Learned Senior Counsel Mr. Holla has taken on the other aspects. I'm only on the aspect of procedure and bias and these issues of estoppel. In this background, my lord, I had all this material which I was able to place before the authority. So in the first instance, my lord, if my lord is pleased to see my writ petition, I took a specific contention with reference to bias. That's at ink page 193. And my contention on bias was at para 5. I've taken a specific contention. The said objections are subject to adjudication in the said case before the Honorable High Court of Karnataka. However, in view of his affidavit before the High Court of Karnataka, after the commencement of the inquiry by issuance of the notice, the CCF has now virtually become both the prosecutor and the judge and is an interested party in the matter, and therefore cannot preside over the inquiry without bias or prejudice, and is legally disabled so and so. The CCF holding this has voluntarily concluded his findings by imputing personal knowledge of the facts in the inquiry. Consequently, he cannot give any other finding in the inquiry. In the result, the inquiry becomes an empty formality. However, since the CCF did not reveal his disability to decide the inquiry on 16/4/2013, or even on 30/4/2013, or on 2/5/2013, the lessee came to know of the aforesaid objections and affidavit on 10/4/2013 only, after 2/5/2013, through his counsel. This is one aspect, my lord. The second aspect, my lord, is the order sheet. Please see the order sheet, which is at ink page 211. So 5/4/2013 is the commencement of proceedings. The order of the order of the Honorable High Court, my lord, of the Honorable Division Bench was on 25th March 2013. So this is on 5th April 2013. The orders of the Honorable High Court of Karnataka and the case cited above are downloaded from the website of the High Court. In the third and fourth paragraph of the orders, it has been directed that this office, when the appeal was filed, this office was the conservator of forests to decide the question if the land in question, those leased to them or assigned to them by the original lessees or by purchase, were a reserved forest or not. The time allowed is 3 months, which counted from the date of the order expires on 25th June. Then the next hearing date, my lord, is first hearing is in the morning, then in the afternoon. Then third item is on 16/4/2013, where I have asked for file application seeking 15 days time to prepare for inquiry and get documents. Matters posted to 30/4/2013. Then on 30/4/2013, inquiry is called. Company is represented by director and so and Mr. So and a wakalat to this effect has been filed. Further, another application related to getting plans annexed to lease deed is filed and accepted. The company and learned counsel seek time to present their cause. Keeping in view the limited time to finalize my report, I'm fixing the case to 16:30 on 6th May. No adjournment will be allowed. Then on 6th May, the inquiry is called. The company is represented by the director and general manager and learned counsel. An application is filed requesting for deferring or postponing the inquiry. For postponing the inquiry, as I am the affidavit swearing authority in writ petition so and holding the inquiry. I am bound by the contents of the affidavit and thus at least restrained in making my findings, and if they are contrary to the affidavit. I hold the stand that inquiry can be at least heard. As regards making a finding contrary to the affidavit, that is my problem. The inquiry is proceeded with. A memorandum of submissions presented by the company, 4 RTC surveyors so when 68/1 itself and all survey numbers from the record cannot be reserved forest is the submission of the learned so-and-so. The reserved forest survey list of DCF so-and-so as reserved forest and the lands leased out now with the company. The inquiry is completed with liberty to the company to file further documents, say within a week. Then on 5/6/2013, the request filed by the company on 34 is sent to the Deputy Commissioner. Then the company has given a copy of the miscellaneous appeal filed by them in the High Court of Karnataka against so-and-so. When the appeal has been made as per last paragraph of me, and send me papers so some other conservator of forest of any other district to hear the matter and dispose of the same. However, no orders seem to have been passed by the Honorable High Court of Karnataka. Thus, the orders of the Honorable High Court are effective till date, and they cast a duty on me to complete the period of time so-and-so. Hence, I do not find any legal impediment so-and-so with the inquiry and assuming my report. Yesterday evening, then 27, today I'm signing and issuing for delivery of all concerned. So on 5/6/2013, they had asked for documents at ink page 213. Then the impugned order comes to be passed. Please see ink page 219. The relevant part, my lord, is paragraph 5 at ink page 220. The task before me is to decide on the issue whether the lands of the company are a reserved forest or not. The Honorable High Court of Karnataka has not directed me to inquire as to whether a land in case it is not a reserved forest is a forest land or not. Thus, I will confine my inquiry to report as to whether the lands a reserved forest or not a reserved forest only. The question now arises as to how to decide whether a piece of land is a reserved forest. Since reserved forest is a legal term that finds mention in the Forest Act of the state and country, and the said term can be safely considered to include all lands which have been declared as reserved forest under the appropriate provision of the Act and rules then prevalent, and further since there is provision made in the same Act and rules to de-reserve, disforest, denotify reserved forests. Reserved forests also have to meet the additional criteria that they ought not to be de-reserved, disforested, denotified as per law. Thus, so and so. Then para 7, since the issues of the entries, this is important, of revenue records have been discussed in many proceedings and courts and cases in the matter of rubber company leases of Kodagu in the past, it is necessary that it is dwelt upon hereto. Many a time, the lands records of reserved forests are found not to contain the term reserved forest in them. In case of tenures, words like redeemed and sagu are found. It is important to mention that in case of reserved forests declared so under the Indian Forest Act 1878 at least, this is quite common. This is because, contrary to what exists in Rule 41 of the Karnataka Forest Act of 1969, now exists, there was no duty formally enshrined upon the revenue authorities to modify land records of reserved forest land. Secondly, the term redeemed is only prima facie indication that the tree value standing on the said land has been paid. The term sagu is prima facie indication that the said land is under cultivation or agriculture. Entries like redeemed sagu do not in any way alter the status of land. Land tenures and legal status of lands are mutually independent. Also, there is the point that the presence or absence of entries to the extent of reserve forests in the records of revenue department, or for that matter, any department, does not in any way take away the effect of reserved forest notification. If such entries or records are at variance, contrary to the notification, it is the entries or records that needs to be changed and not to be interpreted vice versa. This is completely contrary to the regulations. It is seen that the lands with the company forming part of this inquiry are within the boundaries. But those noted as enclosures of the land, which have been declared as a reserved forest with the effect of 30th June 1904, wide notification of the Chief Commissioner of Coorg so and so, the company has presented during the course of inquiry document Annexure 1, which is the indenture of 282 acres, Annexure 4, which is the indenture of 116 acres, and document Annexure 6, which is indenture of 123 acres related to lands of the company, which explicitly and unambiguously refer to these lands as parcels of reserved forest in the second paragraph of this page. This corroborates the fact that these three parcels of land were indeed a reserve forest at the time of indenture. However, after such exchanges and surrenders of land within these indentures as described by the company in paragraph so and so, the company was given 56.10 acres in Kalahala village after de-reserving it from Pattighat Reserve Forest with effect from 15 June 1947, wide notification of the Chief Commissioner so and so, part of so and so. A copy of this is produced by the company as annexures. For lands other than those 56 acres, the company produced records challenging the legal title of their lands being construed as reserved forest, but no de-reservation, no disforestation, denotification order, annulling or modifying the notification of reserved forest cited before the extent of their lands and being in effect or in force at the time of inquiry was produced. The company has also produced in the course of inquiry Annexure 6 of which indenture 108 acres of land of 24th October. This document does not mention about the legal title of the land as has been done in the three indentures. These are but within, this is also significant, my lord, because in this, there's no reference to reserve forest. Within the boundaries, but not those noted as enclosures, which have been declared as reserve forest with effect from 30th June, wide notification of the Chief Conservator. The Coorg district on 1st July 2004. No de-reservation, disforestation, so and so, modifying. In view of the comments, I declare. My lord, few aspects for my lord's kind consideration. In paragraph number, which is that? Yes, my lord. In paragraph number 8, that's in page 222, before para 9, they refer to this, sorry, para 8, it starts at page 221. They refer to this exchange deed, my lord, of around 56 acres of land, which my lord will be pleased to find. Where is it? No, here. The exchange deed. If my lord is pleased to turn the page, page 222, after the writ petition number, the company was given 56.10 acres of land. My lord, the notification is produced at ink page 245. And my lord is pleased to see in the schedule, it says brief description of the property, and there's a certain key, and that's at the bottom, the second one, private land in good condition. My lord, what happened is when they had issued this notification declaring the land to be forest land, they have used natural boundaries like rivers and mountains and lakes. Now, a land which was not even a forest land was included in that notification. My submission for my lord's kind consideration is that the Gazette notification by itself, earmarking some lands as forest land by itself is not sacrosanct, because even according to them, they had to execute this particular document. And this document was executed by them because they had made an error. So they cannot just say that the original notification of land as forest land was 100% valid or tested by them. Similarly, my lord, the aspect about the Coorg revenue regulations, more particularly section 29, if my lord sees in the annexure 1, where all the revenue records, my lord, from page 14 column 9, will show it as,
How much longer will you take?
my lord, any other, I'll just take another, any other day, my lord,
How much longer will you take?
just 15, 20 minutes.
Lawyer saying 15 minutes is
Yes, my lord.
15 minutes or more.
Just 15, 20 minutes. Any other day, my lord, so that I'll just give my notes also.
How much, after that is your reply. How long will you take?
Lord, I may need about an hour minimum. No, because what happens, my lord, in this case, it largely depends on the interpretation that my lords will give it.
So we'll give him 15 minutes next week.
Next Wednesday.
For 1 hour, we don't know when. This has been going on
I'll
for.
start, my lord. Lord keeps it on the same day, I will.
Further, I heard argument by Sri Ajesh Kumar, counsel for the petitioner in WP number 40364 of 2013, for his further arguments released on 18th at 4:30 p.m.
Grateful.
15 minutes.
Yes, ma'am.
You want to file your written submission, you can file
Yes,
your
ma'am.
written.
I'll also, my lord, Lord permits me, I'll just take all the relevant extracts of these.
Make that instead of all these.
Yes, yes, I'll do that.
You can make that, make your written submissions.
Yes.
Whatever you want to say, you can
I'll
say it
do
in that.
Yes.
Restrict this.
Your lordship's kind permission, my lords.
Of the list.
Serial number 8 in list 2, my lord.
Of the list food matters. Dev Prasad.
Yes, Mr. Advocate General, you are here for what?
Solid waste.
That solid waste matter.
Solid waste, my lord. The tenders all have been stuck, my lord. Can tomorrow, if your lordships have time, my lord?
We'll have it tomorrow, but
2:30 list.
2:30, if we may request.
serial number
71.
71 tomorrow at 2:30 p.m. Where the other matters? When is that?
56 also, my lord.
When are those matters?
All are listed today, my lord.
Only 71 is what we are told.
In 71,
55.
I'm sorry. I think I'm sorry.
55. 2:30 tomorrow.
61 also, my lord.
Hmm?
61 also, my lord.
61, 2:30.
55,
Anything else? Solid waste? We are only dealing with waste.
57, my lord. 55, 56, 57.
Any other waste matters?
62 and 64 also.
Waste matter. 57. 57 tomorrow at 2:30. Ashchana,
Please, my lord.
Interim arrangement to be extended. Interim arrangement to be extended.
interim arrangement is extended till next date.
Please, my lord.
Serial number 8.
Pass over tomorrow. 110 tomorrow.
My lords, with your lordship's kind.
If we take one matter, everybody will pounce on us. So we can't take any matter.
Your lordship's kind permission.
Monday, my lord. Monday, my lord.
ಯಾವ್ದಪ್ಪ
81.
ಏನಕ್ಕೆ
Simple mandamus.
ಎಲ್ಲ ಸಿಂಪಲ್ ಇರೋದು.
End of the list, my lordship.
15 minutes ಅಂತ ಹೇಳಿ 1 hour ಆಗುತ್ತೆ.
My lordship.
Monday or Tuesday.
End of the list.
My lord, serial number
Ah.
83, my lord.
Vinay Prasad.
My lordship.
Ah.
I'm for the petitioner, my lordship.
Yes.
The convict is a 72-year-old terminally ill patient, my lordship.
You said.
90 days parole is getting over today, my lord, but it's typically his condition is very critical.
Terminally ill. In what has happened?
My lordship is suffering from carcinoma, a type of a cancer, my lordship.
Let him be with his family. He'll make an exception. Petitioner, and AG accepts notice for the respondent. Petitioner is before this court seeking for the following briefs. This court, by, where is our order, earlier order?
My lordship, that is Annexure D, page number 17, my lordship, 17.
No, not 17. Where is our earlier order?
17, that is from the Department of Prisons, my lordship.
So they had given you from the Department of Prisons.
Yes, my lordship.
The Department of Prisons via Annexure D, order dated 10/7/26 at Annexure D, had granted parole to the petitioner for a period of 30 days. The above application has been filed for extension of time on the ground
Medical certificate is in Annexure B, page number 10, my lordship.
that the convict has been diagnosed with advanced squamous cell carcinoma and undergoing chemotherapy at Sri Shankara Cancer Hospital and Research Center. In that background, that an extension of parole by period of 60 days has been sought for. Learned AGA was directed to secure instruction when the matter was moved to ascertain if the contention taken up is correct and the medical certificate is the authentic one. Learned AG on instructions submits that the said medical certificate is authentic and the condition, medical condition of the petitioner is not all that good. Considering the said submission and taking into consideration the medical certificate, the convict being 72 years of age, suffering from carcinoma and undergoing chemotherapy, the earlier, though it is contained at the period of 90 days available for the petitioner detenue for parole is already completed as a exceptional case taking into consideration the above aspects. The petitioner is granted 90 more days of parole on the following conditions. Respondents are directed to act on the operative portion of the order without insisting on the reasoning portion. Learned AGA to inform the respondents about the aforesaid order.
Wait for a minute.
64 petitioner is in custody, my lord.
Serial number 83, my lord. My lord, Honorable Court directed us to produce judgment.
Mohammed Sultan,
General body meeting has been called without even
230 movement.
general body meeting of
for selection of office bearers, my lord, in a masjid. District Waqf officer has called for on selection basis instead of election and without even a calendar of events, my lord.
when is the meeting?
Day after tomorrow.
Day after tomorrow. P. Usman is directed to accept notice for respond number 1 and 2. Notice to respond number 3 and 4 is deferred for now. Relist tomorrow. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on Sri P. Usman by end of day today. IA 1 of 26 is allowed in preliminary hearing.
Serial number 44, my lord.
My lord, hand delivery of the order.
Ms. Navina.
For the petitioner, Lordship.
Huh?
Here the petitioner has been denied the caste and income certificate solely because he's a government employee. We have both AC and DC. We went appeal for both AC and DC. Both of them.
It's a pending matter. Why did you
It's
move
a pending matter, my lord. He has moved the matter
How
for
did you
today.
move a pending matter for end of the list?
Lordship, like what happened is it was listed for.
Morning we asked you, you said it's a fresh matter. We don't ever agree for pending matter.
No, Lordship. Like what happened was like the order was dated like 20.
Nothing what happened. Relist tomorrow. Find out what it is.
Serial number 4 petitioner is in custody, my lord. With your lordship's kind permission, my lord.
Parole matter the 19th.
My lord, one senior citizen matter, please.
The problem is this. Now court has issued warrant and arrested me because I could
We
not.
will extern ourselves.
Please, not 64, your lord.
Please, okay.
My lord, serial number 44, my lord.
Passed over matter.
44, my lord, senior citizen.
Store will come tomorrow. Each of you will ask. We can't make an exception for any of you. Otherwise, everybody else will. It will come in sequence.
My lord, senior citizen matter.
All interim orders will be extended. Yav urgent is you or they heard.
Honorable Court have directed to produce only judgment copy.
Eight senior.